Okay, the hearing will start in a minute and change. I'm going to remind the panelists to please turn their cameras on if you have not yet done so. And unless you're speaking, please mute. Commissioner Briggs, do you remember how to mute your audio?
I'm attempting to do that now. What am I doing?
Okay, it should be on the left lower side of your screen, but I know devices differ. Looks like a little microphone.
Yeah, well, it says mute my audio and
Then you'll need to click on it with your mouse.
I've clicked once, I've clicked twice, Reiko. It's got some green going on it.
Yeah, that means your audio is still on.
Shoot.
Try just clicking it once instead of twice, possibly.
Did that just do it?
No, but we'll just hope you don't have dogs or anything that are really loud in the background.
I do not. There's nothing here.
I have the time of 8:30 by my computer, so why don't we get started? Good morning. This is the public fact-finding hearing of the Washington State Commission on Judicial Conduct in the matter of Judge Tracy S. Flood of the Bremerton Municipal Court. The commission's case number is 11005F204. My name is Eric Price, and I'm the appellate judge member of the commission. I will be the presiding officer and have been the presiding officer of these proceedings. Now, I'm pausing because I just heard that the recording is in progress. I'm assuming I don't need to repeat myself. I will just repeat that the commission's case number is 11005-F-204. Again, my name is Eric Price. I'm the presiding officer and appellate judge member of the commission. Again, as we did start this proceeding 2 days ago on Monday, the 21st of October. Although the proceeding started that day, the panel or the matters before the commission at that point was the entering of a stipulation, and so we didn't actually formally start the proceedings. So I'm going to do that now. Part of the formal beginning of the proceedings is myself reading some important instructions. I'm going to do that now. After I get done reading the instructions and comments that I have, I will ask if there are preliminary matters that the parties want to address. I would also note that there was a number of materials that were submitted late after business hours yesterday, or right on business, the end of the business day. That was not unexpected. There were some unexpected things provided, but I want the lawyers to know that it is unlikely that the panel members have digested everything that was submitted. So don't make that assumption, at least at this point. So I'm going to start by having counsel introduce themselves, as well as other counsel on their teams, if there are any. And then I'm going to turn and have our panel members introduce themselves. Let me start first with disciplinary counsel. Can you introduce yourself, Ms. Rasnick?
Yes, Your Honor. Reagan Rasnick, disciplinary counsel.
And good morning to you. And Ms. Bremner, I'm going to turn to you. I know you have several folks, at least one other folk with you. If you can introduce yourself as well as who's on your side of the table.
Thank you, Your Honor. Good morning. Just a second, we have to check something.
Ms. Bremner, if you have two devices in proximity with each other, then you'll get that kind of echo. So if you can move them apart, further apart, you'll lose the echo.
Like Judge Flood has now muted that. Perhaps Ms. Bremner, you can speak. You're muted.
All right, I think I'm unmuted.
You are.
Okay, thank you. I'll start again, better start. Good morning, I'm Ann Bremner, and I'm counsel for Judge Tracy Flood. We're in a conference room together, and including the judge, who I think you can see. I want to say good morning, even though I won't hear you. Okay. Thank you. And also, we have Karina, our paralegal, and then Nick Gross, my co-counsel, is across the table from me. So I'm here on this side, and the other three are across from me. And good morning to you, Your Honor, and to the panel and to opposing counsel.
So now I'd like to turn to the panel members of the and have them introduce themselves. And as you introduce yourselves, if you could please state whether you are a public member, a judge member, or a lawyer member. And since we're on the Zoom, I'll call on folks alphabetically. First, Commissioner Archer.
Yes, hi, I'm Ryan Archer. I'm a lawyer member of the commission and have been on this commission since 2016. Thanks.
All right, Commissioner Ashby Scott.
Good morning. My name is Terry Ashby Scott. I'm a public member and I'm not remembering how long I've been on the commission.
Okay, thank you. Commissioner Briggs.
Good morning. My name is Wanda Briggs. I've been on the commission for about 20 years. I live in Kennewick.
And you're a public member.
I'm sorry. Yes, I'm a public member. Thank you.
All right, thank you. Commissioner Hedin.
Good morning. I'm Judge Christian Hedin. I'm the presiding judge at the Walla Walla District Court. I'm the current chair of the commission. I represent the limited jurisdiction courts, rather. Sorry about that. And I've been on the commission since 2017.
Commissioner Miller.
Good morning. My name is Tara Miller. I am a public member and I've been on the commission for, I think, about 5 years.
Commissioner Moody.
Good morning, Marcia Moody. I'm a public member and I've been on the commission just a little under 3 years.
And Commissioner Schley.
Yes, Jerry Schley, and I'm a public member, and I think I've been on the commission for about 8 years.
All right, thank you for that, commission members. Also on the Zoom panel is our court reporter, Connie, is it Recob? Did I get that correctly?
Recob.
Racob, my apologies. And also is Amy Baldos, who will be acting as the clerk for proceedings. Most folks, well, Miss Rachel Callner has already spoken, and she's here to facilitate the panel discussions as well as our IT staff people, Gareth Cooper and Christy Perry. They're all on the Zoom call as well. Most of the staff and the court reporter will generally be off camera during the proceedings. Everyone else, panelists, lawyers, and witnesses should keep their cameras on at all times. We're going to start formally here and have, I'm going to ask the clerk to file the finding of probable cause.
This is Amy. I'm filing the finding of probable cause and adding it to the record, Your Honor.
All right, thank you, Ms. Baldos. Now, for the information of the parties and observers, CJC rules require that after a statement of charges is served on a respondent judge, the members of the panel cease to have contact with the investigative staff concerning substantive matters in that proceeding. Investigative staff at that point assist disciplinary counsel and will do so in this case. Members are cautioned to keep incidental conversation with investigative staff to a minimum, and staff and members have been cautioned to guard against any appearance of substantive contact for the duration of this hearing. Members are cautioned that they are not to discuss the substance of the case until the presentations have been concluded and the deliberations have begun. And that includes discussions among themselves about the evidence. They are also cautioned not to discuss the case with anyone outside the commission while the hearing is pending. Any questions about this process may be referred to Executive Director Rachel Callner. I'd like to remind everyone to turn off their cell phones, and as Ms. Callner earlier said, make sure if you're not speaking, you have your Zoom muted. Commissioner Briggs, I understand that that'll be something that we'll work on, but for the most part, folks, keep your Zoom muted. Now, counsel and others watching this hearing might be aware that at least some of the members of this panel did participate in the preliminary investigative part of this case. Almost 1 year and a half has passed since the panel members made a determination of probable cause. At that time, members relinquished all materials about the Judge Flood matter and ceased having any further contact with investigative staff about the matter. As presiding officer, I remind the panel members that the members' duties in the earlier investigation are not the same as their duties in a fact-finding hearing. To the extent you might retain any recollection of information from the investigative part of the proceeding, you are required to put such information aside and to rely solely on the evidence and law presented to you in this hearing from disciplinary counsel and from respondents' counsel. I'm going to repeat that. To the extent you might retain any recollection of information from the investigative part of the proceeding, you are required to put such information aside and rely solely on the evidence and law presented in this hearing. To the extent it is still relevant after the party's recent stipulation to code violations, which I'll discuss in a moment, disciplinary counsel has the burden of proof to prove facts and code rule violations by clear, cogent, and convincing evidence. Clear, cogent, and convincing evidence is described in CJCRP 7, following the definition enunciated by the Washington State Supreme Court. Clear, cogent, and convincing has been defined to mean highly likely. A contention that has been proved by clear, cogent, and convincing evidence is established if it is established that is highly likely to be true. Let me restate that sentence. I'm not sure I read that very well. A contention has been proved by clear, cogent, and convincing evidence if it is established that it is highly likely to be true. This level of proof requires a greater weight of evidence than a preponderance of the evidence, which has been defined to mean a contention is simply more likely true than not true, but it is less than the evidence required by the beyond a reasonable doubt standard. The commission's case will be presented by disciplinary counsel Reagan Rasnick, except as otherwise provided in the commission's rules of procedures. The rules of evidence applicable in civil proceedings before the Superior Courts of Washington shall govern. Disciplinary counsel will present their case first, followed by respondent's case. Disciplinary counsel will be offered an opportunity to present rebuttal evidence, and both parties will be permitted and are encouraged to provide the commission panel with closing arguments and recommended disposition. We'll probably have some discussions later about how that process has been altered by the stipulation that has been entered. Now, as part of the duties of the presiding officer, it is my duty to rule on evidentiary and other procedural questions, and I will make my rulings based upon legal principles applicable in civil trials according to the rules of the commission. I may, under the commission's rules, refer any of these matters to the entire hearing panel. If the panel confers on something during the proceeding, will be placed in a breakout room by staff, and that, of course, has occurred on Monday. The witnesses in this case shall be subject to direct examination first, and then cross-examination and reasonable direct and cross-examinations. Now, just like in civil trials, members of the hearing panel are permitted to ask questions of witnesses concerning the testimony, in which case counsel will be permitted an opportunity to object and also have an opportunity to ask follow-up questions narrowly related to the members' questions. Now, prior to this hearing, I issued an order which stated in part that the fact-finding hearing will begin on October 21st, 2024. And on that day, the panel granted a joint motion to accept the parties' stipulation to facts and code violations. And we will be moving forward consistent with that stipulation. I expect that our morning sessions will run from 8:30 until noon with a 15-minute break at or around 10:30, and the afternoon session will run from 12:30 into 5 with a 15-minute break. If panel members or parties are in urgent need of a nature break, please raise your hand and we can see what we can accommodate. However, we do have a aggressive schedule, and I'd like to have as much time dedicated to the parties as possible. Any witnesses in this matter other than the respondent are excluded from observing this hearing until they are excused from further testifying. And I assume, I'm confident I can assume that the parties have told all of their witnesses they are not to be watching on the YouTube until they testify and until they are released. Ms. Dremner, is that true?
Yes, Your Honor.
Ms. Rasnick?
Yes, Your Honor.
Okay. So that does conclude my opening comments. Before we turn to opening statements, let me ask if there are any preliminary matters that need to be addressed. Ms. Rasnick?
I have just one preliminary matter, Your Honor. We received a couple of declarations from respondent past the due date that had been set for the declarations. We received the John McKay declaration and the Leslie Weber declaration. The McKay declaration was received last night, and the Weber declaration was received about a little before 7 a.m. this morning. I would move to exclude those because they were not received by 5 p.m. yesterday, as had been directed.
Ms. Bremner?
That's, I'd actually ask the court to hear from Mr. Gross on that. Thank you.
Mr. Gross?
Your Honor, we're obviously working on. Sorry about that. Your Honor, we're obviously working on a tight timeline here. For one thing, our witnesses are not starting until Thursday. We did the best we can working with our witnesses and got them out as soon as possible. I'd ask the court to exercise its discretion and not exclude them. There's been no prejudice. We're not cross-examining these witnesses, at least not until Friday, if at the earliest. So for those reasons, I'd ask the court to deny the motion to exclude.
Ms. Rasnick?
Your Honor, it was very clear on Monday that we were to provide the declarations by 5 p.m. I think this is just another example of the non-compliance with orders that has characterized the respondent's participation in this proceeding. I believe there needs to be some accountability for that, and the declaration should be excluded.
Any argument regarding prejudice?
Your Honor, I have barely had an opportunity to look at those declarations. One came in just before I got to the office this morning. We are not going to have an opportunity to interview either of those witnesses. Further, I would note that with regard to Mr. McKay's declaration, he indicates that he is not familiar with the investigation. So, in addition, I think there is a relevancy issue with regard to the McKay declaration, and certainly he doesn't qualify as any kind of an expert witness under ER 702.
So I'm going to take the matter under advisement, and Ms. Rasnick, because you have not had an opportunity to review them in detail, I'll provide you that opportunity. And if you want to remake an argument regarding prejudice, I'll allow you to do so. But at this point, I'm going to reserve ruling. All right, are we ready? Are there any other preliminary matters? Ms. Rasnick?
No, Your Honor.
Ms. Bremner?
I don't know.
Ms. Bremner, I'm taking it you're saying no.
I'm saying no. Can you help on this?
Okay. So at this point, then we'll have opportunities for opening statements. Ms. Rasnick, if you would like to make an opening statement, now is your opportunity.
All right. Thank you, Your Honor. I'd say good morning to the presiding officer and the members of the panel, and thank everyone again for their time today. I would like to note initially that we are here this week because of the unique role that judges occupy in the community, which is especially true in Washington, where we elect judges for the most part. The community has an opportunity to evaluate candidates and choose whom it wants to hold its members accountable, to follow the law, and to solve some of its most important disputes. we decide who will sit in judgment of us and our peers. And the individuals we elevate to those roles, who are judges, have tremendous power over the lives of the public. And the office that judges hold is described as a public trust. And it's through the Code of Judicial Conduct that the public gets to hold judges accountable. The preamble to the code recognizes this. It says that inherent in the rules and contained in the code are precepts that judges individually and collectively must respect and honor the judicial office as a public trust, and they are to strive to maintain and enhance confidence in the legal system at all times. And it goes on to tell judges that they must aspire at all times to conduct that ensures the greatest possible public confidence in their independence, their impartiality, their integrity, and their competence. I would note that that says the greatest possible public confidence. So not just good enough public confidence, but the greatest possible. Some commentators who wrote about prosecution and defense of disciplinary charges against judges about 15 years ago, the Gersteins, noted that judges are human beings with strengths and weaknesses, but that they must be prepared to be held to a higher standard than other people. This proceeding concerns Judge Tracy Flood of Bremerton Municipal Court, as we've heard. Let me say a little bit about Bremerton. As of 2020, according to the U.S. Census, Bremerton had about 43,500 people, of whom 69% were white, about 5.5% were Black or African American, about the same amount, 5.2% were Asian, 12.9% Hispanic or Latino, another about 12.3% identified as two or more races, and just over 1% Native American and Alaskan Native, and just under 2% Native Hawaiian or other Asian Pacific Islander. And in 2021, at the end of that year, that diverse group of people elected Judge Tracy Flood as their one and only municipal court judge. As Judge Price acknowledged, municipal courts and district courts, which are they're referred to as our courts of limited jurisdiction. And these courts are in a unique position because these courts are the way most people in Washington interact with the judiciary. Here we're talking about traffic tickets, infractions, criminal misdemeanors, domestic violence protection orders. Judge Flood took this bench in January 2022. We're here today because complaints against Judge Flood were lodged with the Commission on Judicial Conduct, as Judge Price described. The first complaints, which were lodged in July of 2022, alleged that the judge had displayed an injudicious temperament and had engaged in discourteous treatment of attorneys and other potential misconduct from the bench. And then there are additional complaints alleging rude and disrespectful treatment of attorneys were received. And finally, in October of 2022, the Commission received a complaint alleging disrespectful and demeaning treatment of court staff. As Judge Price summarized, the Commission conducted an investigation, which was confidential, determined that the complaints were serious enough to warrant a statement of allegations, which was provided to Judge Flood, and Judge Flood responded to the statement of allegations. The confidential proceedings then continued for a while longer so that the judge had an opportunity to address the issues of her own accord. But the issues were not addressed, and the statement of charges was filed, as the presiding officer referenced, in July 2023, and that began the public proceeding. The judge responded to the statement of charges, and there followed well over a year of litigation, which has led us here to this hearing this week. Now, on Monday of this week, October 21st, Judge Flood admitted to violating 3 sections of the Code of Judicial Conduct, and those are as follows. She is admitted to violating Canon 1, Rule 1.1, which requires judges to comply with the law, including the Code of Judicial Conduct itself. She's admitted to violating Canon 1, Rule 1.2, which requires judges to act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, as well as to avoid impropriety and the appearance of impropriety. And finally, the judge admitted to violating Canon 2, Rule 2.8b, which states that a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity. The judge was also charged with violating Canon 2, Rule 2.5a, which states that a judge shall perform judicial and administrative duties competently and diligently. As the presiding officer reminded us, the panel accepted the stipulation on Monday, October 21st, and now today we are here so that the panel can begin to receive evidence so that it can make factual findings and additional legal conclusions if necessary and decide the appropriate sanction for the misconduct. Now, today and tomorrow, and maybe a little bit of Friday, the judge will receive live, or the panel will receive live and written testimony from witnesses who are former employees of Bremerton Municipal Court, some of them who worked there for decades and will testify that they plan to stay there and retire. Bremerton is a very small court. There have been fewer than 10 employees for a lot of the last few years. The former employees who were there when Judge Flood took the bench in January 2022 will testify that they expected there would be change when the judge took the bench because her predecessor had been on that bench for 24 years. And these former employees will also testify about their interactions with Judge Flood and the effects on them of the judge's lack of patience, diligence, and courtesy, and the effects on them of being belittled and subject to condescension and bullying. These folks who had been in their jobs for decades and were active in professional organizations, had won awards from their peers, will testify that they soon felt they could not do anything right in the eyes of the judge. And when they asked questions or made errors, they will testify they were met with scorn and derision. And a judge who up until about 2 days ago would not even begin to own up to what had happened, much less take responsibility for it. They will testify they began to dread going to work, that they drove home in tears, and pretty soon they left for other jobs, even though, as you will hear, some of them had to take pay cuts to do that. You will also be hearing from witnesses whom the judge hired to replace those original employees who left. Those were also experienced court staff, and they will talk about how excited they were to get to work with Judge Flood. Some of them left long-time positions with other courts of limited jurisdiction. Some moved to Bremerton for this opportunity. They will also testify about the effects of being belittled and condescended to by this judge and treated cruelly, and how those who she initially favored eventually fell out of favor and came to be targeted.
Your computer shut down.
I'm sorry?
Okay.
Ms. Bremner, you're not muted in your conference room?
Should I continue?
I think in order to stop the background noise, we need Ms. Bremner and Judge Flood to mute their mics.
Ms. Bremner looks
And
like she's
possibly
frozen.
Mr.
Can we have a moment? We're having some technical difficulties here.
Ms. Rasnick, why don't you just pause for a moment? All right. Ms. Rasnick, rather than continue to pause, let's keep moving forward.
All right. Where was I? Let's see. The attorneys who had been hired to replace the original attorneys who left will testify about those who the judge initially favored, eventually fell out of favor and came to be targeted, and how it felt when the judge would gaslight them, would tell them that the things they had heard and seen did not happen. Those employees will also testify about how they came to dread going to work, how they cried at their desks and in their cars and experienced physical and emotional symptoms, and pretty soon they too left. The employees who are still at the court, and you will hear from at least one of them, will testify about the stress of dealing with the constant turnover of colleagues, how they at times have felt they could never catch up and constantly felt as though they were struggling just to deal with basic tasks. And significantly, you will also hear from attorneys who have practiced and continue to practice in front of the judge the entire time that she has been on the bench in Bremerton. And these attorneys will describe the effect on them of the judge's impatience and lack of basic respect. And importantly, these attorneys, who will include prosecutors as well as defense attorneys, will also describe the impact the constant turnover of court staff has had on the court's functioning. They will testify about how the court continues to struggle to carry out such kind of ground level tasks as hearings not being properly set, docketing not happening timely, probationers not being monitored, counsel not being appointed, competency and restoration orders not being competently and timely processed and sent to Western State, and warrants not being quashed, which can lead to improper arrests. These attorneys are not just describing a judge who is mean to them. They are describing a court that at times is barely able to do what it is supposed to do because of the chaos of its staff and administration. The panel is going to be asked to decide a sanction. The judge has agreed and the panel has accepted the stipulation that any sanction has to include a program of training and coaching and mentoring, but the panel is not limited to that. To make its decision, the panel has to weigh a number of factors. You will be hearing in the testimony not about isolated incidents, but about a pattern of violations which has profoundly affected the well-being of the court's employees and has hamstrung the court's operations, which has resulted in harm to the public and diminished the public's respect for the court and the judiciary. You will also be hearing about how the judge failed until the 11th hour. Actually, it was after the 11th hour because it was after we had already gone on the record for this hearing on Monday to take responsibility for her actions. And importantly, how she has obstructed and failed to cooperate with this proceeding and treated those who she believed planned to be witnesses. In short, members of the panel, you are going to hear evidence that Judge Flood's violations of the Code of Judicial Conduct are very serious. The judge has admitted she acted contrary to the Code of Judicial Conduct, which she is obligated to uphold. This conduct requires a serious sanction, which will fulfill the Commission's duty to restore and maintain the honor of the judgeship and protect the people by assuring the judge will refrain from acts of misconduct. Thank you again for your attention this morning.
Thank you, Ms. Rasnick. Ms. Bremner, am I turning to you or Mr. Gross?
To me, Your Honor.
All right, go ahead, Ms. Bremner.
Thank you. Thank you. And obviously I'm on a different computer because mine failed for a minute, but we're getting it back up. But I wanted to be able to proceed expeditiously, of course. And so I'm over here with Judge Flood. I want to say first, good morning, Your Honor, and members of the panel and opposing counsel. Mr. Gross and I are very honored to represent Judge Flood. And I think we need to start with this, that what we're talking about here in terms of this more narrow proceeding is a question of what should be done, if anything. She's wanted to expedite this by stipulating, and that's why you're not having to have a full hearing that could last a week or more based upon what's been alleged here. We're recommending to you, when you hear all of the evidence, that there be an admonishment and some stipulated training. She's acknowledged in the stipulation where she can approve, where things in retrospect are, with respect to tone and other things like that, are things that could be perceived as problematic to some folks. So she stipulated to that. But what we have in this case, first of all, is that the witnesses and disciplinary counsel have grossly overstated what they allege she did and said and how she acted. They overstate the severity and pervasiveness of impatient and discourteous conduct. Some of you were on the commission back when I had the Judge Judy Eiler case. And that case was one about tone, impatience, and her personality. Judges should be tough. She was tough. We went through a full hearing in that case on the merits in person, not on Zoom. The recommendation from the CJC counsel in that case was removal from office. Well, that's not what happened at the end of that hearing. There was a suspension for some time, relatively brief. We appealed it to the Supreme Court. It's the only time I've argued in front of the Supreme Court in my 40-year career. And in that case, what we argued was this, and you have these cases, and you know in your history of cases that you've heard, that it can't just be who somebody is. I mean, people may not like me. I'm sure a lot of people don't. But the fact is, I am who I am. You know, the way that I act, my tone, all of those things, that's just who I am. Can I be punished for that as a lawyer? No. Can a judge be punished for her tone or being tough or having a certain attitude? No. And that's what the Eiler case said. When I got up in front of the Supreme Court in that case, I said, I had a quote, and it was something like this: she's a terror on the bench. Nobody likes her. Everybody walks on eggshells around her, and she's just mean. But that quote wasn't about Judy Eiler. It was about Justice Sotomayor during her confirmation hearings. And I said to the Supreme Court, all of the justices, they could tell me to shut up and sit down. They could cut me off. They can interrupt me. They can talk down to me. They didn't, of course, but I'm saying they could. Because it has to be speech and demeanor plus something to be sanctionable. Like this: is it racist speech? Is it discriminatory speech? Is it sexist speech? Is it speech that in any way singles somebody out in a discriminatory way based on their sexual orientation, their religious beliefs, their ethnicity, their immigration status, all of the LGBTQ issues? If it's not any of those things, we just get back to who that person is. And yes, judges can be strict. Judges have to be tough. By the way, they're supposed to control their courtroom. They're supposed to run their staff. They're supposed to run a courthouse. And when I was, over the years I practiced, I had a judge tell me to sit down and shut up, and I did. I also was asked to babysit a defendant's kids in the hallway when I was a prosecutor. And I thought that was a bad idea because I'm not great with kids, but I did it. So that, I think we really need to start with that, which is she somebody that can be tough? Yes. Is she somebody that at times it can say, why didn't this happen or that happen? Well, yes. But she cannot be sanctioned for something where she did nothing else. She's never treated someone in a racist way with her language. She has never demeaned somebody in her speech or tone based on their gender or anything else in terms of protected classes and individuals. So then we get back to the issue, and that is, you know, what's her tone? You know, how is she in court? How is she with staff? She's been the sole judge at Bremerton Municipal Court for more than 3 years. And here's something I think is so important for the panel's consideration. She's been on tape. She's been on audio recorded tape for every single second that she's on the bench. Thousands and thousands of hours of interactions with staff, attorneys, probation officers, defendants, and other court participants. And despite alleging that this judge's violations frequently occurred on the record, disciplinary counsel has not listed a single audio or videotape. I'm going to say that again. They have not listed a single audio or videotape exhibit, not one clip from a hearing or video that would allow this panel to judge for itself whether or not her interactions cross the line. And I know in many other proceedings, of course, you've had access in cases where I've represented judges. Certainly, we've had video proffered evidence, and there's none of it here. She's the first female judge and the first Black judge in Bremerton Municipal Court history. And she walked into a courtroom that had been run by one white man, Judge Doctor. He'd been there for decades. She inherited, actually 24 years to be exact. She inherited a court that was so dysfunctional that the judge gave a speech to the Kitsap County Bar Association, calling his own court in the midst of COVID a joke. He wrote an email to the Kitsap Sun that was published, stating cavalierly that he did way too much eye rolling on the bench. And he retired early. And he also said there was no justice in that court. He was the judge. He was the judge that turned this court over to our client. And this is the conduct for which the prosecutor, I'll pronounce it, I hope correctly, Gary Hersey, who also practiced frequently in front of Judge Doctor, will tell you was unprofessional and unacceptable, eye rolling. But the previous judge, Judge Doctor, said that's what he did, and he put that in writing because the court was so dysfunctional. Judge Flood raised her voice so rarely that multiple of the CJC's key witnesses will say that she never yelled, ever. And these are their witnesses. A word the panel will hear over and over in this case is, and something I mentioned from the outset, is the word tone. Judge Flood has submitted the declaration of expert Susan Dreyfus, explaining how racial bias often manifests in tone policing, especially Black women. Tone policing, especially Black women. Their tone, their volume. So she is. And I'd submit that there's implied racism in a lot of this, and we will hear it from the expert, to say that her tone should be different. Her tone should be like mine. Her tone should be like Nick Rose's. Her tone should be like yours. But it's not. It's who she is. And that's part, especially tone policing is especially conducted against Black women, like Judge Flood. Many of the disciplinary counselors, witnesses, were friends with each other before they worked in this court or worked with the judge, and they're friends now. And this is really important, I think, too. And you're sophisticated, obviously, on this panel, dealing with bias of witnesses, witnesses that have a financial or other interests, or bias against a judge. These were friends before, and they're friends with each other now. At least four are represented by the same law firm or are planning to file lawsuits against the city seeking money. And we have cases that have been filed. And think about that. The interest in going after this judge and the city for money, the bias. And part of that too is when you look at the bias, like yesterday, when it was alleged that the judge was presiding over a calendar and thumbing her nose at you and the presiding judge here, somebody called that in. Someone with a bias. And guess what? It was false. She had a pro tem at 8:30. Think about that for a minute. Also, in terms of objections from the public to release, let me back up on that. When the court asked about objections from the public to sealing the medical records and affidavits, declarations of Judge Flood, well, somebody did weigh in, but that somebody, again, is someone with an interest in turn, and she'll talk to you about this in terms of an interest in the court and a commissioner position. That wasn't just John Q. Public. That was another quote unquote interested party. The litany of things that we saw from the prosecutor are all things dealing with the court and what you just heard from counsel. I know you've dealt with these courts before, because more often than not, the cases that come before the commission are from judges in the courts of limited jurisdiction, municipal courts, district courts, where it's difficult, they're overloaded, and so their criticisms have been generally lodged by a prosecutor. And that's how these things go if there's problems, but they weren't the fault of the judge. In these courts, the admin folks will stay, and oftentimes judges can come and go. In a lot of ways, they feel like they run the court. Interestingly, in this case, you've got an administrator who's telling the judge how to act. An administrator is telling the judge what to do. An administrator is complaining about the judge and her tone. Well, you're going to hear in this case that these witnesses were insubordinate. They called her Tracy. They called her Tracy. I don't call her Tracy. They talked behind her back and gossiped about her. They talked back to her. You're going to hear that, and I'm being very general here in terms of the CJC case, that Judge Flood is delightful, funny, self-deprecating, smart, and dedicated. These individuals will show you didn't want to work as hard. They didn't like the change from a judge that had been there for 24 years to a new judge who's a Black woman who's very accomplished. And they would talk back to her and they would push back on her. I'd submit to you, and this is the reason we had the John McKay declaration in the McKeenan case, the group that John McKay spearheaded, and then that group wrote to the commission in connection with that case, is we cannot have a commission that is not fully diversity trained to understand these types of issues that present themselves here and did in McKeenan's case. He came from nothing. He was in juvenile jail. He worked his way up through community colleges to end up on law review in law school and had a picture on the side of a bus that pertained to that. This commission found against him. That was appealed, and the Supreme Court unanimously found in his favor that we want to make sure that we have inclusion in this system, that we have judges of diverse backgrounds, and that we understand who they are and how they got to where they got today. She's a judge. She served in the Navy. She worked her way up. She has a family. She's done everything she can, including trying to control the court and have everything operate smoothly. But you cannot have a situation where the staff are not cooperating, some of them, the CJC witnesses, and where the CJC has been investigating her for a long time. She had to deal with the court during COVID, during her own health issues, during a staff that was not helping her, and over calendars that were overwhelming, and dealing with security, and dealing with budget issues, and dealing with other obligations she's had. Let me turn to who she is, aside from what I've just said. She's somebody that served on the board of governors of the Bar Association. That's a big deal. I mean, obviously, big responsibility, but it also means that she's held and has always been held in high esteem. She's also been on the executive committee of the Lauren Miller's Bar Association. Of course, that's a bar association for lawyers of color, and a very lofty purpose, again, of trying to integrate all of us in a system where everybody's treated fairly. And we elevate certain voices, including Black voices, like Judge Flood's. But I frankly, sitting here and knowing her and knowing what I know about her and what we see in these various declarations, it's amazing that she's still standing. Speech plus something, tone plus something. All you have here is speech and tone and not anything else, where she's talking down based on race, disability, gender, financial status, immigration status. Absolutely zero evidence of any of that. And I would urge you to look back at the Eiler case, because we fought long and hard for that. Also, Judge Robert Macbeth, who's an expert in judicial ethics at the Judicial College, he assisted in that case, and he sent me all the more recent cases on tone and speech. And again, all across this country in ethical opinions, it has to be something beyond just who she is, how she acts, and how she presides. If you were to impose a rule that said that judges all have to act a certain way, you would be absolutely buried, because that's not what you're here for. And you have a lofty purpose and do wonderful work in the commission to make sure that we have judges that are fair and serve the public in a way that is appropriate and exemplary. But you're not here to police people's personalities, their tone, their demeanor. I'll close by saying that it was about change, It was about insubordination, and it was about personalities, and it's about bias. And yes, she knows there's times when she's not been exactly perfect. But the system doesn't require perfection. It just requires justice. And it would be unjust and an injustice to sanction her in a way other than what we've requested. An admonishment, she's happy to do that. Some training, she's happy to do that. And finally, you will be hearing from her in this case at some length. And I just, for the CJC counsel to say this has been a series of events where she's not cooperating. This is a series of events where, she's just acting in a certain way that you need to sanction. You sure she's had health issues? And frankly, nobody needs to have that broadcast anywhere. None of us do. It's been in the news, the questions about her health. Every single part of this case has been reported, and that's another part in terms of punishment against her. She's already suffered that publicly in terms of what's been out in the news about her with false information about her. Thank you so much for your consideration. And I know that this is a case that has been around for a long time, but it's an important purpose that we elevate judges like Judge Flood, but we also, where needed, where she wants to do this, that she has additional training so that she can be the best judge that she can be for the citizens of Bremerton. Thank you.
Thank you, Ms. Bremner. So panel members, that does conclude the opening statements by counsel. The next step is Ms. Rasnick is going to present her witnesses. Looks like, there you go. So Ms. Rasnick, do you have a witness?
Yes, Your Honor. Disciplinary counsel calls Jennifer Johnson.
All right, Ms. Johnson, if you can hear me, can you turn your camera on?
Oh, yep. Give me 1 second. There you go.
Okay, Ms. Johnson, you have been called by Ms. Rasnick as her first witness. If you can raise your right hand. Do you swear or affirm the testimony you're about to give is true and correct?
I do.
All right. Ms. Rasnick, you may continue.
Good morning, Ms. Johnson. This is Reagan Rasnick, disciplinary counsel. Can you hear me okay?
Yes, I can.
Great. May I call you Jennifer today?
Yes, you can.
All right. Jennifer, where are you currently employed?
I am currently employed with the Administrative Office of the Courts.
And how long have you been employed by the Administrative Office for the Courts?
Since last June of 2023.
Did you have a history of being employed in the court system before you went to work for AOC?
Yes.
Can you describe your background of work in the court system, which courts you worked for?
Okay. I previously to working at AOC, I started working in the court systems about 35 years ago. I started with King County District Court as a court clerk in actually Sunnyside District Court in 1989, and then went to King County District Court in November of 1999. And then I went to Kent Municipal Court in 1998 or 96. And I was a lead at Kent Municipal Court. And then after Kent Municipal Court, I went to the Des Moines Municipal Court in January of 1999 and was the court administrator there. And then went to Bremerton Municipal Court in November of 2022, and then left there and went to AOC.
Great.
And
How many total years of court management experience do you have?
Court management, At least 30.
Are you active with any professional organizations for court managers?
When I was a court administrator, yes, I was very active. I was on the District and Municipal Court Managers Association. I was also a part of the National Court Administrators Association. I was on the Gender and Justice Committee for years. I was also on the Legislation Committee. I was also on the Interpreter Commission, and I was Vice President of the District and Municipal Court Managers Association.
Right. How did you first come to be involved at Bremerton Municipal Court?
I received a phone call from Latricia Kinlow, who is a colleague of mine from Tukwila Municipal Court. And she had reached out to me and said that she needed me to go out with her to Bremerton to go help. And it was through Courts Helping Courts. And I said, okay. And we drove out to Bremerton to
Okay,
go.
let me just ask you first, if you could explain what is Courts Helping Courts, just so folks have a sense of what that is.
Okay. Courts Helping Court is where if a court is in need of some help, and it can range from anywhere of, court administrator may, have a shortage of staff or something might have happened, or that court administrator may need some help with putting something together. That's what this program was set up to do, was to help courts whenever they needed some help with something.
And Latricia Kinlow, was she someone who was active with Courts Helping Courts?
Yes.
And
yes.
Courts Helping Courts is that a program of DMCMA or
yes.
or that DMCMA was part of?
Yes, that program is through DMCMA. Yeah.
Okay. And do you remember about when Ms. Kinlow reached out to you about helping out at Bremerton?
It was about sometime in late September of 22.
Okay. And were you aware of anything about what was going on at Bremerton Municipal Court before Ms. Kinlow reached out to you in September 2022?
No, I didn't know anything.
Were you acquainted with any of the staff at Bremerton Municipal Court?
I did know Dawn Williams, and I knew her through our association and different committees that we were on. So that's how I knew her.
Okay, but you weren't friendly with Ms. Williams?
No, she was just my colleague. We didn't, yeah, that was about it. Yeah.
Did you know any of the other Bremerton Municipal Court staff then? So we're still talking about September 2022.
No, I didn't know any of the staff there.
Were you acquainted at that time with Judge Tracy Flood?
No, I didn't know Judge Flood.
And had you helped out any other courts through Courts Helping Courts before this time in September 2022?
Yes, we had. I had helped with Bellingham Municipal Court. They were having some issues like a year or two prior, and so they needed some help with staff coverage. And so I had a couple of my clerks help with covering calendars.
And in your experience, what is the usual length of time that Courts Helping Courts kind of pitches in when a court is in need? Is it a long-term thing, a short-term thing, an emergency thing? What is the general way it operates?
It's generally a short term. It's not meant to be for a long term. It's just to kind of like fill in the stopgap measures for that court to help them get to where they need to be, but it's generally been just short term.
Okay. So you mentioned a moment ago that you were starting to say you and Ms. Kinlow had gone out to Bremerton after she contacted you. Did the two of you go out there, like literally go out there together?
Yes. So Miss Kinlow, after she had messaged me and said she needed me to go with her to Bremerton, we coordinated so that we could ride together out there, and we went during the week and headed out there to
Okay.
Bremerton.
Did the two of you talk at all about what to expect?
We did. We were in the car driving, and I asked Miss Kinlow, I said, why are we going out to Bremerton? And because I didn't know what was happening. So she said, well, we need to go out there because they need some help out there. And I said, oh, okay. I asked Miss Kinlow, I said, who's the administrator out there? And she said, Don Williams. And I said, Don Williams. I said, Don knows what she's doing. Why are we going out there? And she says, well, she has a new judge, and the judge called me and said that she needs some help out there. And I said, okay, well, what's going on? And she said, well, there's no staff there. And I said, well, where's Dawn? And she said, well, Dawn's gone. I said, what do you mean Dawn's gone? And she said, she's not there. And so we're going to go help and see what we can do to help assist this judge. And I said, well, who? I said, who's the judge? I said, isn't it Judge Doctor? And she said, no, it's a new judge. And I said, oh, okay. I said, who's the new judge? And she said, well, it's Judge Tracy Flood. And I said, oh, okay. I said, I don't know who that is. And Ms. Kinlow said, well, she's a judge of color. And I said, oh. I said, okay. I said, let's go, let's see how we can help. And she says, yeah. And
What was it notable to you that Ms. Kinlow said Judge Flood is a judge of color?
it was. And the reason why it was because when I went to Des Moines, the judge there was Judge Raines, and he was a judge of color. And we went to Des Moines to help Des Moines also. And we were able to, I ended up staying at Des Moines and was able to turn that court around. So I wanted to be able to, working with help a judge of color to help succeed that court. So yes, I was very optimistic so that we could help her in any way we could in that court.
And how would you describe your own racial identity, Ms. Johnson?
I am African American and Mexicana.
And so was it important to you to be able to provide assistance to a judge of color?
Yes. Yes, it was.
And when you and Patricia Kinlow went out there, did you think you would be helping out long term or short term?
Short term. I did not think it would be long term. I thought we would just be going out there, see kind of assess the situation and see what we needed to do, but not long term, no.
Do you remember going there the first day, the experience of going to Bremerton Municipal Court that first day?
I do.
And can you describe that? Who did you find was on staff there in the court when you arrived that first day?
When we arrived, we went into the entryway and we told the security guard who we were. And he said, yes. He goes, I know Judge Flood is expecting you. And we said, okay, great. And so he showed us, he showed us back to the clerk's office. And when we walked into the clerk's office, there was two females in the office, and that was Amber Dodge and Martita. Her last name slips my mind right now. And the reception was very welcoming from both of them, and even the security officer.
Were they the only two employees of the court, or did you have any understanding about whether there were other employees who were there?
At that time, I didn't know who the other employees were there, but in the clerk's office, there was just those two.
Okay. And what could you describe what you observed of the demeanors of those two clerks who were in the office? Amber, I think you said, and then Martita.
Yes. So Amber was very excited to see us. She said, "You're coming here to help us. You're coming here to help us." I mean, she was practically in tears, and I kind of looked at Trish, Kinlow, like, what is happening? And I said, "Yeah," I said, "We're here to help." And Martita was very, very welcoming also. And she said, "Oh," she said, "we're so glad you're here, to help." Yeah, they were very appreciative to see us.
And did you notice anything out of the ordinary in or around the clerk's office that first day?
I did. So while Trish was, Ms. Kinlow was talking to Martita and Amber, I just kind of was looking around the office, looking at each desk, kind of taking in and assessing the situation. And as I was looking around, I had walked towards the back of the office, and I looked and I saw what looked to be like Dawn's office, and then there was another office right next to it. And I peeked my head in, and I saw that there was a safe in there, and that the safe was wide open. And I looked over at Trish, and I called Ms. Kinlow. I said, "Trish," and she said, "Yes." I said, "You need to come see something right now." And she looked at me, and she walked over to where I was, and I pointed to the safe. I was standing in the doorway, and I was pointing to the safe. I said, "That safe is open." I said, "There's bags of money in there." I said, "There's money bags in there." And Trish looked, and she called Amber over, and she said, "Amber," she said, why is that safe open?" And Amber was
Objection, hearsay.
I'll move on.
Okay.
I'll ask a different question.
All right.
Okay. Did the safe get closed?
Yes. Ms. Kinlow directed Amber to close the safe.
Okay. And did you have any understanding of whether who was covering the in-court calendars, whether court was going on at that time?
At that time that we were there, or
No, that particular morning. Like, did you know whether there was anybody covering in-court calendars?
I don't know. I don't know.
Okay. Do you recall whether you saw Judge Flood that morning, that first day?
The first day we did, and we were there in the afternoon.
Oh, sorry, in the afternoon.
That's okay. We did. She appeared in the door as we were talking to Martita and Amber, and she said, "Hello." And we said, "Oh, hello, Judge Flood." And Amber was very excited, and she said, "Judge Flood, this is Miss Jennifer and Miss Kinlow." And Judge Flood said, I know I invited them, and so Trish and I started walking towards Judge Flood, and she said, let's go upstairs.
And what was upstairs? Where were you going upstairs?
Going upstairs to her office.
So the judge's chambers were on the second floor of the court, and the clerk's office is on the first floor of the court.
Yes.
And is the courtroom also upstairs, or the multiple courtrooms, are they also upstairs?
Yes, the 2 courtrooms are upstairs. Yes.
Okay. So you and Ms. Kinlow went upstairs to the judge's chambers with her.
Yes.
And what happened once you got upstairs to the judge's chambers?
So we walked into the judge's office, and we sat down, and she was speaking very softly. We were having a hard time kind of trying to hear her, and she had closed the door, and Trish started the conversation, and she asked, Judge Flood, how can we help you? What is going on? And Judge Flood said that there was a culture there. And
those are the words that she used. There's a culture.
Yeah. She said there's a culture here. And Trish and I looked at each other, and we said, what are you talking about? Because we were there to find out what she needed. And she said that almost all the staff had left. And we said, okay. And she said that Cindy Hope was getting ready to go out on vacation, and that she needed help covering with court coverage because she didn't have any staff. She only had Martita and Amber, who didn't have any court experience. And we asked, well, where did everyone go? And she said they've left, and only Cindy and a Heather Hunt was left, and Ian Cohen, probation officer. We said, okay.
Did
So
you
we asked,
did you see any of the others of them? Did you see Mr. Cohen or Ms. Hunt or anything?
I don't recall seeing Mr. Cohen. Mr. Cohen had walked by when he was leaving, and he had knocked on the judge's office while we were in her office and said he was leaving and said goodbye to her. That was the first time we had seen him. We didn't see Cindy Hope that afternoon, and we hadn't seen Heather Hunt either.
Okay. So the judge said to you there's a culture and that she needed help covering the court. Did she elaborate on what she meant by there's a culture?
We did, yes. We were asking her, what did she mean? And she said, she kept repeating there was a culture, and she kept whispering, and then she put her hand up to us and went like this, and we stopped talking, and then Ian, Mr. Cohen, had knocked on the door, and then because I guess she could hear him walking or coming close to the door, and then that's when he had popped his head in to say he was leaving, and she said okay, thank you, we'll see you tomorrow. And then she said, we were like, we didn't understand what she was meaning to about a culture, and we kept trying to get clarification. but it just wasn't clear, and she just wasn't being clear to us, and so we just kept trying to focus on what she needed. So we shifted back to what she needed.
And what did you and Latricia Kinlow do for the remainder of that day? Did you stay at Bremerton Municipal Court like for the rest of that work day?
So we had gone there in the afternoon, and so we had to find out like the accounting hadn't been done. So we quickly did the accounting, and we asked her, we said, okay, so, can you please clarify to us if Ms. Hope was going to be there, so that if the accounting was getting done, who was doing the accounting? And I don't think, because I think it was either a Thursday or Friday, and she wasn't going to be there. So we had to figure out coverage to help do the accounting. So because Amber and Martita didn't know even how to like cut off or anything like that. So we showed them that day how to cut off.
And when you say cut off, do you mean like just close the books for a certain period? And
close the books for the day.
Who had a court, like at your court that you were working for at the time, whose responsibility was it to keep the books like that, to cut off?
So when I was at Des Moines, my lead would do the accounting, and so they would cut off every day about 4 o'clock and balance to collect all the money from the clerk and do a deposit.
Okay, but from what you could see there at Bremerton on that day, did it seem like there was anybody there who was prepared to cut off and do the accounting for the day?
No, there was not.
Did you and Ms. Kinlow pitch in and get that taken care of?
I did. Ms. Kinlow asked me to do it, and so I showed them how to cut off, and then we just had them put their money in a bag and do a deposit.
Objection, relevance.
Ms. Rasnick.
It is relevant to the status of what was needed to get the court up and running, and what Ms. Johnson and Ms. Kinlow did on the first day, because they were short-staffed.
Overruled.
Right. Other than dealing with the getting the cutoff, the day's finances bundled up, what else did you and Trish do on the first day?
That was about it, because we had gotten there kind of late. It was after 3 o'clock sometime. So by the time we left, it was well after 5 o'clock. And so we had a sense of direction from Judge Flood as to what she needed for coverage. So as soon as we wrapped up with the accounting, we headed out and started heading home.
And had she also asked you to help to get some coverage lined up for the courtroom the next day?
She did. She had actually asked us to get coverage for the following week, as Cindy Hope was going to be going out on vacation.
Okay. And did you and Ms. Kinlow set to the task of trying to do that as well?
We did. We also asked her, okay, if Ms. Hope wasn't going to be there, who was going to be doing the daily accounting? And she didn't know. So we added that to our task of figuring out how we could also include how to do the deposits and things like that. So we were tasked with covering the courtroom calendar.
Objection, relevance.
Overruled.
And how did the two of you set to the task of getting this coverage lined up? Were you, for example, making phone calls, or sending emails to folks, or what was the process you went through to get that coverage lined up?
So
Objection, relevance.
Overruled.
Go ahead, Jennifer, you can answer.
So we started on our way back home, we started to figure out who we needed to get for coverage because we needed clerks with courtroom experience. And we had told Judge Flood we would not be able to get clerks in person. That just wasn't going to be able to happen just because how far it was. And we asked her if it was okay to get clerks that would be able to remote in, and she said yes. So we started to put together a list of clerks so that we could figure out the coverage for the week. And so we started sending out emails to other court administrators to see if they could help coverage for the following week. And then we worked with a couple other court administrators to help with accounting so that we could get someone out there in some type of management role to be able to help with the accounting. And that ended up being myself and Christy Shorn from Issaquah Municipal. So her and I would do the accounting at the end of the day.
Okay. And did you did either you or Ms. Kinlow or both of you go back out to Bremerton Municipal Court the next day?
I don't think we went out the next day. I think we ended up going out the following week to help to make sure everything was going fine and we had the coverage and the accounting was getting done. And just trying to be present for the staff there and for Judge Flood.
You had mentioned a second ago, I think that one of the clerks, Cindy Hope, was going to be on vacation. Did that person then come back from vacation?
Miss Hope did not come back from vacation, or she came back from vacation, but then she ended up, Judge Flood sent, I think it was Miss Kinlow, I can't remember who, but we got a phone call from Judge Flood that
Objection, personal knowledge.
Mr. Resnick, you want to set a foundation?
Sure. Jennifer, did you have knowledge of the communication regarding Cindy Hope? Are you speaking from personal knowledge of this communication from Cindy Hope?
Yes.
How did you learn about the communication from Cindy Hope?
Because we had, Trish and I had a phone call with Judge Flood.
Okay. And did Judge Flood convey to you the information about Cindy Hope during the call?
Yes.
And what was the information about Cindy Hope that was conveyed during the call?
That Ms. Hope had given notice that she was going out on medical, and that she would not be in the week she was supposed to be back.
Okay. And so did this create a need for more staff coverage?
It did, yes.
Do you recall a conversation with Judge Flood about her own schedule and her own plans to be at the court, present at the court around this time?
Judge Flood was scheduled to go to a conference out of state that week that Ms. Hope was supposed to be back. And Trish and I said, you should not be going. We would strongly recommend you not going to this conference. We're trying to get you coverage and you don't.
I didn't hear that.
I'm sorry, the objection was hearsay?
Yes.
Ms. Resnick, perhaps make sure the question is limited to what the witness said.
Sure. Jennifer, could you describe first, let me ask a different question first. I mean, did you have concern about learning that the judge planned to be out of state for a conference at this time?
Yes.
And why were you concerned about that?
I was concerned because she didn't have an in-court clerk to do the calendar, and Cindy Hope had just given notice that she wasn't going to be there, and we had only provided coverage for the week of the vacation.
And did you give any recommendations?
Sorry to interrupt, but I'm connectivity issues.
Did you have an objection, Mr. Gross?
No, I'm just having connectivity issues and I can't hear the witness. Your Honor.
I've lost Mr. Gross's audio as well. I cannot hear him.
Mr. Gross, can you hear me? I cannot.
Your Honor, can you hear me? Your Honor?
You're breaking up a little bit, Mr. Gross. Can you fix what's going on over there?
Yeah, so we're at a business center conference room and the Wi-Fi just is not good. It's because my computer's frozen. No. Your Honor, can you hear me now?
Can.
Did you hear what I said about our Wi-Fi?
You said you were at a business park conference room and the Wi-Fi was iffy.
Exactly. It keeps freezing.
So what do you propose we do about it?
Well, we can continue. I think we're okay for now, so I'm okay to keep going. I would ask that the disciplinary counsel to repeat the last question.
Sure. Can you hear me, Mr. Gross?
Yes.
Okay.
And Ms. Radnick, before you continue, let me say the time is now about 9:57. I'd like to take a nature break right around 10:15. So if you have a breaking point around that time period, let me know and we'll take our 10-15 minute break.
Okay, great. Thank you. Jennifer, what I wanted to ask is, did you give any recommendation or advice to the judge regarding the planned out-of-state conference?
I did. I suggested to the judge.
Objection hearsay.
What was the question again, Ms. Rasnick?
Did Jennifer give any recommendations or advice to the judge about the out-of-state conference?
The question technically is not calling for hearsay.
Objection non-responsive.
I don't recall what the answer was. At this point, re-ask the question, Ms. Rasnick.
Okay. Jennifer, did you give any advice or recommendation to Judge Flood regarding the out-of-state conference?
Yes, it was my recommendation.
Objection non-responsive.
Overruled.
Objection hearsay.
The question was whether Ms. Johnson gave any recommendation. Is that correct, Ms. Rasnick?
That was the question.
Then
yes.
Overruled.
You can answer, Ms. Johnson.
Yes, I recommended that she not go to the conference as we had only provided coverage for the previous week, and Ms. Hope had just given notice that she was going to be out on medical leave.
Okay. So, did the judge go to the conference?
She did.
And how long did you and Ms. Kinlow working together have to put together coverage for clerks at Bremerton Municipal Court?
We got coverage together for that week, and then long term, it ended up going longer than expected. Gosh, we ended up having clerks cover almost through the end of January, and then we had one or two still straggling of helping 1 day a week through the end of May.
But
We had one clerk.
the initial period of the most coverage was a couple of months.
It was a couple of months, yes. I would say October through December.
And during this period, did you and Ms. Kinlow also help Judge Flood try to fill vacancies?
In regards to filling the vacancy, that didn't happen until I came on board in November.
Okay, so can you describe the process of yourself coming on board? And yeah, just describe that first.
Okay. So the position for the court administrator had been posted, and I had ended up applying in October and then was offered the job late October, and then started full time November 1st.
When you decided to apply for the position, had there been anyone else interviewed before you decided to apply?
I'm sorry, can you ask that question one more
Sure,
time?
I'll make that shorter. Was anyone else interviewed for the position of court administrator before you decided to apply for it?
I don't.
Personal knowledge.
Well, let me ask it a different way. Did you participate in interviewing anyone else for the court administrator position before you decided to apply for it?
No.
Okay. And do you know whether anyone else applied before you?
No, I don't know.
Okay. How did you decide to apply for the court administrator position?
Actually, it was my husband who had encouraged me because he could see that I was lighting up.
Objection, relevance.
Overruled.
Go ahead, Jennifer.
He could see my excitement in the possibility of helping rebuild this court, and he encouraged me to apply. So,
were you optimistic that you could make a difference at Bremerton Municipal Court?
Yes, I was. Yes, I was very optimistic. I was very excited.
And did you feel it was a good fit for you based on your skills and experience?
Yes, I did.
Was part of your excitement, did it have to do with getting to work with a judge of color?
It was, yes.
Who interviewed you for the court administrator position, if you recall?
It was Judge Flood, Ms. Kinlow, Gail Cannon from CTAC Municipal, and Christy Shorn from Ithaca Municipal.
And who communicated to you that you had been selected for the position?
Judge Flood.
Do you recall her demeanor when she contacted you or let you know that you had been selected?
Yes.
How did she let you know?
She contacted me by phone.
And what was her demeanor on the phone call?
She seemed very happy and extended an offer for the job, and I was very excited and I accepted, and she seemed excited also.
Okay. I'm going to share a document which I would like to have you take a quick look at. Let's see. Jennifer, let me know if you can see the document I've just put on the screen. And for the panel, this is what was identified as disciplinary counsel's exhibit 223.
I do see it.
Let me just scroll through and let you get a chance to, have you seen this document before?
Yes.
Is this the letter that was sent to you by Judge Flood offering you the court administrator position?
Yes.
And is this your signature on the second page accepting the job offer?
Yes.
Okay. Disciplinary counsel offers exhibit 223.
Exhibit 223 has been offered. Mr. Gross?
No objection.
Without objection, 223 shall be admitted.
All right. Take down the share. Oh, let's see. I will stop sharing. Okay. When you took the position at Bremerton, how much notice did you give at Des Moines Municipal Court where you had been working?
I gave less than 2 weeks notice. I had talked to Judge Leon because I needed to work. I needed to be in Bremerton and at Des Moines because there was both at the week of the 24th, both courts were right in the middle of budget. And so I needed to be at both cities. And so I worked. Go ahead.
Oh, no, go ahead and finish. Sorry.
I worked half day the following week, half day at Des Moines, and then would leave around noon and go to Bremerton.
Were you concerned at all about leaving your position at Des Moines Municipal Court?
No, I wasn't.
Why were you not concerned?
Relevance.
Overruled.
Go ahead, Jennifer.
In 2019, 18, I think, the city manager wanted all departments to start working on succession planning because there was quite a bit of movement coming of succession planning, and I had worked with Judge Leon. We had put together kind of a succession plan, and it took about 5 years. And so I had two senior clerks who I had sent to training for kind of management. They received, both of them received their national certifications for court management, court executive. So we really were looking towards the future, and that's what the city manager wanted of all, including the judicial Des Moines Municipal Court. And so we had put together a succession plan. So I felt very confident in leaving, that either one of them would be able to step into the role of the court administrator at that position.
Okay. And was the court administrator position in Bremerton Municipal Court at the same rate of pay as you had been receiving in your position at Des Moines Municipal Court?
No.
Did you live in Bremerton at the time?
No.
Did you and your family eventually move to Bremerton?
We did.
And before you moved to Bremerton, where were you commuting to Bremerton from?
Federal Way area.
When did you move to Bremerton?
We moved to Bremerton in late or December 9th. We had put an offer in the house in November, late November.
So you moved to Bremerton in December 2022?
Yes.
Okay. And do you remember when your first day as court administrator was?
It was October 24th.
And do you remember your first day?
I do.
Who was on staff, if you remember, who was on staff at the court then?
It was Amber Dodge, Martita, and Stephen DeRozier. And that was the first time I got to see Stephen as a full-time person.
And what was Mr. DeRozier's position?
He was the therapeutic coordinator.
Therapeutic court coordinator?
Yes.
And was the probation officer still employed as well?
Yep. Mr.
And-
Cohen was there also, yes.
Okay. Who had been doing the court administrator duties at Bremerton before you started as court administrator, like in those couple months before?
I believe Miss Heather Hunt.
And was she still employed by the court when you started as court administrator? Did you have a knowledge of what her situation was?
On the 24th, I didn't have full knowledge, but I knew that she was still employed with the court.
Did you later come to have knowledge of what Ms. Hunt's employment situation was?
I did.
And what did you learn? What was her situation?
So when I started full time, I think November 1st, I had called HR because I needed to know what her status was. Because I had asked Judge Flood, okay, where is Miss Hunt? And she had informed me she was out on some medical leave. And so I said, okay. And so I called HR and I spoke to, I believe, Charlotte Nelson. And I asked her what the status was with Miss Hunt, with her leave. And Miss Nelson informed me that
Objection, Hersey.
Okay. I can ask it a different way. Did you gain an understanding of what Ms. Hunt's leave status was?
I did.
And was there an expectation? Did you gain an understanding of whether there was an expectation of when Ms. Hunt would be returning from leave?
Can you ask that again?
Sure. Did you gain an understanding of when Ms. Hunt would be returning from leave?
I did.
And what was your understanding of when Ms. Hunt would be returning from leave?
She was supposed
Objection, this is still hearsay.
Overruled.
Go ahead, Jennifer.
She was actually supposed to be working. She only had leave to be for doctor's appointments.
But she was not working at all.
She was not at the office, no.
And was Miss Hunt eventually dismissed from the petition or from the position? What was the result with Ms. Hunt's employment?
In January, she ended up resigning from the position.
Okay. All right. Your Honor, you had mentioned wanting to take our morning break around 10:15, and I've got 10:13. If this would be a good time, it would work.
Let's do that. All right, by my computer, the time is now 10:29. That is a full 15 minutes for our mid-morning break, and we are ready to resume with the direct examination of the witness. Appears that we have everybody with us. Commissioner Miller, are you back with us? Pausing just till we have Commissioner Miller's camera back on. Right, Commissioner Miller, are you with us? There she is. Okay. So at this point, let's continue with the examination. Ms. Rasnick, you may continue.
All right, Jennifer. Just before we left off, you had mentioned that Martita May was working as a clerk when you started as court administrator. How long did Martita stay at the court after you started as court administrator?
Miss May left. She only stayed about 3 weeks. She left about mid-November.
Did she give notice?
No.
How did you come to know that she was leaving her position?
She had gone to lunch and she hadn't come back, and I thought it was odd, and so I tried to reach out to her, and then I received an email from her saying that she was resigning effective immediately.
Okay. And Amber Dodge was also employed at the court.
I'm sorry.
Sorry, I heard something, but I wasn't sure where it came from. I'll just keep going. How long did Amber Dodge stay with the court after you became court administrator?
Amber Dodge left mid-December.
Okay.
I'd ask Ms. Johnson. I'd ask Ms. Johnson to speak up. I'm having a hard time hearing her.
Yeah, I agree. Ms. Johnson, if you can speak more closely to your microphone, it does appear that you're sounding more quiet than you did prior to the break.
Okay, hang on 1 second. Is that better?
It is. Thank you.
Okay, you're welcome.
Great. Where was your office as court administrator located in the court?
It was on the first floor in the far back corner.
Of the clerk's, like within the clerk's office?
Within the clerk's office, yeah.
Okay. And from your vantage point there, could you see and hear what went on in the clerk's office?
Yes, I could.
I want to ask you about an episode, whether you recall an episode involving Amber Dodge and Judge Flood that I believe may have happened before you were officially in your position as court administrator. But do you recall an episode with Amber Dodge and Judge Flood where Latricia Kinlow was also present in the office?
I do, yes.
Okay. What time of day was it?
It was in the early morning.
And who else was in the? Do you remember being in the clerk's office that morning, and you're in the court administrator's office?
I was. Yes.
And were you officially in your position as court administrator at that time?
I was, yeah.
But was Ms. Kinlow also in the office at that time?
Yes, she was.
Why was Ms. Kinlow, just briefly, why was she at the court that day?
I needed some help on some process. I can't remember what I needed, but I needed her help, and she had come out to Bremerton.
Okay. And so do you recall there being anybody else in the clerk's office besides yourself and Ms. Kinlow and Amber?
That morning, no, it was just the three of us.
Okay. And did you know where Judge Flood was that morning?
I had heard her go upstairs to the courtroom. So as far as I knew, she was in the courtroom.
Okay. And did Judge Flood come downstairs at some point?
She did.
What do you recall of Judge Flood coming downstairs? What did you observe then?
I was downstairs in the clerk's office, and I was standing in the doorway of my office, and Trish and Miss Kinlow and Miss Dodge were standing over by Miss Dodge's desk area, and Miss Kinlow was showing her something, and Judge Flood came down the stairs and in the doorway of the clerk's office screamed in the direction of Miss Kinlow and Miss Dodge and said, "Will someone please let me in the Zoom room? I have been waiting for 10 minutes." And
What did you do? What was your reaction when you heard this?
I froze.
Did you say that again?
I froze. I just froze. I think I couldn't respond. And I couldn't move.
Could you see what Amber was doing?
Amber, she said, I'm sorry, Your Honor. I'm sorry, Your Honor. Miss Campbell was showing me something on the computer. I'll get you in right now.
Hearsay. Objection, hearsay.
I'm gonna overrule it with respect to the first thing that the witness said about what was said, because I don't believe that goes to the truth of the matter, but I am sustaining it as to the remainder of what she appeared to be saying. Ms. Rasnick, perhaps you can ask the question in a way that makes it clear you're not soliciting hearsay.
Sure. What was your observation of Ms. Dodge, of Amber's demeanor when she said these things?
She was frightened. She was scared. She was very panicky and very apologetic to the judge.
And was Ms. Kinlow there as well?
Yes.
And could you also see Ms. Kinlow?
Yes.
And do you recall what Ms. Kinlow's demeanor was while this was going on?
She stood there looking at Judge Flood and just told her she would.
Objection, hearsay.
Let's just concentrate on what you observed of Ms. Kinlow's demeanor.
She looked at Judge Flood and just, and I don't.
Okay. Was this an episode that was, well, let me ask that a different way. Was this the first time you had seen Judge Flood behave in this manner?
Yes, it was.
In your experience working in courts, had you ever seen a judge behave in this manner towards a court staff?
No.
And from your demeanor, just speaking, you seem upset. Are you upset in recalling this incident?
Yes, I am. Yes.
Why is it upsetting for you to recall the incident?
Objection, relevance.
Overruled.
I've never, in my 30+ years of working in the judicial system, ever experienced anything like that. You said, scream at someone like that.
And once the episode was over, what did the judge do?
turned and just looked at me and very upset.
Did
And
she
looking
stay?
at
Oh, sorry, go ahead. I'm sorry. Finish.
she just stared at me and then turned around, walked away.
Could you tell whether she went back upstairs to in the direction of the courtroom?
I heard her go upstairs. She was stomping upstairs.
Did you see what Amber did after the judge went back upstairs?
Amber was crying. Amber was upset.
Could you see what Trish did after the judge went back upstairs?
Miss Kinlow was consoling her.
Okay. Did Amber work the rest of that day, as far as you know?
Yeah,
And did Miss Kinlow stay at the court for the rest of that day as well?
she did.
Okay. Did you notice any changes in the judge's behavior in the days following that incident?
I did.
What did you notice?
She was being very nice to us. She was being very nice to me and Amber.
And was there anything particular she did that you interpreted as being nice?
She brought some treats or something.
Did she ever apologize to you for that incident?
No. No.
Do you recall an incident in this will be January 2023 involving the judge and Ian Cohen?
Yes, I do.
And did this incident that you're recalling, did it happen in the clerk's office or in a courtroom, or where did it happen?
It happened in the courtroom.
And were you in the courtroom?
I was in the courtroom.
How did you come to be in the courtroom?
Judge Flood called me and asked me to come up to the courtroom.
So what did you find when you went up to the courtroom?
When I walked into the courtroom, Mr. Cohen was standing at one of the counsel tables. And she turned to me and said, "Okay, good. You're here. Now I have a witness so that he knows that I'm not screaming at him."
Was it just yourself and Judge Flood and Mr. Cohen in the courtroom?
I don't think so. I can't remember who else was in there.
Okay. After she made the remark about a witness, then what happened?
She started to talk to Mr. Cohen, but it wasn't like a nice conversation.
What was she talking to Mr. Cohen about?
She was talking to Mr. Cohen about a person that he was trying to help get set up with EHM.
And EHM is electronic home monitoring?
Yes.
And okay. So what do you recall of her talking to Mr. Cohen about getting the person set up with EHM?
She was telling him she was upset with him that he was helping this person because it was outside of Bremerton and that he shouldn't have been doing that. But she was talking to him in a manner that was very belittling.
And how you received it as belittling? This is the way what you thought to yourself as you were hearing this?
I did, yes.
And could you observe Mr. Cohen's reaction to the judge speaking to him?
I did, I could, yes.
And what did you observe of Mr. Cohen's reaction?
Mr. Cohen just stood there, and he just looked like he was just kind of shrinking and just kind of sulking as she continued to her conversation with him.
Did he try to speak back to her? I'm not asking you to relay what he said, but did he try to speak back to her?
He did.
And how did she receive it when he tried to speak back to her?
She spoke over him. She spoke over him.
Do you recall how this incident concluded?
She told him he was done and not to do it again. And she dismissed him from the courtroom.
And did he leave?
He did.
Was the way that Judge Flood addressed Mr. Cohen, how did that square with the way you had heard judicial officers address court staff in the past?
As she was talking to, I've never experienced a judge talking to a staff member like that. I didn't want to be there because what I was witnessing. No, she wasn't screaming at him, but at the same time, she was belittling this person.
Let me ask you about another incident in January 2023. If you recall, another incident in January 2023 that involved Stephen DeRozier, who I think you said was the therapeutic courts coordinator. Do you recall an incident between Mr. DeRozier and the judge in January 2023?
I do.
Do you remember where the incident occurred in the courthouse?
It was in the clerk's office by his desk.
So he had a desk in the clerk's office where you also were located.
Yes.
And you were able to observe this incident between Mr. DeRozier and the judge?
Yes.
What did you observe? Did the judge say anything to Mr. DeRozier?
Yes.
What did the judge say to Mr. DeRozier?
They were discussing some things about the therapeutic court. Stephen had put together some processes and manuals, or had put something together, and he was trying to talk to Judge Flood about it.
And let me just pause for 1 second. Did you have an understanding of what Mr. DeRozier's job was as the therapeutic court coordinator? Just asking if you had an understanding of it.
Yes.
And was it part of his job to put together manuals and processes for therapeutic court?
Yes.
And was he the first therapeutic court coordinator the court had, as far as you knew?
As far as I knew, yes.
So what you were observing then, you were just saying he was communicating with the judge about something that he had put together.
Yes,
for
that
his
he had been
job.
working on. Yes.
And what was the judge's reaction to this?
She said it wasn't what she had asked for. She was very short with him. He tried to clarify, and she just cut him off and wouldn't let him finish. And I could see by his body language and his expression on his face, he was just disappointed.
Let me ask you about a couple more, if you recall, a couple more incidents. At some point, was there an employee at Bremerton Municipal Court named Serena Daigle?
Yes.
Was Ms. Daigle someone who you had worked with before she came to Bremerton Municipal Court?
Yes, she was.
Did Ms. Daigle also start assisting the court through the Courts Helping Courts program?
Yes.
And did Ms. Daigle at some point then get hired for a permanent position at the court?
Yes.
Were you involved in her hiring?
Yes.
And was Judge Flood also involved in Ms. Daigle's hiring?
Yes.
Okay. What was Ms. Daigle's position when she was hired?
It was a senior tech position.
Okay, a senior legal technician position?
Yes.
Okay. Was Ms. Daigle, did she have to cover the courtroom sometimes?
Yes, she did. She covered the courtroom a lot.
Okay. I'm asking about if you recall an incident around the beginning of February 2023 between the judge and Ms. Daigle. Do you recall an incident around that date?
I do.
Where did this incident happen?
Down in the clerk's office.
Was Serena in the clerk's office?
Yes, she was.
And were you in the clerk's office as well?
Yes, I was.
And what did you observe? Well, let me ask, was the judge also in the clerk's office?
At the initially, no, but she came downstairs to the clerk's office.
Okay. Can you describe what you saw after once the judge came down and was in the clerk's office?
She had come into my office to talk to me about something, and then was leaving my office, and I heard her ask Serena if she had given a defendant his hearing notice, because this person was standing out in the lobby area and she could see him.
And did Ms. Daigle respond?
Yes, she did.
And what happened after Ms. Daigle responded?
Judge Flood stopped and looked at Ms. Daigle and asked her again if she had given this defendant his hearing notice, and Ms. Daigle said, "Yes, Your Honor."
And had she responded, was this the same way that Ms. Daigle had responded the first time the judge asked the question?
Yes.
And did the judge leave it at that, or did the exchange go on?
No.
What did the judge do after Ms. Daigle responded yes for the second time?
The judge just stopped and looked at her and said, "You did." And Serena said, "Yes, Your Honor, I did." And she just stared at her.
What did you what did you make of the fact that the judge asked the question of Serena several times?
She didn't believe her.
And what was Serena's reaction that you could observe during this exchange?
I could see Serena directly from my office, and she was frozen. You could see the expression on her face. And she turned, and so I could feel, I could not see the judge, and I was sitting at my desk. I could feel the tension that was happening at that moment, and it was dead silent. in the clerk's office. And everyone, all the staff was there. That's how intense that moment was. And it felt like an eternity.
Okay, I want to ask you about another incident in February 2023 involving Brian Knowles. Was Brian Knowles someone who was also an employee of the court?
Yes.
What was his position?
He was a legal tech.
Okay. And is he someone who started working at the court after you came on board as court administrator?
Yes.
Let's see. And do you remember the incident I'm referring to?
Yes.
Where were you when this incident happened?
I was in my office.
And where was Mr. Knowles?
He was in my office. Judge Flood had asked me to come into, have him come into my office because she had walked into my office.
So you and Mr. Knowles and the judge were all in your office.
Yes.
And what happened once you were all three in your office?
Judge Flood asked Mr. Knowles why he had not had Pro Tem Armstrong fill out, or why he hadn't had Pro Tem Armstrong fill out the judgment and sentence on a few cases. And Brian started to get up and she snapped at him and said, "Sit down."
Was there anything, could you see Brian's demeanor when he started to get up?
I could.
Did he seem angry? Did he seem like he was going to storm out?
No, he was going to go try and.
Objection, personal knowledge.
Did you have an understanding of, based on your observation of Mr. Knowles, of what you thought he intended to do?
Yes.
Did he seem angry?
No.
And so that you said the judge snapped at him, and did she say anything to him?
Yes.
What did she say to him?
After she told him to sit down, she started to yell at him as to why he had not loaded or done the JNS and why he hadn't filled that out.
Did Mr. Knowles get an opportunity to explain himself? I'm not asking you what he said, but just if he had an opportunity to explain himself.
He tried to explain. He said, he tried to explain and she cut him off. And then she started to scream at him. She started to scream at him as it was his job to make sure that those orders needed to be done. And she was screaming at him while he was sitting there.
Could you see Mr. Knowles while the judge was screaming at him?
I could.
And what was your observation of Mr. Knowles? A look on his face, his demeanor?
He just sat there. He just was just looking directly at her. He wouldn't look away. He seemed very nervous.
And how did the exchange end between the judge and Mr. Knowles?
She told him to go take care of the judgment and sentence and work with Pro Tem Armstrong. And then he opened the door and exited my office.
Did the judge do anything then?
She looked at me and said, "Are you okay?" And then I said, "No, I'm not." And she walked out of my office. And then about 20 or so seconds later, she turned back around and came back in my office. And she said, "Well, that was a teaching moment." And I said, "That was not a teaching moment."
Objection, hearsay.
Overruled.
What was your demeanor at the time? You were tearing up while you were saying this. Were you also?
I was really upset. I was very upset. I was shaking. I told her, I said, "That is not a teaching moment. It was not a teaching moment at all."
What did she do after you said this?
I said, "You can't speak to people like that."
Hearsay. Objection, hearsay.
And what did she do?
I'm sorry, Ms. Rod.
I apologize.
I'm overruling the objection.
What did the judge do when you said that to her?
He said, "I'm leaving." I said, "I'm leaving. You can't talk. I'm leaving for vacation. You can't talk to people like that." And she said, "I know, I know." And she put her hands up. I said, "I know, I know."
And are you describing when you're making that gesture, are you describing what you saw the judge doing at the time?
Yes.
And you mentioned your vacation. This was February 2023. Did you have a vacation coming up in February 2023?
I did.
Was this a vacation that you had told the judge about before this incident happened with Mr. Knowles?
I did, yes.
How long did you plan to be away?
3 weeks.
How did the exchange conclude with Judge Flood? This exchange that we were just talking about that involved Mr. Knowles. How did it conclude that day?
I was crying. I was telling her, I was like, you can't do this." And she came and she
I'm sorry, Mr. Gross, I cannot hear you. Were you objecting again?
Yes, hearsay.
Okay, overruled.
And then what happened after that?
she came around the side of my desk, and I had gotten up to go get a tissue because I was so upset. I was crying. And she goes, "I'm sorry." And she put her she came to hug me. And I just froze. I just froze. And I pushed her away.
Okay. And then what happened after the judge tried to hug you and you pushed her away?
I told her, I said, "You have to be nice. And you have to be nice to Serena. I'm leaving on vacation."
Overruled.
Okay. Let me move on from that. In your experience, did Judge Flood's behavior towards staff have an impact on hiring and retaining staff?
Yes, it did.
How so?
Um, so um, the clerks that were helping us, we started to, when they were helping us in October and November, she was having them fill out the orders, and that's not what these clerks would do at their other courts. And
Objection, personal knowledge.
Did you have an understanding of whether or not these remote clerks had been asked to fill out orders at the clerks where they worked full time?
I'm sorry, can you say that one more time?
Sure. Did you have an understanding of whether these remote clerks were expected to fill out orders at their regular jobs?
I did.
And what was that understanding?
Objection calls for something that she doesn't have personal knowledge of and or is hearsay.
Overruled.
So one of my clerks specifically had been helping also remotely, and I know my previous judge in working at Des Moines would not have the clerks fill out the orders, especially like judgment and sentence and things like that. She would have the clerks review them to make sure everything looked good, but she wouldn't have them fill out the orders. And the same was with other courts.
And your testimony was that Judge Flood expected the remote clerks or expected clerks to complete these judgment and sentence orders. Is that right?
Yes.
And did that have an impact on your ability to hire and retain staff?
Yes.
What was the impact that it had?
The impact was the remote clerks did not want to fill those out. And so they
Objection, personal knowledge before hearsay.
Right. Go ahead, Ms. Johnson.
They did not want to fill out the orders. And so we started losing the remote clerk for help.
Okay. Let's see. Let me ask about a couple of additional things. In the first month or so after you were hired as court administrator, were you working a regular 8-hour day?
When I first started?
Yes.
Not really.
Were you working more than 8 hours, less than 8 hours?
More than 8 hours.
Well, what time would you usually get to the courthouse in the morning?
About 6:30.
And what time did you typically leave?
4:45.
Did you ever have to stay past 5?
Oh yeah. Yes.
And during these first couple months, were you just doing the court administrator tasks, or did you also have to do other types of tasks at the court?
I had to do clerical work.
Did you have to assist people at the counter?
I had to assist people at the counter. I had to answer the phones. I had to do regular duties of a clerk.
And this was in addition to the court administrator tasks?
Yes.
Did the judge ever express any displeasure to you because if you wanted to leave at 5 o'clock?
At that time?
Ever?
She did in sometime around April.
Mm-hmm. Anytime before April?
I don't recall.
Did the judge contact you after hours?
Yes.
Did she contact you before hours?
Yes,
How about on the weekends?
yes.
And was she contacting you by phone, by text? How was she contacting you?
Either by phone or by text.
And were you expected to respond?
Yes. I actually had to tell her that I don't respond to text from
Objection,
8,
hearsay.
Overruled.
Go ahead.
from 8 p.m. till 6 because I needed to sleep.
Do you recall an incident? I'm thinking now about an incident between yourself and Judge Flood in December of 2022 that had to do with the cancellation of a review hearing.
Yes,
Um, were you both in the courthouse at that time?
we were in her office.
And was it during the court day?
No, it was after.
Okay. And what were you doing in the judge's office after hours on that day?
We were discussing and going over just different things. We usually would have like a check-in to discuss anything coming up.
Did the judge give you any instruction during this meeting?
She had brought up about a case that was scheduled for review in a couple days, and she had told me to cancel the hearing.
Did she tell you why she wanted the hearing canceled?
No, and I asked her why.
Did she respond to you?
She did.
What did she say?
She said it doesn't need to be said. It doesn't need to be heard.
And did you cancel it?
I did, but I asked her
Did you
more.
did you do
Non-responsive.
Ms. Rasnick, you want to ask another question?
Sure. Did you do anything prior to canceling the hearing?
I asked her if we could look
Objection,
the case up.
non-responsive.
Yes, I did.
Did you have any concerns about canceling the hearing?
I did.
Did you do anything to act on those concerns?
I did.
What did you do?
I asked her if we could look the case up on GIS.
And did you look the case up on JIS?
Yes, we did look the case up on GIS.
And what did you learn after you looked the case up on JIS?
That the case had been set about a year previously.
So the review hearing had been set about a year previously?
Yes. And there was a docket note that stated it needed to be heard by the next incoming judge.
Because the hearing would have been set when the previous judge was on the bench. Is that right?
Correct.
Okay. So you canceled the hearing. And was there any what did anything else happen with regard to the cancellation of this hearing after that afternoon?
Yeah, yes.
What was the next thing that happened?
The next day, Mr. Cohen came into my office and asked me.
Go ahead.
And asked me why I can't.
Did you have a discussion with Mr. Cohen about the hearing?
Yes, I did.
Did you tell Mr. Cohen why the hearing had been canceled?
Yes, I did.
What did you tell Mr. Cohen?
I told Mr.
Objection,
Cohen
calls
that
for hearsay.
Overruled.
What did you tell Mr. Cohen?
I told Mr. Cohen that Judge Flood had directed me to cancel the hearing.
Did anyone else ask you about the cancellation of that hearing? I'm not asking you what they said. Did anybody else ask you about it?
Yes.
Who else asked you about it?
Mr. Hersey, the city prosecutor.
And did you respond to Mr. Hersey similarly to the way you had responded to Mr. Cohen?
Yes, I did.
Do you know whether the defendant whose hearing we're talking about actually appeared for that hearing?
I don't
Okay.
recall.
Okay. Was there any further discussion between you and the judge about that hearing?
Yes.
When did that discussion take place?
About a few days later, about a week later.
And did the judge contact you, or did you contact the judge? How did this come up?
The judge contacted me.
Did you have an understanding from that conversation of why the judge had contacted you?
Yes.
What was your understanding of why she contacted you?
She wanted to know about me canceling the hearing.
Okay. Did she ask you why you would cancel the hearing?
She did ask me that.
And did you respond to her?
I did.
And how did you respond to her?
I said, you directed me to cancel the hearing, Judge.
Objection.
And sorry, Your Honor, I didn't hear that.
The objection was hearsay and it was overruled.
Did the conversation continue after you responded to the judge?
Yes.
What was the judge's response to you?
She said, no, you canceled the hearing. I said, no, I said, Judge, at your direction. And then there was a long pause.
What happened after the long pause?
I then said, is there something wrong?
And did she respond to you about whether something was wrong?
She did.
How did she respond?
She said the prosecutor was making a fuss about it.
And how did that conversation end?
I said, I don't know what you want me to do. I said, but I did not. You directed me to cancel that hearing. And she said, I'll take care of it. Because I asked, do you need something from me?
Objection. Hearsay. Overruled.
And she just hung up.
Were there other incidents where the judge asked you to cancel hearings, and you canceled them at her instruction?
No, that was the only one.
Okay. All right. In January of 2023, was there some sort of a staff retreat?
Yes.
Did you attend the staff retreat?
Yes.
Did you have an understanding of the purpose for the staff retreat?
It was, yes.
What was your understanding of the purpose?
We were in the process of having all new staff team, and she wanted to get together with the entire staff and work on like how things would be moving forward.
Was there any kind of improvement in the atmosphere in the workplace after the retreat?
After the retreat initially, yes.
About how long did that last?
About maybe a week.
We were talking a couple minutes ago about your vacation in February and March of 2023. Did you get to take that vacation?
I did.
And when you returned from the vacation, how were things with the court when you returned? Did you return to problems to solve?
When I returned to the court, there was a surprise that I was there, that I came back.
What was the surprise?
It just seemed people were surprised that I came back.
Oh, they were surprised that you came back.
Yeah.
How were things at
Objection, personal knowledge.
what are you basing that on, Jennifer? That your sense that people were surprised that you came back?
Your Honor, I'd ask the court to rule on my objection.
The objection, as I understand it, was personal knowledge. The question was related to whether people were surprised. Ms. Rasnick, why don't you ask a question in a way that allows us to understand what the foundation of the question is, and then I can rule on the objection.
Sure. When you got back from vacation, did you communicate with your colleagues at all about getting back?
Yes.
And based on your communications with them, did you form an impression of how they reacted to your coming back from vacation?
Yes.
What was your conclusion about their reaction to your coming back from vacation?
They were very happy that I came back.
Foundation, personal knowledge.
I'm going to overrule the objection. I'm overruling the objection with respect to foundation and personal knowledge, but I am concerned about the foundation being rooted in hearsay. So, Ms. Rasnick, if you can clarify that the basis of the knowledge is not hearsay statements.
Okay. Jennifer, are you basing your testimony on what you observed of your colleagues?
Yes.
Your observations of their reactions to you coming back from vacation?
Yes.
Had there been any changes in court personnel during your vacation?
Yes.
What changes had there been in court personnel?
Christina Miss Roundhorst was interim court administrator while I was gone. And Miss Daigle was out on medical leave.
So when you left for vacation, was Ms. Daigle what was Ms. Daigle's position when you left for vacation?
When I left for vacation, she was going to be interim court administrator.
And was this something you understood when Ms. Daigle was hired as a legal technician, that the plan was for her to become interim court administrator?
When I came on board, no.
When did you develop? I mean, is that correct that it was an expectation that Ms. Daigle was going to become interim court administrator?
When we
personal knowledge.
The objection.
Expectation of. I'm sorry.
What is your objection, Mr. Gross?
Your objection, Mr. Gross. The question is, as I understand it, was there an expectation? And I'm saying that's vague. We don't know who expectation to first.
Ms. Rasnick, can you repeat your question?
Sure. Jennifer, when you left for vacation, did you have an expectation that Ms. Daigle was going to be interim court administrator?
Yes. Yes.
Was there a timeline that you understood that she was supposed to become interim court administrator?
Yes.
What was the timeline?
So we had, Judge Flood and I had filled out a PPAF form for her to be interim from like a day or two before I left through when I came back.
So were you surprised when you came back that Ms. Daigle was not interim court administrator?
Yes.
Okay. Did Judge Flood ever convey to you that you were expected to do competency evaluations for therapeutic court participants?
Can you repeat that again?
Sure. Did Judge Flood ever convey to you that you were expected to do competency evaluations for therapeutic court participants?
No.
Did anyone else ever convey the expectation to you that you were supposed to do those evaluations?
No.
Okay. Who was supposed to do competency evaluations for the therapeutic courts participants?
Well, that was supposed to be Mr. Cohen, because he was probation, if there was any type of evaluations or treatment agencies that they would refer them to.
And once Mr. Cohen left, whose responsibility was it then?
We didn't have anybody.
Do you recall a community court coordinator being hired?
A community court coordinator. Being hired? No.
Okay. Let me ask you about something a little different. Was it your task as court administrator to approve staff's requests, for example, for leave or for remote work, those kind of condition-related requests?
Yes.
Did you consistently get to approve those requests during your tenure as court administrator?
At Bremerton?
Yes.
Initially, yes.
And then did it change at some point?
It did.
Do you recall about when it changed?
It changed, probably it changed not too soon after I came back in March.
Are you talking about coming back from vacation?
Mm-hmm.
What was the change after you got back from vacation?
Mr. Brian, I can't recall his last name, had requested to take some time off at the
Objection,
end.
Hersey.
If you I'll just ask a more focused question. What was the change? What changed about how the leave requests and such were handled after you got back from vacation?
It would go to staff would go to Judge Flood and then would come and tell me this is their time that they're taking off.
So you were not involved in approving the requests for leave?
Correct.
Did that create any challenges for you in your role as court administrator?
It did.
What were the challenges it created?
And the challenges it created was sometimes there wouldn't be any staff.
Was the judge also approving requests for remote work?
Yes.
And were you looped into those requests?
No.
Did you ever raise this concern with the judge that she was not looping you into her decision about staff requests for leave and remote work?
I did.
What was the judge's response?
She didn't really have a response. I said to her, I said, you need to
Objection, Hersey.
Okay. How did you convey, how do you recall conveying your concern to the judge?
I told her my concern of the impact that it was having in the fact that we didn't have staff.
Action, Hersey.
And your testimony is that she had no response to this.
Correct.
I objected on hearsay. I didn't hear a ruling.
Ms. Rasnick, were you waiting for did you move on? What were you?
I moved on. I'm sorry. The windows have rearranged on my Zoom screen and I could not see the presiding officer. So I just moved on. I apologize.
Okay, the question was moved on from.
Oh, there you are. Okay. Jennifer, did you receive a performance review from the judge at some point after you got back from vacation in spring 2023?
Yes.
Would that have been around April 2023?
Yes.
And do you recall when this performance evaluation happened, or performance review? Sorry.
Yes, I do.
Were you at the courthouse?
I was in my office.
When did you learn that you would be having a performance review?
I learned that morning that I was going to be having a review.
How did you learn you would be having a performance review?
Judge Flood walked into my office and said, "We're going to be doing your 6-month review today."
Did she say what time that day it would be happening?
And yes.
What time did she tell you it would be happening?
She said it would be, I actually asked her what time.
Objection, hearsay.
How did she respond? I'm sorry, I'm moving on. What time was your review supposed to happen?
4:30.
Did it happen at 4:30?
No.
Did you go to meet with the judge at 4:30?
Yes.
What time did the review start?
5 p.m.
And about how long did the review take?
2 hours.
Do you recall the judge conveying some information to you or making some statements to you during that review?
I do.
What do you recall the judge conveying to you?
We discussed about processes and procedures on some of the things that were happening in the court.
Did you discuss whether the judge was satisfied with your performance?
We did.
Do you recall anything specific that she said to you along those lines?
She discussed trust issues, and I said trust is a two-way street, and that we weren't, she felt, we weren't working well together in regards to communication.
Did you express concerns to the judge about the quality of your working relationship with her?
I did.
This was in April of 2023?
It was.
Did you at some point decide that you were going to leave your position at Bremerton Municipal Court?
I did.
Were there any particular incidents that led you to make the decision to leave?
Yes.
Could you describe those incidents, please?
So when when I had my performance evaluation with Judge Flood, we walked away from that meeting of doing a rebuilding our relationship, our communication.
And did that, what did that mean to you when you say doing a rebuild? What was that supposed to look like?
Rebuilding trust, talking to each other, working together, not being left out of, the loop, especially when it came to staff, working together.
So this was your understanding after the two of you had the performance evaluation meeting in April?
Yes.
So when you made the decision that you were going to leave, was that related to how the rebuilding had been implemented?
Sorry, can you ask that again?
Sure. When you made the decision to leave, was that connected to the understanding you had at the end of the performance evaluation?
Yes.
And how was it connected to that?
About after our meeting, about a week later, I had a staff member come in and she had approved for them to work remotely.
Who had approved for them to work remotely?
Judge Flood.
Had the judge discussed this with you before approving the remote work?
No.
Did you bring that to the judge's attention when you
I
heard
did.
it from the staff member?
I did.
Did the judge confirm that she had approved the remote work?
She did.
Were there other instances happening during this period after the performance review meeting that the judge was continuing to approve remote work requests?
Yes.
Was she also continuing to approve scheduling requests?
Yes.
And were these incidents significant in your decision to leave your position?
Yes.
Why were those the significant incidents?
Because we never had the discussion in regards to approving the staff, and it was to the point where there was no staff for 3 days. It was just myself and 2 other management people, because the staff that needed to actually be working the front counter, she had approved for them to work remotely.
And did you have a change in the way that you reacted to this?
Yes.
What was the change?
She wasn't gonna work with me.
Objection,
The objection is non-responsive. Is that what the objection was?
Yes.
Ms. Resnick, what was the question?
What was the change? What was the change in Ms. Johnson?
And she talked about the judge not wanting to work with her. It's not responsive.
Why don't you re-ask the question, Ms. Resnick?
Sure. Was there a change in?
Hang on a second. I'm not sustaining or overruling the objection. I don't know that we were far enough into the answer to get a tie to the question. So let's just ask the question again and we'll see.
Okay. Did the judge's handling of these remote work and scheduling requests, did it change what you thought about her commitment to working with you?
Yes.
What was the change in your thought about her commitment?
Her commitment wasn't going to be there.
And did you at some point begin looking for a new position?
I did.
Did you begin looking for a new position before you resigned from Bremerton?
I did.
And did you find at that time the new position that you have at AOC?
I did.
Let me just briefly share one more document. Can you see the document I'm sharing, Jennifer?
Yes.
Okay, let me scroll to the end. I'm sharing what's been identified as Disciplinary Counsel's Exhibit 231. Ms. Johnson, is this your the letter of resignation that you sent to the city of Bremerton?
Yes.
That's your signature at the end?
Yes.
Okay. And it's dated May 26, 2023?
Yes.
Disciplinary Counsel offers Exhibit 231.
Exhibit 231 has been offered, Mr. Gross.
I object. This is filled with hearsay.
Response.
We're simply offering it to confirm that she did in fact resign on this date.
That's already been established.
Yeah, I'm going to sustain the objection.
Okay.
Exhibit 231 shall not be admitted. Is it 231? 231 shall not be admitted.
All right. Let me take that down for a sec. Jennifer, was your working relationship with Judge Flood a significant factor in your decision to resign?
Yes.
Was your experience with the judge's treatment of you as court administrator, was it similar to the way you had been treated as court administrator by previous judges?
No.
In your previous court administrator positions, did the judge approve time off and remote work requests?
No, not unless I was out on some type of leave.
Did you resign in part because you felt Judge Flood was micromanaging you in your role as court administrator?
Yes.
Did the judge's demeanor towards you factor into your decision to leave your job?
Yes.
Did what you observed of the judge's treatment of other staff figure into your decision to leave your job?
Yes.
Right. I don't have anything further on direct.
Thank you, Ms. Rasnick. Mr. Gross, will you be conducting the cross-examination?
Yes.
All right, you may proceed.
Ms. Johnson, hello. If you don't hear a question I ask, will you please let me know that?
Okay.
Before you were hired at Burn Municipal Court, you worked at Des Moines Municipal Court.
Yes.
And for the prior 5 to 6 years, roughly, you worked under Judge Lisa Leone.
Yes.
Judge Leone is white.
Yes.
And Judge Leone is a very
I'm sorry, I didn't hear you.
Mr. Gross, you appear frozen. Ms. Bremner, you appear not frozen.
Brains?
Your Honor, Mr. Gross is frozen. Oh, we're all frozen.
Ms. Bremner is not frozen.
I'm not sure, Your Honor. I cannot hear you at this time, but Mr. Gross is frozen, so I'm not sure if you can hear me.
I can hear you. Ms. Bremner, can you try speaking? It looks like you're not muted.
We had it, we're back.
It appears we have Judge Flood and Ms. Bremner, but Mr. Gross remains frozen.
Yeah, I had to start at like 4 times.
I'm gonna use the chat, or if someone can, if anyone can tell me if you can hear me. I see movement with Counsel Rasnick, but we don't see anything else.
Judge Flood, we're able to hear.
Okay,
you.
you can hear me, yes.
We're
Oh,
able to
thank
hear
you.
Ms.
We
Bremner.
can hear now. Sorry, we can hear you now. Okay.
And I have a suggestion. It is 11:46. Your Honor had suggested a half-hour lunch break. Perhaps we could take that earlier and still use a half hour unless there's a granted objection to that. And during that time, council can work on their connectivity.
Right.
Ms. Rasnick, any objection if we take an early lunch break here at 11:46?
No objection. I would just note that I have a hard stop at 5 o'clock today. But I think probably we all would, and I don't know how that would impact, but I don't have any objection to taking an early lunch.
Okay. So, Ms. Rasnick, when we do come back from lunch, I am going to ask about where you think you are in terms of the remainder of your witnesses. Obviously, this witness took some time, but I am interested in your thoughts on our progress. Ms. Bremner, any objection if we take an early lunch?
No, Your Honor, thank you.
Okay, and perhaps you all there can work on your technical difficulties. Obviously, we want to avoid those as much as we can. And Ms. Rasnick, I'd like to have you view the Weber and McKay declarations to see. I'm going to give you one more opportunity to argue prejudice with respect to the late disclosure of those declarations. And I do expect to make a ruling when we come back from lunch on your motion to exclude.
Your Honor, I did want to add one thing on that. And my understanding that those items were filed earlier in this case, and also have been, of course, part of the McKean case. The letter, excuse me. So it's been on file in this case, is my understanding. Of course, we're newer counsel, but that's my belief. So I just wanted to put that on the record.
I'm not sure what you mean. Is one of the declarations, does it enclose a letter that you're referring to?
Exactly, Your Honor.
All right. Well, in any event, we'll address that very briefly when we come back from lunch. At this point, let's take a recess of 30 minutes. Let's go 32 minutes. Let's come back at 12:20.
Thank you.
12:20, we'll be in recess. All right, the time is now 12:20. And we're prepared to resume. Just waiting for Commissioner Evans. Well, while we're awaiting Commissioner Evans, I don't believe that his presence is absolutely necessary here for the my consideration of disciplinary counsel's motion to
Go ahead.
strike the declaration of Weber and McKay. So, Ms. Rasnick, I was going to provide you an opportunity if you wanted to augment your argument with any additional arguments about prejudice for the late filings of the two declarations.
Sure. The letter that's attached to John McKay's declaration has been submitted as an attachment to some pleading in this case before. That is true. But there has not been any previous declaration from Mr. McKay. He hasn't been interviewed. Ms. Weber, the other declarant whose declaration was submitted late, did not respond to attempts to schedule an interview. So my position is to cure the prejudice from these being provided late. Both of these declarants should be made available for a telephone interview this evening. That is my position, that the prejudice could be cured, the prejudice associated with the late providing of the declarations, to determine whether or not disciplinary counsel would want to request cross-examination of those witnesses.
Ms. Bremner?
There I am.
Ms. Bremner? Can you hear me? Ms. Brenner, you don't appear to be muted. Can you hear me? Ms. Bremner, I can hear you. Can you hear me? Mr. Gross, can you hear me?
I can, yes.
Ms. Bremner, can you hear me? Well, maybe I'm confused as to why Ms. Bremner does not appear to hear me. Mr. Gross, are you in the same room with Ms. Bremner?
Go ahead without me. Shit.
And we can hear you.
Okay, well, who is going to respond to Ms. Rasnick's further comments on the motion to exclude the declarations?
I'm happy to, Your Honor.
Okay, please.
So I can't speak for these two individuals. I don't know their schedule, but I'm happy to attempt to facilitate interviews tonight.
Okay. Well, then I guess I'll reserve ruling on the motion to exclude until Ms. Rasnick has an opportunity to, well, actually, let me say this. The consideration that I would typically apply to this type of motion is comes from the Burnett factors. Perhaps the lawyers are familiar with the Burnett factors. Burnett versus Spokane Ambulance, 131 Wash 2nd, 484. And those three factors that the court must apply when deciding whether to exclude late information, late evidence, has three factors. First, whether a lesser sanction would suffice, whether the violation was willful or deliberate, and whether the violation substantially prejudices the opponent's ability to prepare for trial. Those are the three factors. Ms. Rasnick is offering that a potential lesser sanction would be to require the facilitation of telephone interviews with the declarants this evening. I'm in agreement with that, at least with respect to the declaration of Leslie Weber. That does appear to me to be I can understand disciplinary counsel's request to discuss with Ms. Weber her thoughts prior to making a decision on whether cross-examination would be something that would be requested. I am hesitant about the John McKay's declaration. The reason I say that is I'm not entirely sure the McKay declaration is all that relevant. I recognize that the letter has been submitted before in these proceedings, and certainly the panel is aware of it. But as I look at the Deming factors, I'm not entirely sure how the McKay declaration has any relevance to the consideration for the panel with respect to discipline from the admitted violations of the code that we have through the stipulation. I hesitate to have the parties spend any time and energy trying to interview Mr. McKay regarding his declaration when simply it attaches a letter that the panel understands and is familiar with, as well as his statements here that are, again, I'm having a hard time finding their relevance. Ms. Rasnick, what's your reaction to that observation that I have in terms of not requiring the facilitation of an interview with Mr. McKay? What do you hope to get from Mr. McKay? Actually, I guess is my question.
I also question the relevance of the McKay declaration, but to the extent that just seems reasonable to propose the same remedy to mitigate the potential prejudice as to both declarations. So I am not sure that I could get much more out of Mr. McKay because his declaration says that he doesn't have any familiarity with the investigation. But if Ms. Weber is going to be made available, then it would seem reasonable that Mr. McKay be made available as well. Just trying to be consistent.
Okay, well, I'm going to be inconsistent. I'm going to require the availability of Ms. Weber for the reasons that Ms. Rasnick has requested, but I'm not going to require that of Mr. McKay. At this point, I think that would be a waste of everybody's time. He has said under oath he doesn't have any information about the investigation. He's attaching a letter we're all familiar with. He does have his opinions about based on no familiarity with the investigation. I'm not inclined to strike the declaration, but I'm also not inclined to have anybody waste their time further probing it. Ms. Bremner, or Mr. Gross, your thoughts?
Well,
Go
ahead, Mr. Gross.
Whoever is going to respond on behalf of respondent, please give me your thoughts.
Okay, I've had to move to my phone to do this. Your Honor, I think that this, as I indicated before, that those letters were given to counsel in the course of this case sometime back through prior counsel. So, and like you said, he doesn't have anything of substance really in his declaration. And so as attachments, the letter and the response from the CJC should be considered.
Well, I'm not necessarily making that decision now, but I am making the decision that for the purposes of the motion to exclude based on late disclosure, Miss Weber will be made available as a lesser sanction. Mr. McKay need not be, and that'll be the ruling at this point.
All right, thank you.
Ms. Rasnick, if you have further motions after your discussions with Ms. Weber, we can deal with that then. I'd rather not delay things anymore. We were pausing for lunch, and now we're picking up with the cross-examination of the witness. Anything that we have to deal with before we get back into the cross-examination, Ms. Rasnick?
Don't believe so. Well, I would point out that we're about an hour behind where I'd hoped to be with getting through testimony today, and so it may be that I have to switch the orders of my witnesses, and will likely be taking Mr. Cohen and Ms. Kinlow after Ms. Johnson is finished, and I have to take Mr. Hersey this afternoon because of his schedule and his availability. I need to get him in this afternoon, so I would be potentially requesting some leave to take Ms. Rauenhorst in the morning. We don't have to talk about that right now, but it is important that we get in all of this witness testimony. We engaged in a lot of back and forth to try and narrow the witnesses to allow for a good cross-section of witnesses to be able to present evidence. This is an important fact-finding hearing. So I would just say I may be asking for a little bit of leave to take one witness tomorrow, but I think we should discuss that a little bit later in the afternoon.
Okay, seeing as though we don't have a controversy at this moment in time, let's proceed with the cross-examination. Unless, Mr. Gross, did you have anything unrelated to what Ms. Resnick just said that you want to raise?
Yes, I do.
Okay.
I want to just make a record. There are many occasions during Ms. Johnson's testimony where she's
Mr. Gross, you're breaking up. I can't hear you.
Mr. Gross is actually muted right now.
I don't.
No, it's not.
Can you hear me now?
Yes.
There have been many instances during Ms. Johnson's testimony where she's testified to her own out-of-court statements for the truth of the matter asserted, and even though Ms. Johnson is testifying to her own out-of-court statements, they are still inadmissible hearsay if they are offered for the truth of the matter asserted. So I think she's probably done that 15 times, if not more, and so I'm going to continue to object.
Well, Mr. Gross, you've made your record. With respect to the presiding officer's rulings in that regard, my impression at each of those instances was that the statements that she was testifying to were not related to the truth of the matter, but related to the context of the conversations with which Judge Flood's statements were, of course, not hearsay. And therefore, there was not factual assertions being made within those statements, but rather it was the context for the statements made by Judge Flood. That was the basis for the ruling. But you have made your record and I have made mine. Let's proceed with the cross-examination. Mr. Gross?
I'm ready.
Proceed.
Ms. Johnson, we only got a few questions in, so I'm just going to start over. Before you were hired at Bremerton Municipal Court, you were the court administrator in Des Moines Municipal Court.
Yes.
And for the prior 5 to 6 years, when you before you went to Bremerton, you were the court administrator for Judge Lisa Leon.
Yes.
Judge Leon is white.
Yes.
Judge Leon is a very even-keeled person.
Yes.
It takes a lot to get Judge Leon upset.
I'm sorry. Can you repeat that again?
Would you agree that it takes a lot to get Judge Leon upset?
Yes.
Yet for the few years before leaving for Bremerton Municipal Court, you butted heads with Judge Leon frequently.
No.
Ms. Johnson, I apologize, but I'm having a harder time hearing you now that we've come back from lunch than before. If you were once
Okay.
able to correct your volume, and if you could try that again, that would be useful. Thank you.
Okay, hang on one. Is that better? Or the same?
Sort of the same.
Let's see. Is that better? Can you hear me now?
Much better. Thank you.
Much better. Okay. Hang on, I can't hear you. There we go. Okay.
I'll ask my question again. My question, a few years before you left for Bremerton Municipal Court, you and Judge Leon butted heads frequently.
No.
No? You and Judge Leon many times disagreed about court decisions. Do you agree with that?
About court decisions? No.
You said you never seen a judge act in the manner that Flood did while you were at Bremerton Municipal Court. Is that true?
Yes.
Okay. Did you one time get in a shouting match with Judge Leon?
Yes.
And were there a number of occasions where there was a decision to be made about the court, and you said your piece about what you thought the decision should be. Judge Leon made a different decision, and you continued to argue with her about it.
No, I don't know what incident you're talking about.
Not a specific incident I'm talking about. There were a number of occasions that fit the description I just said.
Can you repeat the question again?
Yes. There were a number of times that there was a court decision to be made. You said your piece about what you thought the decision should be. Judge Leon disagreed and told you the decision would be different. And then you continued to argue with her even after that.
No.
No.
At some point, you talked to an attorney about potentially suing Des Moines Municipal Court and Judge Leon. Is that correct?
Yes.
You testified earlier that you did not give Judge Leon less than 2 weeks notice. How many days notice did you give Judge Leon?
Gave them 7 days.
And in your opinion, that wasn't a concern because you had done succession planning.
Correct.
Are you saying that Judge Leon did not have a problem with you giving only 7 days notice?
I'm sorry, can you say that again?
Did Judge Leon have a problem with you giving only 7 days notice?
No, because I explained to her why.
You said, you testified earlier that on a prior occasion you had worked for a judge of color, I think through Courts Helping. Is that what you said?
No.
You didn't testify that you had previously worked with a judge of color?
I previously testified that, yes, I had worked with a judge of color, but not through Courts Helping Courts.
Thank you for clarifying that. What judge was that?
That was Judge Raines, Judge Alicia Galvan, I worked with Judge St. Clair. And that was it. Those are the previous judges of color that I worked with.
You first came to Bremerton Municipal Court through Courts Helping Courts.
Yes.
Judge Leon had to agree to you going to help out Bremerton Municipal Court.
Yes.
And after she agreed to allow you to go help Bremerton, you left Des Moines for Bremerton.
Yes.
When you started at Bremerton, there were the employees that were still there were and actively working were Amber, Martitha, Cindy, and Luann. Correct?
I'm sorry. Did you say inactively?
And actively.
Inactively. Yes.
And you have no personal knowledge about why any of the previous staff had left.
No, I didn't.
You testified earlier about some of the court's needs when you got there, such as accounting and scheduling.
Yes.
But you knew when you were going over there that Bremerton Municipal Court needed help.
I didn't know ahead of time. I only knew when we were driving there because Miss Kinlow had reached out to me. But prior to that, no, I didn't know that.
So through Courts Helping Courts, you were into Bremerton, but you didn't know they needed help?
No, not until Ms. Kinlow had reached out to me.
But the reason that you and Ms. Kinlow were going to Bremerton Municipal Court was to help a court that was having functionality issues.
I'm sorry, so I didn't hear your question.
The reason you were going through helping courts to Bremerton was to help them with functionality issues they were having.
Yes, to go see what issues they were having and what the need for help was.
And accounting and scheduling are the types of things that a struggling court might need help with.
Yes, it could be. Yeah.
For the first 30 days that you were working and helping with Bremerton Municipal Court, you didn't see Judge Flood do a single thing that you thought was inappropriate.
Correct.
And your first 30 days assisting Bremerton Municipal Court was also Latricia Kinlow's first 30 days helping Bremerton Municipal Court.
Yes.
Okay. But according to you, after those 30 days, Judge Flood suddenly started to be regularly rude and condescending.
Yes.
But you saw no hint of that before those 30 days.
No.
And no one who worked at the court in those 30 days told you that they thought Judge Flood had done anything inappropriate.
No.
You testified earlier about how at some point shortly after you started, Judge Flood had an initial conference that she had planned to go to. Is that right?
I'm sorry, can you ask that question again? You cut out.
You testified earlier about a time shortly started that Judge Flood had told you about a scheduled judicial conference she was going to.
Yes.
That was actually a judicial college, right?
I believe so. Yes.
Judge Flood had fully covered her calendar for her planned absence with pro tems.
I believe so.
And Judge Flood ended up leaving the judicial college early to come back to help the court.
Yes.
Will you describe the job of a court administrator?
Sure. The duties of a court administrator involve day-to-day operations. They involve can be budgeting, accounting, accounting management, case flow management, overseeing court staff, overseeing implementation of policies and processes. Also maintaining financial accounting, which can range from accounting to end of the month, end of the year. Also provide work towards providing training for court staff, work with stakeholders, work with your judge to help also implement policies and procedures. Approve hiring, performance evaluations, approve leave requests, manage budget, give input of budget operations and budget recommendations, maintain the yearly annual budget, work with oversee working with probation, approving or not approving, paying bills, submitting bills to fiscal, approving and submitting payroll, or monitoring for auditing purposes, financial, especially at end of the month. There's certain reports that are generated, and you have to monitor and audit those reports. I think that roughly covers a court administrator position duties.
When a court has a new judge, do you feel it's part of the court administrator's job to train the judge?
Yes. Or to help them understand if you're the court administrator there, to explain the current processes.
Did you feel that's part of what you were doing as Bremerton's court administrator, was helping train Judge Flood?
I'm sorry, can you say that one more time?
Did you think that part of what you were doing as court administrator for Bremerton Municipal Court was train Judge Flood?
Was to train Judge Flood. I don't know if it to train, but to show her the processes and get her input on and give to make sure that we were getting the processes done.
Is it ultimately the judge's decision? I'm sorry, I interrupted. Please continue.
Nope, you're fine. Go ahead.
Is it ultimately the judge's decision what a court administrator does?
Yes.
Is it ultimately the judge's decision what all of her staff does?
Yes.
So when you talked about Judge Flood changing the process, for example, of approving leave requests, the judge didn't do anything improper.
Is that a question? I'm sorry.
Yes, it is.
Okay, I'm sorry. So can you ask your question again?
When the judge makes a decision such as changing the process for who approves leave requests, like in this case, when Judge Flood, according to you, changed the leave request process so that she would approve them.
Mm-hmm.
There's nothing improper about that.
If you, but she wasn't involving me in the process. And so I wasn't being told when people were being approved, and it had an impact on staff not being available. If I don't know when someone's going to be off, how am I supposed to be able to make sure that there's coverage if I'm not informed?
But you were on vacation, so you were not able to make leave requests when she changed that process.
Correct. Sorry, say that again.
When Judge Flood changed the leave request process, you were on vacation for 3 weeks and not able to approve leave requests.
Correct.
And even when Judge Flood approved leave requests, you still had to process them.
Yes, there was a form.
So you knew that those leave requests were approved.
No, I didn't.
What time does Bremerton Municipal Court start?
What time? Can you repeat that one more time?
What time does, all right, I want to ask about the in-custody calendar. What time does Bremerton Municipal Court's in-custody calendar start?
It changed a couple times. First it was 7, the actual calendar started, I think, at 8, and then it was changed to 7:45, but on certain days it kept changing.
You testified earlier about a few occasions when you heard Judge Flood talking to Ian Cohen, Stephen Rozier, and Serena Daigle in a manner that you thought was inappropriate, right?
Yes.
In none of those occasions did Judge Flood yell.
No.
I guess I want to be clear. Did she yell during any of those occasions?
To those 3 people?
In those 3 instances that you described in your direct testimony?
No.
I thought her tone was inappropriate.
For the 3 incidents or the 3
Yes.
people no, it wasn't her tone.
Her tone was not inappropriate?
It was more than her tone. It was more than that. So
My question was, you thought her tone was inappropriate.
I'm sorry, say that again.
My only question was whether you thought her tone was inappropriate during those 3 occasions.
Yes, but it was more than her tone.
Okay. You encouraged Serena Daigle to apply for the senior legal technician opening at Bremerton Municipal Court.
I did.
You and Serena were friends.
Yes, and we were coworkers.
At the time that she applied for that position, Bremerton Municipal Court's assistant court administrator was on leave.
Correct.
And before Ms. Daigle applied for that position, you told her that you expected the assistant court administrator to resign her position later that month.
Yes.
And you promised the assistant court administrator job when that happened.
I didn't promise. I had hoped she would be able to get that position.
You didn't tell her that she could expect to have that position when it opened up?
I couldn't make that. I mean, it would still have to go through Judge Flood.
Right, but Judge Flood didn't tell you that you could tell Serena that she could have that assistant court administrator job.
The assistant, no. I'm sorry, maybe I'm not understanding your question.
Question is, did Judge Flood tell you that you could tell Serena she could expect to have the assistant court administrator job when it opened?
No.
You described an incident involving interaction you saw between Serena Daigle and Judge Flood, right?
Yes.
And in describing that incident, you testified to different facial expressions that Judge Flood had.
I'm sorry, different what? I'm sorry.
Facial expressions.
Yes.
You were sitting in your office when that happened, right?
I'm sorry, can I back up for a second? In my previous testimony, I didn't say facial expression. I said I could hear.
Okay. Well, that's not. Okay. You went on a 3-week vacay within a few months of becoming the court administrator in Bremerton Municipal Court.
Yes.
A court that you knew to be struggling.
Yes. It was a pre-planned vacation.
You talked earlier about Judge Flood texting you outside of court hours. Is that true?
Yes.
Did you also text Judge Flood outside of court hours?
Yes, because she expected me to respond.
Did you initiate texts with Judge Flood outside of court hours?
Sometimes, yes, I would. I had council meetings that I had to go to.
Do you remember what month you hired counsel to pursue a civil claim for you against Bremerton Municipal Court in Bremerton City?
I'm going to object. That's mischaracterizing her prior testimony. And I'm also going to object to any question that would require her to discuss any interactions that she has had with counsel, any discussions that she has had with counsel on the grounds that that would implicate confidential attorney-client privileged communications.
Yeah, I don't hear the question yet that would implicate the attorney-client privilege, so we'll wait to see if that occurs. With respect to the mischaracterization of testimony, I'm not sure I picked up on the mischaracterization. Ms. Rasnick, what about the question was mischaracterized in your view?
Sure. Mr. Gross just stated that Ms. Johnson testified that she had engaged counsel to pursue a lawsuit against, I believe, her prior employer, and I don't think that was her prior testimony.
Mr. Gross?
I didn't say anything about this.
Mr. Gross, you are breaking up. I have been told by Mr. Cooper that if you continue to break up, you could try phoning in, and perhaps that would be a clearer connection. But you I got maybe 3 syllables of what you just said.
Happy to phone in, and I can do that at our next break, or whatever the court wants. What I said was, I didn't characterize any prior testimony. I simply asked if she hired counsel.
Okay.
I disagree. That is not what I heard. I heard an assumption that counsel had been hired, and he was attributing to her having hired counsel.
Okay, can you restate the question, Mr. Gross?
Sure. Ms. Johnson, what month did you hire counsel to pursue a civil claim against the municipal court?
I'm going to object lack of foundation.
I'll sustain that. You can set a foundation if you'd like, Mr. Gross.
Ms. Johnson, have you sued Bremerton Municipal Court in the city of Bremerton?
Have I filed a lawsuit? I'm
Correct.
sorry, can you? Yes,
Who is your attorney?
it's Miss Stephanie Stoker.
What month did you hire Ms. Stoker and/or her law firm?
I'm going to object that this intrudes into attorney-client privileged information.
I'll overrule that.
I think it was about mid to end of May.
Is that before or after you resigned?
That was a few days before I resigned.
Did Ms. Stoker or her law firm draft your resignation letter?
Yes, they did.
So you've had nearly a year and a half, correct?
I'm sorry, I did not hear your question.
You've had personal civil counsel for over a year and a half, or almost a year and a half?
Yes.
Are you aware of any recordings, audio or video, of Judge Flood saying or doing something inappropriate?
I'm sorry, say that again.
Are you aware of any recordings, audio or video, of Judge Flood doing something you consider inappropriate?
I mean, I would only know. I mean, I have my own recollection of a proceeding, and it's on an audio, but I don't. It's on the court's audio.
You've never listened to it or tried to find that?
I think I might have listened to it while I was there, but not since then.
In direct examination, you got an instance where Judge Flood asked you to cancel a review hearing, correct?
Yes. Mm-hmm. Yes.
Judge Flood didn't, and according to you, Judge Flood didn't tell you the reason for canceling the.
Correct.
Did Judge Flood in fact just reschedule the hearing?
No, I had in the meeting that we were in.
Yes.
No, she did not.
And just because Judge Flood didn't tell you a reason why she was canceling or rescheduling a review hearing, that doesn't mean she didn't have a reason.
I'm Sorry, what is your question?
Just because Judge Flood may not have told you the reason for canceling or rescheduling that review hearing, doesn't mean she didn't have a reason.
I guess maybe I don't understand your question. Can you clarify?
You can't say one way or the other. You can't say one way or the other what Flood had a reason for canceling that review hearing.
But she did tell me, she said it just didn't need to be heard. That's what she said.
You testified earlier that Ian Cohen was doing competency evaluations at the court.
I didn't testify to that earlier. Or Mr. Cohen was doing evals? Yes, I did testify to that.
So Mr. Cohen, who was a probation officer, was doing competency evaluations?
Oh, competency evaluations. No, Mr. Cohen was not doing competency evaluations. He was meeting with clients that Judge Flood was putting on probation. So no, I apologize. No, Mr. Cohen did not do competency evaluations.
You testified earlier something that you characterized as a performance review meeting, correct?
I'm sorry, Mr. Gross, can you repeat that again?
You testified earlier about something characterized as a performance review meeting, correct?
Yes.
You said that during that meeting, Judge Flood raised the issue of trust issues between the two of you.
Yes.
And you responded to her telling her trust is a two-way street.
Yes.
You had no problem talking to the judge like that.
We were discussing, we were discussing trust. And I said, trust is a two-way street. We both have to have trust in each other. And that we both felt like we had lost that trust. I said, that's a two-way street. We have, in order to have that relationship with the judge. And she agreed. And that's when she had proposed of doing a rebuild, of building trust and commitment.
And what was your response to Judge Flood talking about doing a rebuild between the two?
I asked her, I said, okay. So we're going to rebuild. We're going to have better communication. We're going to talk about things. We're not just going to do things on our, make decisions without talking to each other. And she said, yes. She says, let's work out a plan so that we can have, so we can meet to discuss any issues that may come up. Yes.
Did you mean those things genuinely?
Yes, I did.
But at that time, you had already filed a complaint with the CJC.
I'm going to object. That would be a confidential complaint. That would relate to a confidential portion of the proceeding.
Mr. Gross, response?
I believe it's in her declaration. I also would argue that the mere fact of the timing of a complaint is not confidential.
I think the fact of a complaint is confidential. The question is whether it was in her declaration. And Mr. Gross, I do think that the audio for you, whatever situation you're in, is bad enough that we might need to try you calling in. Every other statement you're making is missing some syllables. So if we could have you try calling in, I think that would be helpful to everybody. In the meantime, if you find something in a declaration about that, we can deal with it. Otherwise, I'm going to sustain the objection.
Your Honor, I should say, this is Ann Bremner. I have been on my phone for the afternoon for the problems that we've had, so I'm in on an iPhone. Just an FYI.
Well, we can hear you clearly, Ms. Bremner. Hopefully those same will go once we get Mr. Gross on a telephone.
Okay, I think I'm on my phone.
You'll need to mute your computer, however.
Okay, should be good. I'll come back to this topic if I find that portion of the declaration. But when you told the judge that you wanted to work with her to rebuild your relationship, you were actively looking for other jobs.
No. No.
You testified that when you went to your 3-week vacation, that's when Serena Daigle went on leave, right?
Yes.
And you testified that when you returned, you were surprised to learn that Miss Daigle had gone out on leave.
I was.
And again, you and Serena are friends.
Yes.
So it's your testimony that Miss Daigle did not tell you that she was going out on leave?
Miss Daigle did reach out to me to let me know she had gone out.
Okay, so help me understand when you say that you were surprised when you returned to learn that she had gone out on leave, but that she had already told you.
I was surprised. I was hopeful that, everything would be fine. So yeah, I was surprised.
The law firm that represents you also represents at least 3 other Bremerton Municipal Court employees who are employed under Judge Flood.
Are you asking me? I'm sorry, what is your question?
The law firm that represents you also represents at least 3 other employees of Bremerton, former employees or employees of Bremerton Municipal Court under Judge Flood.
I guess, yes.
So one of them is Stephen DeRozier.
Are you asking me, or what is your?
Yes, all of my statements are questions for you to agree with or not.
So, Mr.
Okay.
Gross, why don't you ask your questions in the form of a question, and that will alleviate any confusion. Typically with a cross-examination, they are asked in the form of a question, even if they're declaratory in their form, but just ask them like a question. Thank you.
Okay. Is one of the clients of the law firm that represents you also Stephen DeRozier?
I'm going to object. This is calling for speculation at this point.
Mr. Gross, do you have, would you set a foundation for your question? I'm not, without more understanding of whether this witness knows anything about that, I'm tempted to sustain the objection unless you can set some sort of knowledge here about these issues.
She just testified she knows that 3 other of these employees are also represented by the same law firm. So I'm basically just trying to establish 3 employees are.
Okay, she said, I guess. So it was unclear to me what the basis of that knowledge was.
Ms. Johnson, do you know which current or former employees of Bremerton Municipal Court are also represented by the same law firm that represents you?
No, not 100%. I know that I'm represented by her.
You testified earlier that you left Bremerton Municipal Court for a job at AOC, correct?
Yes, yes.
That is a work from home position?
It's a hybrid. I go in, work from home, and I go on site
How often do you go in?
once a week.
Did you ever file a complaint with the City of Bremerton Human Resources Department?
I did.
Is that in April of 2023?
I did.
Thank you. That's all the questions I have.
Thank you, Mr. Gross. Ms. Rasnick, redirect.
Just very briefly. Jennifer, you were asked about the discussion that you testified about the training that Judge Flood was scheduled to attend in October 2022. Was the issue with her being gone for the training that there were not pro tems scheduled to cover the court, or was it something different?
It was something different.
What was the issue in your mind with her leaving to go to a training in October 2022 if it wasn't coverage of the courtroom?
The issue was we hadn't prepared to cover another week for staff, and we were there to help, and she was leaving to go to a training, and so we were of the mindset like, you should be here. You're having issues with your court, and we're courts helping courts. We're trying to help with this coverage, but she's leaving for this training.
Okay.
And
you were asked by Mr. Gross about the leave request process that, during your vacation, your pre-planned vacation in February and March 2023, that during that vacation, the judge began having staff bring their leave and scheduling requests directly to her. Did that process continue after you got back from vacation?
yes.
And you were asked about, you testified earlier about the incident when you recall Judge Flood coming down the stairs into the court's office, into the clerk's office, and shouting at Amber Dodge. Do you remember testifying about that earlier?
Yes.
And is it your recollection today that this incident happened more than 30 days after you started, after your first day at Bremerton Municipal Court?
Yes.
And you were surprised, you testified earlier that you were surprised when that happened because you had not seen anything like that from the judge previously.
Correct.
Okay. I don't have anything further on redirect.
Thank you, Ms. Rasnick. Mr. Gross?
Nothing further.
All right, so ladies and gentlemen of the panel, that concludes the attorney's direct and examination of the witness. You now have an opportunity, though not the obligation, to ask questions of the witness, and each attorney is able to object to the question, and I will make a ruling on the objections. So if you have a question for the witness, please raise your hand. Commissioner Moody has a question.
This is Commissioner Moody. Ms. Johnson, I've never worked in a court system whatsoever, so I just want to preface that by saying that's not my background. But I want to clarify, when Judge Flood was set to go to this judges conference or training, I've heard it called a couple different things. What was the expectation of yourself that her staying would add, would help? In other words, what could the court, as court administrator, what could you not do with her gone versus her there? I mean, was the expectation that she would take payments from the public, or what was that expectation?
Well, at that time, there was no court administrator. Ms. Kinlow and I were just there to help. And so there was no court administrator there at that time. And so with her leaving, that would just be leaving just the staff with no management. And technically, the judge is management.
Redirect narrowly confined to that question, Ms. Rasnick?
I don't have any, thank you.
Mr. Gross?
No, thank you.
Any further questions from members of the panel? I see no hands. Ms. Rasnick, can this witness be excused?
Yes, Your Honor.
Okay, and when I ask that question, I want both counsel to highlight whether you believe this witness should be subject to recall, just so I can make that sort of statement on the record. At this point, Ms. Rasnick, I'm taking from your comment that the witness will not be subject to recall.
Actually, Your Honor, I cannot say that the witness would not be subject to recall. So I would like to, we can release the witness subject to potential recall.
If that's the case, then Ms. Johnson, you are instructed not to view any other testimony from any other witness. All right, Ms. Rasnick, do you have another witness?
I do. Disciplinary counsel calls Latricia Kinlow.
All right, Ms. Kinlow, I am the presiding officer, Judge Price. If I could ever have you raise your right hand. Do you swear or affirm the testimony you're about to give is true and correct?
I do.
All right, Ms. Rasnick, you may begin.
Good afternoon, Ms. Kinlow. I'm Reagan Rasnick, Disciplinary Counsel. Can you hear me okay this afternoon?
Yes, I can.
Okay. I can hear you as well. Where are you currently employed?
I'm currently employed with Tukwila Municipal Court.
And what is your position with Tukwila Municipal Court?
I'm the Judicial Branch Administrator, also known as the Court Administrator.
How long have you been in that position?
I've been here almost 19 years.
And did you work for any other courts before you came to Tukwila?
Yes.
What other courts did you work for and for how long?
I worked for Kirkland Municipal Court from 97 till 2005 when I started here.
Okay. So how many total years of court experience do you have?
Approximately about 26 years.
Are you currently active in any professional organizations for court managers?
Yes, I'm active in the National Association for Court Management, as well as the Washington State District and Municipal Court Management Association.
Are you involved in, as faculty, for presenting any trainings for judges or court managers?
Yes, I facilitate training. I'm part of the Judicial College faculty for Washington State. I also do training for the Center for Court Innovation out of New York. And I also do customer service training for courts nationally.
Are you acquainted with Judge Tracy Flood, the respondent in this proceeding?
Yes, I am.
Did you do some, did you participate in doing some work with Bremerton Municipal Court in 2022?
Yes.
How did that come to happen that you did some work at Bremerton Municipal Court in 2022?
Well, if I recall correctly, I believe I received a phone call from Judge Flood stating she was advised or recommended that she contact me because she was having staffing issues, some issues at our court. And that was kind of what I'm known for, is I work for the DMCMA's Courts Helping Courts Committee. I'm also on that committee. And what the committee does is if a court is having some either administrative issues or they need some support as it relates to court staffing and doing the administrative duties of the court, they'll reach out to our association and we will get people to go over and provide the support that that court needs.
Okay. And when Judge Flood reached out to you, did she give you any idea of why she thought things were going badly in her court?
Yes, she did.
What did she tell you?
She told me that she believed that some of the issues that she was having was due to her race.
And did she specify who she thought was targeting her?
She had said that she had some turnover from the initial court administrator, then the interim court administrator, and at the time they just kind of had a revolving door of staff coming and going.
But did she identify anybody in specific who she thought was targeting her because of her race?
I don't recall that specifically.
Okay. How did you respond to Judge Flood's request for help from Courts Helping Courts?
Well, the first thing I did as a woman and a woman of color, I was very concerned. I know the area that she works in, and it's not a whole lot of diversity. And so, as I always do, if I get a request to go to another court to provide support services, I always talk to my presiding judge, Judge Kimberly Walden, to get her support for me to go over and lend support to another court.
And was Judge Waldron supportive of your assisting in Bremerton?
Yes, very supportive.
And you mentioned that you are a woman of color, Ms. Kinlow. How do you identify racially?
African American, Black, female.
Thank you. Thank you. After you talked to Judge Walden and got her support to provide the assistance in Bremerton, what do you recall doing next?
The next thing I did is I had a close working relationship with the Des Moines Municipal Court Administrator at the time, which was Jennifer Johnson. I reached out to her. I kind of told her what was going on, and she said, "Hey, I've got time to go over and help." And usually with Courts Helping Courts, what we do is we go in, do an assessment of what the needs are, how long the support is going to be needed, and kind of report that back to the chair of our committee. So Jennifer and I drove over, met with Judge Flood to look at what she had going on and what support was needed.
Okay. How do you remember how Jennifer Johnson reacted when you reached out to her about the two of you doing this in Bremerton?
I did share with her what Judge Flood had shared with me about.
Excuse me?
I said objection, non-responsive.
I don't believe the witness had finished her sentence.
Yeah, right. Let's overruled at this point.
So again, the question is, how did Jennifer Johnson react when you reached out to her about going over to Bremerton?
She was willing to go to provide the assistance so we could go over and support Judge Flood.
And did you and Ms. Johnson go over to Bremerton together?
Yes, we did.
Did the two of you discuss the situation while you were traveling over there?
There wasn't much to discuss. I shared with Ms. Johnson what Judge Flood had shared with me about what she thought were the issues or why she was having issues.
And what did you expect, just speaking for yourself, at the point that you were headed over to Bremerton that morning, what did you expect to find based on what you had heard from Judge Flood?
Well, I expected to find all kinds of things. I was looking for macroaggressions, microaggressions, looking for anything that supported what Judge Flood believed she was dealing with at the court at the time.
And what did you in fact find when you and Jennifer Johnson went over to Bremerton Municipal Court that first day?
We found that there were a lot of administrative duties that needed to be taken care of, things that had fallen way behind, collections, sending cases to collection was way behind, receiving of parking payments had not been processed. The old court system was not being properly used. And with the staff, what I found is there were a number of new staff members. So there was a young lady there that I called Sweet Amber. Amber was there, and Martita. They were both new clerks, new to the courts. They hadn't even been there 6 months. And so they were doing the best they could. And so it just felt like they were very short staffed, and that you had new clerks who did not know what needed to be done.
Sorry, Ms. Kinlow. I was just gonna ask a slightly different question. You mentioned Amber and Martita. Were the two of them there on that first day?
On the first day, Amber was there. Martita was not. She was out ill.
Okay. And just from your interaction with Amber, I mean, did she seem to be hostile to the judge?
Not at all.
And so you mentioned, did you take note of those issues that you were just recounting about the financial issues and the need for payment processing and such? Did you take note of those on that first day the two of you were over there?
Yes, I did, because that's what we do as part of Courts Helping Courts. So we're getting an assessment of just exactly what the need is, so we can go back and talk to our committee and see if it's something that we could actually assist with. So yes.
And then did you stay through that the whole day, that first day?
Yes, yes, we
And
did.
okay, and Jennifer also stayed through the day?
Yes.
What did you do as the day continued? What did you focus your time on?
I focused on working on the parking receipting, as well as looking at the collection payments that needed to be processed and getting those prepared to be processed in the judicial information system.
Were the two of you also trying to get some coverage in place?
Yes, that's part of the assessment, is determining what coverage is needed, what level of expertise would be needed to assist the court, as well as looking at the current staffing. And like I said, they were new to the court, and so they also needed training. So you needed people that could not only come in and do the job, but they also need to train the staff on how to do their job.
So after that first day, did you yourself go back for additional days at Bremerton Municipal Court?
Yes, I did.
Do you remember about how many times you went back?
I do not remember how many times I went back, but it was over a period of about 4 months that I went back and forth,
And
if I recall correctly.
Was it sort of on an as-needed basis?
Yes, because they were without a court administrator. And so there were some functions that had to be taken care of, such as month end, such as the daily cutoff. All of those things need to happen. And so I would go back periodically, sometimes myself, sometimes Jennifer went over. We also participated on their hiring panel for their court administrator position. So several times I went back and forth.
And did Courts Helping Courts, was it a short time engagement of providing the clerk coverage assistance, or how long do you remember that lasting?
It was, I don't remember exactly how long, but I know it was for at least 4 months. And so we were able to get various courts to allow their staff to provide remote assistance and do virtual clerking for their hearings and things like that. It was a few courts. It was Des Moines Municipal Court, it was Tukwila Municipal Court, and Issaquah Municipal Court that were able to provide that assistance.
Okay, and you testified that you were involved in helping Judge Flood to hire a new court administrator. Did you participate in any of those interviews?
Yes, I was a part of the interview panel.
Okay. Do you recall who else participated in the interview panel?
Christy Shorn from Issaquah Municipal Court.
Okay. And did Jennifer Johnson at some point decide to apply for the court administrator position?
Yes, she did.
Did you have any feeling about whether Ms. Johnson was qualified to be court administrator in Bremerton?
I had no doubt that she was qualified. Jennifer had been a court administrator longer than I had been one. And so I knew she was qualified. I just questioned her timing.
Object. Unresponsive.
Okay, I'll move on. I want to switch gears just a little bit. During the times that you were over in Bremerton, did you ever, let me just ask you first, did you ever have the opportunity to observe Judge Flood interacting with court staff?
Yes, I did.
Do you recall an incident involving Amber Dodge when you were at Bremerton Municipal Court and Ms. Johnson was also at Bremerton Municipal Court?
Yes. Yes, I did.
And the incident that you're thinking of, where did it happen in the courthouse?
It happened in the front office.
So would this be like the clerk's office where the counter is and phones and people have their offices?
Correct.
And where were you when this incident happened?
Well, I recall that I arrived there. It was just before lunchtime. Amber was working with somebody at the front counter, as well as trying to prepare the jail calendar for the upcoming hearings that were taking place that afternoon. And then she also had somebody on the phone. So she was trying to manage all these three customer service areas. And so I came in and I said, okay, you handle finish with this. I will take the phone call and then I'll help you with this other thing. And so
where was Judge Flood at this point? Had you seen Judge Flood?
I had not seen Judge Flood. I believe she was up in the courtroom.
And was Jennifer somewhere in the clerk's office at this time too?
I don't recall Jennifer being there at the clerk's office. I think Jennifer had a meeting over, because at this point, Jennifer was then the court administrator and she had a meeting with, I think, the finance director or somebody.
But did you see Judge Flood during this incident?
I did see Judge Flood as we were trying to finish up things. And I was still, like I said, Amber was new. I was still trying to train her on how to do something. Judge Flood approached or came to the back of the clerk's office and with her voice raised, asked how come nobody was handling the Zoom call. And Amber was responding. She said, Judge, I didn't know you had one. She says, I've been calling. No one's been answering the phone. And I needed this meeting with her IT department. And Amber said she didn't know anything about it. And Judge Flood said, well, I'm calling and there's nobody to let anybody in. And she was very upset. She was very upset.
Was the judge raising her voice?
Yes, she was.
You could hear her all the way across the room from the back?
Yes, I was at the front counter with Amber and the judge was at the back door of the clerk's office.
And the judge seemed upset?
Very.
And based on your observation, how did Amber react?
When the judge walked away, Amber began to cry. We didn't have a customer at the time, so I took her over into one of the offices. I talked her down. I told her, I said, just go to lunch. And she just kept sobbing.
Did Amber go to lunch?
Yes.
There was an objection to hearsay. I'm going to overrule the objection that it's not, doesn't go to the truth of the matter.
What did you do after Amber went to lunch?
After Amber went to lunch, I continued to finish processing the jail calendar and getting that prepared. At that time, Jennifer had returned from her meeting. I immediately informed her what happened since she was a court administrator. And I said, you got to do something. I said, because Amber's really upset.
And when the judge came in and was shouting at Amber across the room, what were you doing? Were you looking at the judge? Were you trying to do anything to intervene at the time?
I did not try to intervene because remember, I was there for Courts Helping Courts. At this time, Jennifer was the court administrator, so she was responsible for the staff. But I did just look at Judge Flood because I was trying to figure out what.
Not responsive.
Overruled.
So yes, I was looking at Judge Flood at the whole time that she was yelling. And as soon as she left, I immediately went to go and see about Amber.
Did you ever speak to Judge Flood about that incident?
Yes, I did. That evening.
I'm sorry, I was going to say, when did you speak to her about it?
That evening, Jennifer and I went up to her office and I spoke to the judge about it.
Do you remember what you said to the judge about it?
I said, Judge Flood,
I'm sorry, Mr. Gross, I can barely get your objections. I guess it was hearsay. Ms. Razing, do you have a response?
I couldn't hear Mr. Gross either. I can ask it a different way.
Why don't you ask a different question?
Okay, so you were saying, Ms. Kinlow, that you met with Judge Flood. Where did that meeting happen?
In her chambers upstairs.
Okay, and what did you want to convey to Judge Flood? What was your intent in what did you want to convey to her during that meeting?
First of all, they didn't have enough staff as it was, and Amber was there. working as hard as she could. I wanted to convey that we were in a situation that we could not afford to lose any more employees at this point. And I wanted to convey that it wasn't necessary to yell. And I wanted to explain everything that Amber was trying to take care of at that time, which might have been the reason why she missed having to let IT into the Zoom room.
Did you feel like those concerns were conveyed to Judge Flood during the meeting?
Yes.
Did the judge say anything to you to indicate how her perspective, or did she respond at all?
She responded that she didn't yell at anybody.
And from your perspective, did she yell at someone?
Yes, she did, and I said so.
Who did she yell at?
And she said she didn't. She says, who would she have known? She didn't know who was supposed to let somebody in the Zoom room. And I explained, I said, well, you knew I wasn't letting anybody in the Zoom room, and the only other employee there was Amber. So that's how I left it. So
did Judge Flood take responsibility for her conduct during that meeting that afternoon?
her response to me is, I got it.
Those were her words?
I got it. Okay, I got it. I got it. I got it. That's all she kept saying is, I got it.
Do you know whether she ever apologized to Amber?
I do not know.
Okay. Let me ask you about another, well, first, during the times that you were at Bremerton Municipal Court, do you recall whether you ever offered any suggestions to Judge Flood about court operations, like about how court operations could be handled?
Yes, I did.
Do you know whether she took any of your suggestions?
She did not. She did not take. The one suggestion that comes to mind is I was explaining that she need to have a cutoff time. She need to work with prosecutors to have a cutoff time for when matters that need to be on the jail calendar could be filed with the court and heard on that same day, because there wasn't enough time between the time that the clerks received the filings to properly prepare the case file for that afternoon hearing. And so I had suggested either not only having that cutoff time, but also working with the correctional agency to see if they could have a different start time for those in custody matters.
Okay. You mentioned at the beginning of your testimony that when you headed over to Bremerton that first day, you were alert to looking for what you described as macroaggressions or microaggressions, or things that we would associate with kind of institutional racism or workplace racism. Did you find anything during the times that you were in Bremerton Municipal Court that you recognized as macroaggressions or microaggressions?
I did not witness anything like that. What I witnessed are really hardworking employees that kept.
Okay, I'll move on. It's fine. Let me ask a question about Stephen DeRozier. Did you ever interact with Stephen DeRozier, who was the therapeutic court coordinator in Bremerton?
Yes, I did.
Did you have occasion to discuss with him or just talk with him about the work he was doing to set up the therapeutic court?
Yes, I did.
Did you have an understanding of whether part of his position was trying to sort of set up systems and processes for therapeutic court?
Yes, that was my understanding.
Were you present on an occasion when Mr. DeRozier tried to share some of the work that he'd been doing to set up the processes with Judge Flood.
Yes, I was.
What do you recall about that incident? Let me ask first, where did it happen?
It happened in the front office. I was
Um,
there. I was working on some collection items, and Stephen was sitting over at the desk across from me. And he said, "Hey, can I show you something?" And I said, "Yeah." So he was showing me this intake, I believe it was an intake form that he had created for the program. And I was complimenting him on, and because it was so well thought out. And I was complimenting him on that. And I asked him, I said, "Have you ever had court experience?" He said, "No, this is life experience." And we just kind of laughed. I said, "Well, you should show that to the judge." I said, "Because this is amazing." And he said, "You think so?" I said, "Yeah."
Objection.
I think that was an objection. My guess is hearsay, although I couldn't hear it. Ms. Rasnick, maybe you could ask a question so it doesn't solicit hearsay.
Sure. Did you see Mr. DeRozier interact with the judge about this intake form that he had put together?
I saw him try to.
Can you describe what you saw?
What I saw was Stephen asking the judge if he could show her something. And then he had his form and he was starting to explain it. Judge Flood held her hand up and said, "I told you, email me. Don't tell me stuff, email me." And he just turned around and said, "Yes, ma'am," and just went back to work.
And when you say she held her hand up, how did she hold her hand up?
Like this, like stop.
Could you see Mr. DeRozier's reaction to that gesture and response?
Unfortunately, yes.
And why do you say unfortunately?
Because I saw just his whole demeanor just slump and change and almost like coward-like.
Did you bring that to the judge's attention at all?
I did not. I brought it to the court administrator, Jennifer Johnson's attention.
Did you have occasion to attend any staff meetings at Bremerton Municipal Court during the time you spent there?
Yes, I did. I was invited by Judge Flood to attend a staff meeting.
And were you participating or observing? What was your role?
I was there observing.
What was the format of the staff meeting? Was it sort of a group sharing situation, or what can you recall about the format?
What I recall is we were sitting up in the conference room. Judge Flood was at one end and the staff was around the table. Lunch was provided. And most of the time, Judge Flood did all the communication. The staff did attempt to either ask questions or give input, but they were usually cut off and not heard.
And was it Judge Flood who was cutting them off?
Yes.
Did it feel like a team meeting to you?
Not to what I'm accustomed to, no.
Did you have any opportunity to discuss that meeting with Judge Flood afterwards?
Yes, I did.
Did you ask her how she thought it went?
Yes, I did.
And do you remember what her response was?
She thought it went fine.
Did you share with her your reaction that she had cut her staff members off, disregarded their questions?
Yes, I did.
Did she have any response to you?
Just her usual response was, "Okay, I got it. I got it."
Was there any particular employee you remember who was trying to ask questions during that team meeting?
Yes.
Who was that?
Ian, the probation officer, I believe that's his name, Ian.
Oh, Ian Cohen?
Yes.
And did you have a chance to observe the way that the judge reacted when Mr. Cohen would try to ask questions?
To me, it was dismissive.
Did you try to intervene at all to try to disrupt this process during the meeting?
Kind of. I kind of chimed in and said, well, Ian, that's a good thought, you know, and I just put it like that. And then there was this awkward pause, and then Judge Flood continued on with her meeting.
And she continued talking at the staff.
Correct.
In the time that you spent at Bremerton Municipal Court in 2022, did you form an impression of what changes you thought were needed to help the court work better?
Yes, I did.
Can you share some of what your impression was based on your observations of what you thought needed to change?
Well, I thought that some of the things that need to change is they need to automate some of their processes. A lot of courts are no longer individually processing collection payments. It's an automated process now. So we were in the process, Jennifer and myself, working with their collection agency to get all of those things automated. I knew that they need to either change the time of their jail calendar, their in-custody calendar, or they needed to make a fine cutoff time for when the prosecutor could file those cases to be heard, those new charges, to give the court team ample time to successfully and efficiently prepare those cases for that calendar. The other recommendation that I had made was for them to fully utilize the old court system the way it was designed. Because even though they were set up to be a paper-on-demand court, the court staff was still required to print out all of the case file information for the hearings for Judge Flood.
And having to print everything out, was this putting additional burden on staff and the system?
Correct.
Were there some of your team members from Tukwila who were providing assistance, like some of the clerks from Tukwila, were they providing assistance in Bremerton?
Yes, I had 2 clerks that Judge Walden had supported, allowing them to provide clerk assistance to Bremerton for a period of time.
And was there a point at which Tukwila clerks were no longer allowed to continue to provide assistance in Bremerton?
Yes.
Was there a concern? Did you have an understanding of whether there was a concern that motivated that?
There was a concern.
I'm just asking, I can restate. Sorry, Your Honor.
All right, please restate it.
Sure. Just asking whether you had an understanding of whether there was a concern that motivated that.
Yes.
Objection. Bag.
Overruled.
What was the concern that motivated the Tukwila clerks to no longer be able to go to Bremerton?
Clerks reported.
I believe it's the same question that I already overruled the objection of vagueness on. Go ahead, Ms. Resnick.
You can go ahead and answer, Ms. Kinlow.
There was a concern by the clerks. They were observing some demeanors that made them uncomfortable, and they spoke to myself and to Judge Walden and requested to possibly not continue the work.
I'm objecting on the basis of personal knowledge.
So there's been an objection on foundation. The witness has already said she had an understanding. Ms. Resnick perhaps probed how she got the understanding, and then I can address foundation if there's a further objection to it.
Sure. Um, did the clerks from Tukwila, did they bring these concerns to you?
They brought the concerns to me and to our presiding judge, Judge Walden.
And did you have some discussions with Judge Walden about it? I'm not asking you what Judge Walden said, but just did you have discussions with Judge Walden?
Yes.
And is it based on the information that you got from the clerks and the discussions with Judge Walden that you developed an understanding of the issue that the clerks had?
Yes.
Okay, then I'm gonna re-ask the question. What was the concern that the Tukwila clerks had about continuing to work in Bremerton?
The clerks were.
Objection. This is rooted in hearsay and lack of personal knowledge.
And I'm going to overrule the objection, but the witness needs to answer only as to her impression of the concern and not answer for the concern of the clerks.
So, Ms. Kinlow, what was your impression of the concern that the Tukwila clerks had?
Trying to figure out how to answer.
Sure, just without repeating what the clerks said to you.
Okay.
If you can characterize what your impression or understanding of their concern was.
Their concern was the conduct of the judge in the courtroom with her interactions with the attorneys.
And as a result of this, a decision was made that the Tukwila clerks would no longer provide assistance in Bremerton.
Correct.
Who made that decision?
Judge Walden.
Are you acquainted with Christina Rauenhorst, who is the current court administrator in Bremerton?
Yes, I am.
Have you communicated with, well, let me first ask, were you aware when Christina Rauenhorst became the court administrator?
Yes, as part of DMCMA, we get the notification when a new court administrator takes over a court.
Did you assist with that interview process of Christina being hired?
I did not. I don't recall being on that interview panel.
Have you communicated with Christina Rauenhorst since she has been in the court administrator position to assist her in carrying out that position?
Yes, at the time, I was.
Unresponsive.
Ms. Resnick, perhaps ask the question.
I will do that. So your testimony was you had communicated with Ms. Rauenhorst. Let me ask, have you provided some assistance to Ms. Rauenhorst?
Not directly.
In what form have you provided assistance to Ms. Rauenhorst?
Connecting her to the DMCMA regional director, Amy Knutson.
And what's Ms. Knutsen's position?
She's one of the regional directors for the DMCMA, our state association.
And is she a court administrator as well?
Yes, she is.
Which court?
I believe Amy is Polsbo.
Have you participated in any meetings or with Ms. Rauenhorst and Ms. Knutson?
Yes, I have.
Do you recall about how many meetings you participated in?
I've participated over email, some email questions that came up, and then I was requested to attend a meeting with the two of them that they were having with the prosecutor's office.
So a meeting of Ms. Rauenhorst and Amy Knutson from Polsbo Municipal Court and the Bremerton City Prosecutor?
Two representatives from the prosecutor's office, as well as our DMCMA incoming president, Frankie Peters, who's the Thurston County District Court chief executive officer.
And before you participated in the meeting, did you have an understanding of what the meeting was meant to accomplish?
Yes.
What was that understanding?
Collaboration so that court cases could be processed, and an understanding of Christina's role as a court administrator.
So, and who was going to be doing the collaborating, or whose collaboration was the meeting supposed to be about?
It was for the prosecutor's office and the court, non-judicial functions of the court, which fall under the court administrator.
Did Judge Flood participate in that meeting?
No.
Was there discussion at the meeting about the way the court was able to carry out at that point its functions?
Yes.
Do you remember about when this meeting happened?
I do not recall off the top of my head.
Was it this calendar year, 2024?
I believe it was. I believe it was spring of this year.
And was it a useful meeting?
Yes, it was. Yes, it was.
Do you remember that issue about mislabeling of court hearings coming up at that meeting?
Yes.
What did you understand the issue to be?
The concern was that there was a case that had reached the pretrial status that the clerk was instructed to schedule it for an arraignment.
And
to which, yeah.
Did you have an understanding of who had instructed the clerk to set it for an arraignment?
Yes.
Who had instructed the clerk?
Judge Flood.
And based on your experience, would it have been appropriate to set that for an arraignment at that point? Was an arraignment the appropriate hearing?
Not in my years of experience. No, you don't. You have one arraignment. You don't turn around and go backwards.
And was this issue of the labeling of hearings something that the group was attempting to problem solve during that meeting?
Correct, because the prosecutor was concerned that the court staff weren't properly scheduling things with the right labels, and that gave Christina an opportunity to explain why the clerks were doing what they were doing, because they were doing as instructed.
Okay, and as instructed by Judge Flood?
That was my understanding.
During your interactions at Bremerton Municipal Court and with Judge Flood, did you develop any inclinations or any thoughts about whether the judge would benefit from mentoring?
Yes, I did.
Have you ever worked for a judge who is in a solo court?
Yes, I work for one now.
And have you experienced judges working with mentors?
Yes. Yes, most judges have a support system, especially single judge courts usually have some type of support system, people they can bounce things off of.
And do the professional organizations that exist in Washington, for courts of limited jurisdiction judges, are there mentoring opportunities that are available through those organizations?
Not officially. Unofficially, yes.
Mm-hmm.
They are working on an actual mentorship program.
All right. I don't have anything further for you on direct, Ms. Kinlow. Thank you.
Thank you.
Thank you, Ms. Rasnick. Mr. Gross, cross-examination.
Thank you. Hello, Ms. Kinlow.
Hello.
You assisted Bremerton Municipal Court through Courts Helping Courts.
Correct.
And the whole time you were doing that, you were also the court administrator for Tukwila Municipal Court.
Correct.
And the court administrator job is an important job in the court.
Yes, it is.
you were not able to spend a significant amount of time in person in Bremerton while you were assisting Bremerton.
I would disagree.
Okay. You worked with Bremerton Municipal Court primarily remotely.
Not initially. Initially, I was going over almost every other day until they got a court administrator.
Okay. Well, I'm asking about the whole time. The primary way you were helping them remote.
Yes, and via email.
And you said earlier that you didn't remember how many times you, even roughly, that you went in person to Bremerton Municipal.
Not off the top of my head. No, I do not.
Possibly less than 5 times?
It might have been more than that, but I don't recall.
But possibly less than 5 times.
I believe it was more than 5 times.
Less than 10 times, though.
I will give you less than 10.
And when you were assisting Bremerton Municipal Court remotely, you were not able to observe interactions between Judge Flood and her staff.
No. Usually those remote assistants were helping with case processing.
And you never observed Judge Flood in court.
No, I did not.
So you observed a tiny percent of Judge Flood's interactions with staff.
Tiny but significant.
Significant in what you observed, right? But not significant in terms of the percentage of interactions.
Significant in what I observed, yes.
You testified earlier you did not see anything that you would consider racial bias from staff towards Judge Flood.
No, I did not.
But that does not mean that those instances did not occur from staff to Judge Flood.
I'm sorry, were you asking me a question? You kind of keep
Yes.
cutting in and out, Attorney Gross. I'm sorry.
Just because you did not witness any racial actions you considered racial bias does not mean that her staff did not exhibit racial bias towards Judge Flood.
I did not witness it.
But that doesn't mean it didn't happen, right?
That's a possibility.
Regarding the incident with Amber Dodge, you testified that Judge Flood raised her voice.
Yes.
But you also testified that you and Amber were standing clear across the room,
Yes, we were.
maybe 30 to 40 feet away from Judge Flood.
Possibly. Might have been more.
You also talked about the things that Miss Dodge had been doing before Judge Flood walked in, helping someone at the counter, correct?
Helping someone at the counter, had somebody on the phone, and trying to process cases for the upcoming in custody hearing.
But Judge Flood did not see any of that.
No, she did not.
All she saw when she walked in was you and Amber standing talking, correct?
No, Amber was assisting somebody at the front counter. I was assisting processing the case in the JIS system. We weren't talking.
Okay. No further questions.
All right, thank you, Mr. Gross. Ms. Rasnick, redirect.
I don't have any redirect, thank you.
All right, thank you. Panel members, you now have an opportunity, but not the obligation, to ask questions if you have any. If you have a question, please raise your hand. Commissioner Evans.
I had a question about the timing of there was reference to the out-of-state conference and the judicial conference. I was just curious what the approximate timing of that was.
Ms. Kinlow, did you understand the question?
I'm sorry. No, I did not.
My apologies.
That's okay.
There was some testimony about a scheduled out-of-court conference for Judge Flood. I was just curious about the timing of that. Was it end of the year, first of the year? When was that? And it was made reference that it was the Judicial College and out of state conference. So I'm just looking for the timing of that.
What I recall is there was the National Judicial College that she was attending out of state. We had a conversation about it. I recommended that she not attend because her court was in crisis. Her response to me was that she needed to go. And I'm sorry.
You're muted.
Yeah, Mr. Gross, did you have an objection?
Yes, non-responsive.
Yeah, sustained. Do the attorneys have any follow-up narrowly to the question? Ms. Rasnick?
Yes, I'd like to ask a moment of redirect if the panel is finished with its questions.
I intend to have the attorneys ask follow-up to each specific question narrowly related to the question. So if you have a follow-up to Commissioner Evans' question, now is the time.
Sure. Ms. Kinlow, did you recommend that Judge Flood not go to the out-of-state judicial conference?
Yes, I did.
Was that because there was so much going on at Bremerton Municipal Court that she needed to stay there?
Yes.
Do you know whether she went anyway?
She did.
That's all the follow-up I have on that question.
Mr. Gross?
I need one moment with my client. Ms. Kinlow, was part of Judge Flood's initial request for Courts Helping Courts to come help her because she had National Judicial College scheduled?
No.
You never told Judge Flood to put in writing the fact that her request in part was because she had a scheduled National Judicial College?
Part of the process for Courts Helping Courts is our association does have a form that we request people to fill out. And Judge Flood may have filled that out, but my contact with Judge Flood was by phone, her contacting me to come and provide assistance because they were short-staffed. They were having staffing issues. That's why I was invited. And she believed that some of the staffing issues was a result of that it was racially motivated.
My question is, did you direct Judge Flood to put her request that part of her need was that she was going to Judicial College? Did you tell her to put that in writing?
I don't recall telling her specifically what to put in writing. I'm sorry, I don't recall that.
Okay. Do you know? Yeah. Do you know whether the court administrator and Seattle Municipal Court received Judge Flood's request?
I'm sorry, you keep going out, Attorney Gross. I couldn't hear the question.
Do you know whether the court administrator and Seattle Municipal Court received Judge Flood's request?
The court administrator for Seattle Municipal would not have received Judge Flood's request. It was a manager there, and she is the chair of our Courts Open Courts. So yes,
Did she receive
she received the request.
I'm going to object for a second. I understood that we were to be asking questions related to the question that the panel member had asked, that we were limited to questions related to Commissioner Evans' questions about the out-of-state conference. And Mr. Gross seems to have gone afield from that.
Well, I was going to allow a little leeway here because his questions did seem designed to get at the same issue regarding whether or not this out-of-state conference was or wasn't part of the reason why the witness was involved. But Mr. Gross, do you have anything else, because it's getting close to straying from the panel's question?
No, I'm done. Thank you.
Okay. Ms. Rasnick, anything further regarding the panel's question?
Sorry. No, nothing further, Your Honor.
Okay. Any other panel members have a question? All right. Seeing none, Ms. Rasnick, can this witness be excused?
Your Honor,
Your
it
Honor,
looks
I
like
believe
Commissioner Moody has a hand raised.
Commissioner Moody.
I'm sorry, Your Honor. I just wanted to clarify with Ms. Kinlow, when this quote yelling incident happened, because Judge Flood couldn't get into the Zoom call, it was you and Amber that witnessed this, and Miss Johnson wasn't anywhere around. Can you just
Correct.
clarify that for me? Was she not in her? I mean, just what's your understanding of where she was?
My recollection is that Miss Johnson was out of the office. She was at a meeting, I believe, with the finance director.
Right. Ms. Rasnick, follow up.
Yes. Ms. Kinlow, is it possible that Ms. Johnson was in the office that day and you just don't recall?
That's a possibility.
Good, that's all I have.
Okay.
Thank
Mr.
you.
Gross.
Nothing further.
Any other panel questions? Panel questions? All right, pausing slightly longer than last time. I see none. So at this point, may this witness be excused, Ms. Rasnick?
Yes, I think there's less chance that I would need to recall Ms. Kinlow, but I would still want to reserve the right to recall her.
All right, so Ms. Kinlow, you are excused for now, but please do not view any other witnesses' testimony on YouTube or any other location. Thank you.
Thank you, Your Honor.
So, Ms. Rasnick, it is now 2:23. I'd like to go a little bit longer before we take our mid-afternoon break, so long as the panel members don't need a nature break.
Your Honor, we on our side, we do.
Okay. Let us take our mid-afternoon break a little early, considering we have a hard stop at 5 o'clock. This will be our one break this afternoon. I'm also conscious of our court reporter who's been working diligently and not complaining, so I appreciate that. But she does need a break as well. So let us take a 15-minute break. This will be it for the afternoon. I have 2:24. Let's come back at 2:40. 2:40. We'll be in recess till 2:40. At the time on my computer is now 2:40. We have Ms. Rasnick, Mr. Gross. It looks like we have everybody. So before we get started here with the next witness, Ms. Rasnick, what can you tell me about your schedule?
Sure. I have, I'm going to call Gary Hersey, who is another witness who has a lot to testify about. And I expect that his direct and cross will likely to require the rest of the afternoon, which means that I still have Christina Rauenhorst and Ian Cohen to have testify. Mr. Cohen's direct is probably roughly the same length as Ms. Kinlow's. maybe just a few minutes longer. I don't know how much cross respondent has planned for Mr. Cohen. Ms. Rauenhorst's direct is probably maybe about the same length as well as Mr. Cohen's. So I think I am in the position now where I need likely a couple of hours. And my suggestion would be that that happens in the morning so that I can finish my case. Mr. Cohen is available in the morning, and I believe Ms. Rauenhorst is available in the morning as well. And then I can be done with my case. That's what would seem, that's what occurs to me immediately. But that is the situation that I am in. I have 2 live witnesses that I need to present after the one who's going to go this afternoon.
Ms. Bremner?
Well, Your Honor, we had agreed to a day each, and we anticipated we could end today with, especially with the, well, even in light of the 5 o'clock hard stop time, but Mr. Gross is handling all of the CJC witnesses, so I would defer to him if he has anything to add and defer to the court. I understand how these things go, but we did have some pretty set parameters in terms of times.
Mr. Gross?
Correct. The parties executed a stipulation that the court granted. That stipulation gives each party 1 day. We discussed ahead of time that the parties would need to plan out their own witnesses and the length of time it would take so that they could get in as many witnesses as they wanted to get in. So we would object to extending this, especially, I mean, we would object to extending this, especially for them to call primary witnesses rather than cross-examine declarants. That would be outside of our stipulation.
Ms. Rasnick?
Your Honor, the stipulation called for 5 witnesses, 5 live witnesses per side. We agreed that we would set aside Wednesday and Thursday and that additional time could be granted Friday by motion. There was not an agreement that we would simply squeeze in as much testimony as we each could in 1 day. We didn't start Commission's first witness this morning until 9:20 because of the need to deal with preliminary matters and opening. We also had some delays and had to be off the record because of some technological issues respondent was having. And I don't think it was possible to know how much time we were going to need to spend on objections and questions from the panel. So given the importance of this matter and that we have consequences that this panel is required to rule on that are very significant for this judicial officer, I think it's important that these witnesses be heard from. And if that means we need to take some time on Friday when our stipulation specifically allowed the possibility that we could request time on Friday and that time on Friday would be granted, I don't think that this is an out of bounds request. And Your Honor has sat and listened to these witnesses today and has heard the kind of information that they are describing. It is difficult information for them, and it's taking some time to get out. And it sometimes things just take a little longer in court than one anticipates or plans for. And I think if anything warrants an extension of a few more hours here, I think it is this circumstance.
Ms. Bremner, I take it from your comments that perhaps someone besides Mr. Gross is handling Judge Flood's witnesses. Is that a safe assumption, or is that Ms.?
I am.
Okay. So with respect to that, then, what does it look like with how flexible are you with your witnesses?
Well, I'd have to check in with them because I know I have at least one coming in tomorrow morning at 8:30. And then our paralegal's on this too, and she can let us know if there's people that have an obstacle where they have to be on tomorrow morning. She could pipe in. I know she's on this, but talking just in responding to what counsel said about this taking his time, I've yet to hear testimony about conduct that would be along the lines where I talked about in my opening. We're hearing a lot about these people's backgrounds, a lot about their impressions, a lot of hearsay, a lot of, court staffing issues, admin issues. But I think, with respect to relevance, we've made those objections, or Mr. Gross has, but I don't agree that this has been necessary so far to take this kind of time with these witnesses, or to take more time than today. But I've made my position, I think, pretty clear. But Karina, can you indicate if there's anyone that cannot change from tomorrow morning? I'm not hearing anything, so I think if need be, we'll have to accommodate. Thank you.
Well, it seems like the options would be, well, three options. One, deny the request. Secondly, to take witnesses out of court.
No.
One option would be to deny the request. Another option would be to grant the request with respect to contiguous testimony from the disciplinary council meeting tomorrow morning. Or third option, to take witnesses out of order, perhaps have disciplinary witnesses either in the middle of or after respondent's case. I don't particularly like that third option, but with respect to those options, Ms. Bremner, do you have, obviously you're objecting to option one, right, but the other two options, do you have a preference?
I don't, Your Honor. I do have a matter on Friday late morning that it's going to be very difficult to change, but I would defer to the court. I just think that we've had a lot of extra testimony today that was not necessary to what's being charged or asserted in this case against our client.
Understood. Well, at this point, what I'm going to ask you, Ms. Bremner, perhaps you've got folks at your side who can check about rescheduling your morning witnesses, and then I'll reserve ruling until I hear back from you on those questions.
Excellent. Thank you, Your Honor.
Yeah.
That's all I have.
All right. Ms. Rasnick, another witness.
Disciplinary counsel calls Gary Hersey, Your Honor.
All right, good afternoon, Mr. Hersey. I'm presiding officer, Judge Price. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct?
I do.
Right.
Good afternoon, Mr. Hersey. I'm Reagan Rasnick, disciplinary counsel. Can you hear me okay?
I can, thank you.
What is your job title, Mr. Hersey?
I am the city prosecutor for the city of Bremerton.
And how long have you been in that position?
June of 2020. I think I started June 1st, 2020.
Prior to starting in Bremerton, did you practice in some other courts?
I did. I graduated law school in 2012. I'm from the East Coast originally. I moved back to Maryland and took the Maryland bar. And then for a couple of years, my wife and I, we went to law school together, struggled to find full-time jobs. We were doing various contract work, and I had been working various contract jobs, doc review, as it's most commonly referred to, and volunteering with the Baltimore City Public Defender's Office. Before that in law school, I worked at the criminal law clinic, and then my wife got a job at a nonprofit in Yakima called Team Child. And so we moved across the country. I worked for a very small firm for a couple of years there, doing criminal defense and family law, just for about a year. And then I was offered a job with the prosecutor's office in Yakima County. And I worked there from 2016 to 2020, May of 2020, where I started in district court and worked up through ultimately the special assault unit.
How long did you practice in Bremerton Municipal Court while Judge Doctor was the presiding judge?
So it would have been June of 2020 until he retired. So the end of 2021.
Did you have any experience with Judge Tracy Flood before she took the bench in Bremerton?
Very little. At the time, Judge Flood was a defense attorney. I can only remember off the top of my head one case that she took in Bremerton. And it was, fairly inconsequential in my mind. Essentially, it resolved with the pretrial diversion agreement. And I think we only had a few hearings together.
Okay. How often do you appear before Judge Flood now?
So we have calendars, morning calendars and afternoon calendars, Monday through Wednesday. And then we have morning calendars on Thursday and Friday. Additionally, if we're in trial on Thursdays, that could be all day. But so we're a small office of only 2 attorneys. So my colleague and I, Miss Harvey, we will alternate the calendars. And so it comes out to being between 4 and 5 times a week, depending on if Judge Flood is on the bench or not.
And has that been the consistent frequency of your appearance in front of her since she took the bench in Bremerton?
More or less. She does have the commissioner handle the Wednesday afternoon calendars and will oftentimes have pro tem judges covering other calendars.
Do you also have legal assistants who work in your office?
We do.
And do your legal assistants also appear in court?
We do. They will sometimes appear during trials to help out and appear in meetings like criminal practice and procedure meetings, sometimes therapeutic court staffing, things like that. Currently we have 2 full-time legal assistants. In the past, we had 2.5, so essentially 2 full-time, 1 part-time.
Great. And just briefly, how would you describe the relationship between your office and Bremerton Municipal Court staff under Judge Doctor?
It was great. It was professional. It was cordial. Everyone got along, and the lines of communication were really easy.
And how well did the Bremerton Municipal Court function under Judge Doctor? And I just mean in terms of the, doing the business of the court as your experience as prosecutor.
It was hands down the best court I've ever practiced on.
And I mean, would you have considered Judge Doctor a great judge?
I think Judge Doctor's heart was always in the right place. There's no question about that. I think he, near the end, and I think he would admit that if asked, that he got a little grumpy. But he was always prepared. And again, I really think he always wanted what was best for the community, and that was evident in his preparation and the way he treated people in his courtroom.
Do you recall the staff that worked with Judge Doctor, not specifics, but just generally, do you have a recollection of them?
I do. Yeah, I got to know a lot of them well.
Did he have a good and competent staff?
Yeah, they were fantastic.
And thinking back to when Judge Flood first took the bench in January of 2022, what was your experience of how the court ran in terms of its just core functions within the first few months of Judge Flood taking the bench?
Initially, it was okay. I mean, most of the original staff were still there. There were some rocky moments for sure, I think, but overall, it was still functional. It didn't get bad until later.
Okay. Mr. Hersey, I want to ask you about whether you were in a position to be on the receiving end of any, first, just were you on the receiving end yourself of any lack of professional courtesy or inappropriate treatment from the judge?
Yes.
Objection.
Mr. Gross, what's the objection?
Leading.
Overruled.
And were you present when similar treatment was directed at any other attorneys in court?
I was.
Were you present when any of that conduct was directed at your coworker, Amanda Harvey?
Oftentimes I would be on Zoom observing, or if it was a particularly bad day, I would go back and listen to the recording because Amanda would often ask me to let me know what I thought about it. But it's pretty rare that we would both be in court at the same time because the other person would be working on offers and reviewing cases and things like that.
Do you remember having any incidents where the judge, specific incidents where the judge behaved inappropriately towards Amanda?
Sure. Yeah, there was towards Amanda. I can remember the judge telling her that she was being snide. This was a case where it was a pretrial diversion agreement, I think, that had been negotiated between the parties. Judge expressed some concern about it. I don't know what the nature of it was, but it resulted in some kind of back and forth between Amanda and Judge essentially lecturing Amanda on things like access to justice and things of that nature. And at some point, she told Amanda she was being snide. There was another time that comes to mind where Amanda was making a bail argument about a defendant.
Objection, best evidence.
Best evidence response.
I don't think best evidence, I don't think that's an applicable objection.
Yeah, I don't know, overruled.
You can continue just briefly, Mr. Hersey.
Sure. Yeah, there was another time that comes to mind where I remember Amanda was making a bail argument about a defendant who persistently failed to appear for court, including a trial date. And Amanda used the term scofflaw to scoff the law, and Judge scolded her and told her to check her bias. One thing that's obviously very common, I think, in my experience, is persistent interruptions, eye rolls, glares, condescension.
And these are things you have witnessed or heard?
Yes.
And shifting to ask about conduct that's been directed at you, are there examples that stand out for recency or severity in terms of that kind of conduct being directed at you?
I mean, I can recall feeling like I've been dressed down and lectured, and not given an opportunity to speak. One that jumps out was a trial that had been set, and the defense attorney, it had been confirmed the Friday before. It was the Tuesday coming up on the trial. This defendant's name was Floyd Dale Eccles, and this was back in December 2022. The defendant's attorney, Sean Mills, wanted to do a 1-week continuance so we could have some opportunity to review some jail calls that had been discovered, which would have been relevant to the charge of assault for DV and potential felony charges for witness tampering. So he called me Tuesday and asked to continue the case. I told him that'd be fine. He just wanted 1 week to review everything. I told him that'd be fine. But at the time in December, the court was really running on a skeleton staff at that point, after everyone had quit previously. So I sent an email directly to Judge Flood, as well as all of the clerks, advising them of the situation, that a previously confirmed jury trial was now going to be an agreed continuance. And that at the end of my email, I indicated that I would reach out to the jury administrator so that we wouldn't have a bunch of jurors showing up at the courthouse for an agreed continuance, as well as reach out to the police department, who would be responsible for transporting the defendant, because he had been held in custody at the time of his trial. I didn't get a response from the judge or any of the clerks all day, and then pretty much all day the next day until the very end of business, where I received an email from the court administrator advising that the defendant would be transported. And then come Thursday morning, we come time for the trial, and I remember Judge Flood just starting the hearing without talking to the attorneys, asking what the status of the case was, whether there was going to be a motion of some kind, but just starting off lecturing us, and lecturing me in particular, accusing me of canceling the jury, of canceling transport. And I was taken aback, because I was really in a position where I was trying to help the court. I was trying to help run efficiently, especially given how much dysfunction we had seen recently, and how few staff were remaining, and how no one responded to my emails. I was just hoping to be helpful. And then on Judge's own motion, she then moved to PR the defendant without even being asked by the defense attorney. So that was one of the examples where it felt like she was acting vindictively, and because I had taken some kind of control away from her. And again, my intentions were good. I was trying to help.
And did you try to explain?
I did.
And what happened when you tried to explain?
I mean, I felt like I was interrupted. I felt like I had to jump in to try to speak, because it was just the judge making a record, which in my memory was revisionist at best. And I wanted to clarify the record, for one. And, the defendant was there. He had been transported by BPD after all, of course. So I wanted to I don't know. I felt like my character was under attack. So I did feel defensive. I wanted to defend myself.
It- are there other episodes? I'm not going to ask you to describe them, but have there been other times besides that time when you felt that you have been on the receiving end of the same kind of treatment that you were just describing?
Yeah, I mean, it's hard to condense, nearly 3 years on the bench with Judge Flood. I mean, but there's been plenty of times where I'm interrupted, where I feel like I'm scolded. And yeah, and then judge will act vindictively if you try to confront her.
Let me ask you about the last comment. When you say that she acts vindictively if you try to confront her, what does that look like? How can you tell that she's acting vindictively?
Well, to give you an example, I can recall a couple cases with one of the public defenders, Ben Teets. He had a couple hearings. I feel like this was around the same time where the hearings were set for the purpose of determining whether or not the defendants had been hooked up on electronic monitoring as ordered in their sentence, or completed community service that would previously been ordered. And oftentimes what we'll see is if you get on the judge's bad side in a given day, the rest of the hearings that are contested after that will probably not go in your favor. And this was one of those mornings where Ben was the first one to, I think, irritate the judge. And he had a client coming in for EHM review for 180 days he was supposed to get hooked up on. He came into the courthouse and told Ben and told the court that he had been approved for hookup on EHM. And but the EHM company wasn't available to hook him up until Tuesday when all the equipment was ready, I guess. And so at that point, he was asking for an extension, and I had no objection. It was a reasonable request. This kind of thing happens all the time. And if the tensions are good, this is the kind of thing that's granted 100 out of 100 times. But on that day, it had been very heated, and I distinctly remember a judge saying, "No, you have until Monday or else you're going to jail." And that would have been an impossibility. And Ben Teets pointed that out. And at some point I jumped in and said, "Your Honor, we're also not asking to set this for Monday." Ultimately, judge set it for Tuesday at 3:30 instead. But that's the kind of thing that happens. I can also remember, one time where 80 hours of community service were due, and judge gave the defendant more time, but only until Monday, which would have been like in 72 hours. So it would have been an impossibility to get it done.
And are these things that only happened in terms of defense counsel when Mr. Teets was involved, or were there other defense attorneys who were sometimes the target of this?
No, I think Mr. Teets was probably most common because he was pretty litigious and will stand up for his clients more so than others in my experience. But I can remember Eric McDonald. He was briefly a conflict attorney with the court. He had been representing a defendant with the last name Rasmussen. And Mr. McDonald, when things went south and he moved to withdraw and terminate his contract, I think we probably had 5 or 6 hearings where Eric tried to withdraw and judge just wouldn't let it happen. And then ultimately she claimed that she didn't know he was trying to withdraw, even though these are all in emails. This has all been on the record previously before the judge. So no, I've seen it happen with Ryan Witt too. Ryan Witt has gotten to the point where he's filed notices of disqualification.
So,
I'm sorry, I withdraw.
And so just going back to Mr. McDonald, I think you said was the second attorney. Did you have the impression that the judge's actions towards him in not allowing the withdrawals, not allowing him to withdraw, were retaliatory?
I do. Because we had other attorneys withdraw and it wasn't an issue. But that was a really prolonged, drawn out process.
And is it your
objection? This is an improper opinion.
The objection is to an improper opinion, Ms. Rasnick.
Improper.
I'm sorry, what? Mr. Gross?
I'm sorry. I just wanted to clarify improper lay opinion.
Improper lay opinion. Ms. Rasnick?
I'm not asking for Mr. Hersey to present opinion testimony. For example, under Evidence Rule 702, I'm asking for his impression of what he observed, what he concluded based on his observation.
Yeah, I think, from my perspective, the witnesses set the foundation for having observed these, what he's testifying about, and his, the question asked for his observation about it. And I don't view the question as soliciting some sort of expert testimony regarding some sort of retaliation in some sort of legal sense. So I'm going to overrule the objection.
Just the same question regarding Mr. Witt. From what you observed, Mr. Hersey, did the judge's actions towards Mr. Witt, and you described, I think, dealing with notices of disqualification. Was it your observation that seemed to be retaliatory as well?
Sorry, was there an objection?
Yeah, same objection.
Should I answer or?
Same ruling.
Should I proceed?
Yes, go ahead, Mr. Hersey.
Sorry. So with respect to Mr. Witt, to give you an example, he had a client who was on for a diversion agreement review recently, and Mr. Witt had been filing notices of disqualification. Many of them have been refused to be signed by the judge, which ultimately the case resolved in front of the commissioner. But then when it came time to have the review to make sure everything was in compliance, that was again put, I think, on one of Judge Flood's calendars on a Monday. And then at that point, the defendant was in full compliance. So both Mr. Witt and myself, representing the city, both agreed that we didn't need any future hearings. In that case, the judge overruled that and said, no, you need to come back another time to make sure you're making payments on the PDA, which is just outside customary practice. We will routinely just check for payments at the very end. And when people need more time to pay at that point, we'll often just agree to let them pay more, have more time to pay, or do community service. So it was pretty, I guess I would say it's very inconsistent.
Okay. And during these times that you're remembering when the judge interacts with attorneys in this way, is she raising her voice at the attorneys?
Sometimes it's just glares, eye rolls, things like that.
Since you started practicing, since Judge Flood took the bench, you mentioned a couple of minutes ago that when she started, there was staff there who had been working under Judge Doctor. Do you have recollection of the staff that kind of transferred over to Judge Flood's tenure from Judge Doctor? Like, do you remember in your mind who was there?
I do.
And since Judge Flood took the bench, have you noticed what you would consider to be significant turnover in Bremerton Municipal Court staff?
Yes.
Are there any of the folks who were originally employed by Judge Doctor around?
No, everyone who was originally from Judge Doctor's, I guess, administration, quit or retired. And then many of the replacements have since quit.
Objection, personal knowledge.
The objection is foundation. Ms. Rasnick, I'm willing to sustain that objection. I think there's been marginal foundation set for the reasons.
I can get there. Mr. Hersey, have you interacted regularly with the staff in municipal court over the couple of years that since Judge Flood has taken the bench?
I have.
And are you familiar with the folks who have come and gone? Have you taken note of the folks who have come and gone since Judge Flood took the bench?
Yes, I have.
And based on what you have observed and experienced and your familiarity with the staff, would you say there has been significant turnover?
Yes.
Has the
Asked and answered?
Yes.
Is that the objection?
Yes.
Okay, sustained.
Has the court to you appeared to be understaffed at times?
Oh, definitely.
And do you have any personal knowledge of staff members having decided to leave the court because of the judge's treatment of them?
I mean, yeah, I do based on conversations with them.
Any that you can,
Objection, this is rooted in hearsay.
just that I'm not asking you to describe their statements to you, but your understanding of their intentions in leaving the positions or moving on.
Yes.
Objection. Any answer to this is rooted in hearsay.
Well, I disagree that any answer would be rooted in hearsay. At this point, I'm going to overrule the objection, but Ms. Rasnick, walk carefully.
Okay. Are there particular staff, just the names, that you have an understanding left because of interactions or because of their treatment by Judge Flood?
I mean, pretty much everyone who was there originally. So, and to be clear, I mean, I think people leave jobs for a lot of reasons. I think it's a very least a major contributing factor. So I want to speak with that caveat. But my understanding, you know, there's Dawn, of course.
Is that Dawn Williams?
Dawn Williams, yep. There was a clerk named Kathy, Heather.
Objection. We can now see that this answer is rooted in hearsay.
Identifying the people who have left, overruled at this point.
Okay, well, I'm sorry, may I make one statement?
Let me, Mr. Gross, it's hard for you to, it's hard to understand because you're a phone, but let me pose the question to Ms. Rasnick. I believe Mr. Gross is objecting because he believes that any information known by this witness about the reasons why these individuals would have left would be statements to him. And if he testifies as to his understanding, that in of itself is hearsay. What's your response to that?
I can inquire further of the witness about the basis for his understanding.
Okay.
Mr. Hersey, do you have an independent basis for your understanding of the reasons for any of these witnesses' departures beyond their statements to you?
Well, I mean, some have called me in tears. It's not hard to make that connection. Some have told me, sure, that the reason they've left is because of poor treatment. Others, I mean, we are notified by the HR department when someone quits. We get notice when there's, sorry, go ahead.
Objection.
Mr. Gross.
And I'm objection because he clearly testified to things he knows because of hearsay, and I move to strike that.
The statement, which specific statement are you asking to have stricken?
I believe he just expressly said that some have told me that the reason they left was because of Judge Flood.
Yeah, was that tied to a particular person? Ms. Rasnick, your response?
I am prepared to ask Mr. Hersey a different question.
Okay.
At this point, I did not hear Mr. Hersey identify witnesses who had told him the reason for their departure, but I would rather ask him a different question.
All right, let's move on then.
At this point. Which attorneys, or not which attorneys, which court staff called you in tears?
I guess starting with Dawn Williams.
Anybody else besides Dawn Williams?
Oh yeah, Serena Daigle, Cindy Hope, Heather Hunt. I don't know if Martita was crying. She was very upset when I talked to her. Ian Cohen several times. Stephen, I believe.
Is that Stephen DeRozier?
Yes. Yeah. I don't know if Jennifer Johnson was ever crying. She was definitely despondent several times near the end, as was Maury.
Is that Maury Baker?
Yes, sorry. Trying to think. I think that's it as far as
Okay, thank you.
comes to mind.
That was the question. Um, has the turnover in court staff since Judge Flood took the bench affected the court's functioning?
Yes.
Let me ask you about some specific issues about the court's functioning. And I'm going to ask you about the issues so that we can move through this topic in some kind of an organized fashion, mindful of the limited time that we have this afternoon. Have there been issues with docketing since Judge Flood took the bench? If you could just, let me ask first, why is it important? Why is docketing important, briefly?
Sure. So docketing is something that is done by the in-court clerks, which reflects what happened in any given hearing, and it reflects future upcoming court dates. It will also, an analog to docketing is entering things in JIS that reflects things like active no contact orders, active bench warrants. And essentially JIS is the Judicial Information System, which runs in conjunction with what we call JABS, which is the Judicial Access Browser System, which is used as a cloud-based platform for attorneys and criminal justice participants to log on and see what's on the calendar for any given day. You can search by defendants to see how many active cases they have, if they have any warrants, any orders, and when you can look by looking at docket entries to see exactly what happened in a given hearing.
And what's the harm if the docketing? Well, let me ask first. What was the issue with docketing? What has been the issue with docketing that you've observed in Bremerton Municipal Court?
Everything from delays for docket.
I just want to register an objection at this point under ER 403 that this is not relevant. If it's relevant, it's very minimally relevant, and it's a waste of time, especially given the small amount of time we have.
I think this is squarely relevant. This is a sanction hearing. The court has to weigh a number of factors to make a determination about the magnitude of the misconduct and the appropriate sanction for it. And one specific factor is the impact of the misconduct. And we are talking about, Mr. Hersey was asked specifically about impact on the court's functioning.
Ms. Rasnick, I understand. I'm going to overrule the objection. Go ahead, Ms. Rasnick. Ask your next question.
Yeah, Mr. Hersey, were you finished describing the issues with docketing?
No, I mean, I think, what we would see is because at a certain point, the court became so backed up, they were really behind on docket entries. And if you're behind on docket entries, then cases don't make the calendar. And we would see times where dockets would be 3 to 4 weeks behind. We would see a lot of times where docket entries were just wholly incorrect, where dispositions were entered improperly. And these things matter to anyone who works in another jurisdiction and is trying to track the status of a case to see, well, we had a motion to revoke pending to see if the case resolved with a guilty plea, and all of a sudden what was once a guilty plea now shows as a dismissal, or they're trying to see if orders are active or if someone lost the right to possess firearms somehow. And we've had cases that show that no, the case was dismissed when in fact they were convicted, and that was the only thing that resulted in them losing their firearms rights, as well as there should be an active no contact order that's just missing.
All right, let me ask you, move on to the next issue. Has there been an issue with hearings being mislabeled in the court system?
Yes, so essentially.
And let me ask you first, why is it important briefly for hearings to be labeled correctly?
Yeah, sure. So on any given calendar, you may have a whole different variety of hearings. You could have arraignments, pretrial hearings, sentencing hearings, sentence compliance hearings, probation violation hearings, which are called fact-finding, sentencing on probation violation, competency status. And when you're looking at any given docket, you can scroll down and you can get a feel for what, just initially it will tell you some baseline information, assuming it's accurate, that you're here for a pretrial hearing. So for example, you have to be cognizant of what speedy trial expiration is, and things like that.
So from the way the hearing is logged into the system, it's important information for the attorneys and the court to have in terms of what to be prepared for.
Exactly.
Okay. And in your experience, have hearings at times not been labeled correctly during Judge Flood's tenure?
Yes, very often.
And just maybe one example or one or two short examples of the way hearings can be mislabeled?
We had one just the other day that comes to mind where a defendant had 4 different cases. 2 of them were post-conviction and 2 of them were pending pretrial. So they should have been labeled to pretrial, to fact-finding. They were all labeled as fact-finding. And when you're dealing with like a really busy calendar, especially on the jail roster where cases should be moving kind of quickly to get everyone heard, if you think that everything is post-conviction, then you're not going to be checking on speedy trial. So you have to be hyper vigilant to make sure that it is labeled correctly, just as an example.
Okay. How about exoneration of bail bonds? Has there been an issue with the exoneration of bonds since Judge Flood has taken the bench?
Yes, there has.
And why is that a problem? Well, let me ask that. I'll withdraw that. Was there a change in the procedure for the way bail bond exoneration was handled after Judge Flood took the bench?
No, I mean, not that I'm aware. The only change I can think of is for pretrial diversion agreements. We did explicitly add a line saying bail bond is exonerated when we updated our forms, just to make sure that there was no confusion. Because otherwise, you know, the bond could be held for upwards of two, maybe 4 years, depending on the length of the diversion agreement.
Okay. Let me, are there some documents that I might be able to show to you to refresh your recollection about on issues about exoneration of bonds?
Sure.
Let me direct you to those real quick. Hang on just one second. Here's my screen. Here it is. Mr. Hersey, I am sharing with you a document that's been identified as Disciplinary Counsel's Exhibit 239. So let's just scroll down and let me know if this refreshes your recollection.
It does. I remember this case.
And is Gangle the last name of the defendant in the case?
Yes.
Okay. Let me take the document down. Okay. So you had indicated that your recollection was refreshed by the document. Is that right?
Yes.
And so with that, what would you want to add to your answer about whether there's an issue with exoneration of bonds?
Yes, I do remember this example. This was a defendant who entered a diversion agreement, I think in May of 2024. When she entered the PDA, it includes a separate agreed order of continuance, which includes that line saying that the bond is exonerated. Apparently that was not done because then we received an email from one of the court clerks advising that the party who posted the bail was inquiring about how to get their money back. And I guess she asked Lisa Hardy, who was another clerk, what to do, and had emailed my office. And at that point, we advised that the bond should have been exonerated months ago, and they should be refunded their money. And there is no need to set a separate hearing.
Okay. And the import of what had been communicated to you was that the court was requiring a separate hearing to be set on the issue of the bond exoneration?
Yeah, I'm not sure if it was a lack of training, why they thought that was necessary. But I mean, Lisa Hardy was at that point one of the most, I think, senior employees in the current staff. And so yeah, to require a whole nother hearing for something that they should have had back months ago, obviously would have been improper in my view, because they were entitled to have their money returned already.
Have there been issues with notification of the Department of Licensing about driving related convictions, IID requests, license restorations, that kind of thing?
Yes, that's been a persistent issue.
And has your office, the prosecutor's office, had to take steps because of that issue?
Yeah, we have to go kind of out of our way to check the defendant's abstract of driving record to, for example, if a pretrial ignition interlock is ordered or lifted, to make sure that that was communicated to DOL. So that way, if someone is out driving without a restriction that's required by the court, if an officer were to pull them over, they'd be able to see that. And you know, the other common example is if you're convicted of something like DUI, which comes with mandatory license revocations, depending on the nature of the DUI, then at that point that needs to be communicated to DOL as well. And we saw, I mean, this isn't something that we were auditing necessarily, but just when we would come up on compliance hearings, try to catch and see and make sure that's done. But a lot of times it just was not done at all.
And was that a difference from your experience when the court had more experienced staff?
Yeah, I never saw that problem before.
And has there been an issue with entry of, let's talk about no contact orders for a second. Have there been issues with no contact orders, including communications to the police department or other issues around no contact orders and rescission and modification of no contact orders?
Yeah, there has been several issues. I think the first big issue that came up with respect to no contact orders was the court just did not have any written policies in place for a very long time for victims to know what the process was for how to ask to petition for rescission or modification. And this was something I had sent countless emails to Jennifer Johnson and court staff as directed by judge to try to get that issue resolved because we would have victims contacting us all the time. And then the separate issue came about with the court not sending no contact orders to law enforcement so it could be entered into state and national databases. So they know, one, when a no contact order is active, and two, just as importantly, when a no contact order is rescinded or modified.
Are you able to recall specific cases where no contact order rescissions or no contact order not being sent to the appropriate parties has resulted in problems that have been reported to your office?
Sure. I can think of, I mean, there were many examples with victims contacting us saying they never received a copy of the certified no contact order, which is one of the duties of the court. So they have a copy of that. But with respect to no contact orders not getting to BPD, that happened a lot under the law. It has to happen by the next judicial court day. And
we're just gonna ask if there were some documents I could show you that might refresh your recollection a little bit better about that.
Oh yeah, sure.
Okay. I am going to share. Okay. I'm going to share what has been identified. Let's see, we've got here what has been identified as disciplinary counsel's exhibits 245 and 246. And let me just take a scroll through those. It looks like a email exchange with your name on it from August 2024. And then there's a docket. Looks like for the same case. Does this refresh your recollection about a no contact order issue?
It does. This was a fairly.
I'm going to take the document down.
Okay. Mr. Gross?
Objection. I don't believe Mr. Hersey said anything about not remembering something that would require his recollection to be refreshed.
Ms. Rasnick?
My recollection is that he indicated that he did not recall the specific cases with particularity.
Yeah, unfortunately, I don't have real time to be able to go back and see exactly what the testimony was. If Mr. Gross, do you have a different recollection from Ms. Rasnick?
Yes, I don't remember him saying that or that question being asked.
Okay. I can ask another question if that would help.
Ask another question.
Okay. Mr. Hersey, do you have recollection of the Gardner case, the case involving Jaden Gardner?
I do.
Okay. What is your recollection of the issue involving Jaden Gardner?
So Jaden Gardner had some criminal charges, which resulted in a domestic violence no contact order being put in place, protecting his parents. He was a young man, early, I think, late teens, early 20s. In any event, the family had been in contact with our office and said that, well, we really just want to get Jaden some help and we want to have this rescinded. So we were on board with that once we had the case resolved, of course, and we helped guide them through that process. The no contact order was rescinded, I believe, August 7th. And then in the interim of that, that had apparently not been communicated to BPD because in the interim, he had been pulled over for driving on a suspended license. And the officer noted that he was driving the protected party's car because the officer, when they ran his name, it came back with an active no contact order out of Bremerton Police Department. And it also showed that the no contact order, the original no contact order, had never even been served on him, which also wasn't true. He had been served and was well aware of it because the case had resolved. So at that point, the officer got a copy of the no contact order, served him with it, and told the defendant that he could not have contact with his mom, and advised him he probably shouldn't be driving his mom's car either. And in any event, so that example really just highlights, I think, some of the potential consequences. Fortunately, he wasn't with the protected party or the formerly protected party, I should say, at that time, because that otherwise would have resulted in his arrest.
Thank you, Mr. Hersey. Do you recall the Rodriguez case, the case involving Edric Rodriguez from April of 2024?
Yes, that does ring a bell. That was a similar situation. In this case, I don't recall, I think it was a modified no contact order. It was originally done, the order was modified on March 29th of 2024. And my office had changed our practice because this had happened so many times where we would proactively email BPD to make sure that they were aware when these things happened. And they were kind of keeping us updated when they actually finally received it. In this case, it wasn't received until 18 days after the no contact order was modified.
And why is it a problem that it wasn't received until 18 days after the no contact order was modified? Just so that it's clear, why is that a problem?
Well, let's say the no contact order is modified in a way that allows the parties to be in contact on Tuesday nights for a kid's soccer game or something, and then defendant goes to the soccer game, someone calls 911, or either just happenstance come across a police officer. In the state of Washington, there are mandatory arrest laws for domestic violence offenses, such as violating a no contact order. And if law enforcement doesn't have access to the current no contact order to verify its terms, they will, by law, have to arrest. And it could result in someone being held on a no bail hold. Depending on when they're arrested, they might not see a court until, if they're arrested on Friday night, they won't see a court until Monday morning. So the risk of obviously civil liability to the city is huge. And also, you just, on a moral, practical matter, you obviously don't want someone arrested under those circumstances ever.
Did your office take to auditing the case files or spending additional time to kind of watch this issue to flag these problems when they would come up?
Yes, it had happened so frequently that I asked my legal assistant to just stay in contact with BPD, let them know when orders are rescinded or modified, just so they're aware.
And to be clear, before the turnover began, the period of turnover of staff that you testified about, that was not something that you had to have your staff do.
No.
And having your staff do the kind of what I would call bird dogging of the NCOs and those kind of issues, has that resulted in some other cases, coming to light where BPD was not notified?
Yeah. I mean,
do you have a specific recollection, for example, of the Kelsey case, the Camille Kelsey case
Oh, yeah.
from? Okay, go ahead.
This was a case where it was a domestic violence charge. The case had been set for trial. I believe the victim had been uncooperative, and without the victim's cooperation, it was a case where it wasn't provable. So what we have is called a readiness hearing in advance of trial, which is held the Friday before the trial. That's scheduled on the following Thursday. And the case was dismissed without prejudice. With that dismissal order, the no contact order obviously was rescinded as well. My office, the following Tuesday, sent an email to the BPD records unit to check if they received the dismissal order and the order rescinding, and it was not received. And then at that point, we notified the court administrator, who advised that they were waiting on the judge's signature.
These cases that you've testified specifically about NCOs, are these the only cases where over the last couple of years where there have been issues?
Oh, no. These are just some examples that come to mind.
Okay, all right.
This thing happens fairly frequently. I couldn't put a number on it. There are ebbs and flows. I think what we'll often see is
I think the objection was non-responsive. I'm going to sustain the objection.
Okay. I'm going to move on just in the interest of time. Have you also become aware of any issues with the issuance of restitution payments to crime victims since the staff turnover period started?
Yes.
Were you aware under the prior judge's administration? Were there ongoing issues with payment of victim restitution checks?
No, it had never been an issue to my knowledge. I know it was done. Checks were essentially cut at least once a month. I think it was every month was this court's practice under Judge Doctor's administration.
Okay. Are you familiar with a defendant, Celestino Martin Cruz, and an issue with restitution payments to the person who was entitled to get the payments in the Cruz case?
I am.
Could you just briefly describe what you recall of the issue in the Cruz case?
So this was one that came up fairly recently. We had been tracking. This was a private victim who had had some property damage as a result of the crime. I believe it was a DUI. The defendant had been making payments. There were two payments, one in May of $200, another one in June of like $300. And this is something my legal assistant has had to track as well recently.
Let me just pause right there. So you're also, the prosecutor's office is also having staff track restitution payments?
Yes.
And is that something that you've had to add? The prosecutor's office has had to add this to your staff's plate?
It is.
Okay. So yeah, but was it because of your staff that the issue with the payment to the victim of Celestino Martin Cruz came to light?
Mm-hmm. Yeah.
And what action did your office take any action after having discovered the issue?
Yes, and I think I misspoke with respect to the dates. This case, I remember, actually goes back to 2023, and we continue to track it to this day because there's still an outstanding balance. But there had been payments in April, May, June, July, August, September of 2023. And so essentially, I think it came out to be about $730 that was in the court's possession, but not given to the victim, because sometimes the victim, and I think in this case, had contacted us and said, wanted to know the status.
Okay. How about, do you have any recollection of the Crystal Amundsen case? And in which there was also an issue about restitution not being sent out?
Yes, this was a similar situation. I remember we came across this back in February 2024. There had been another case where there was outstanding restitution owed to the victim, and the defendant had been making payments pretty regularly since March of 2023. But you can tell from looking at the docket that there was nothing reflecting that any checks had been made as of February 2024 that went out to the victim. And I think everything had been paid off. So essentially the victim would have had money that was waiting for them that would have theoretically made them whole, right? That had not been dispersed.
So from looking at the docket, for example, from the Amundsen case, it appeared that the defendant had made the payments. And so was the money sitting with the court?
Exactly. And then I emailed the court administrator and advised her of the situation. And at that point, I hope a check went out.
Who was the court administrator? Do you recall who the court administrator was you emailed about it?
Ms. Rowenhurst.
Because it was this year, 2024.
Yes.
Okay. Let me ask you if there have been issues with competency evaluations, orders for evaluations of competency or restoration orders. First, the question is just, have there been issues that your office has noticed with competency evaluation orders or restoration orders since Judge Flood took the bench?
Yes, there have been.
And just a second question, what generally is the issue or are the issues that you've noticed?
Yeah, sure. So just for some background, so a competency evaluation is done if a defense attorney generally has concerns about their client not being competent to stand trial. That is done here in Bremerton through Western State Hospital. If someone is in custody, a doctor from Western State will go visit them at the jail. By statute, once you raise competency, if someone is in custody, it has to be done within 14 days. So that's the one common component of competency that we see. Otherwise, if someone is found incompetent, but the doctor in the court ultimately finds that what's called restoration should be ordered to try to bring this person back to competency because there's a compelling state interest in doing so, and it seems feasible within 29 days, then at that point, competency restoration can be ordered, which at that point, the court has to communicate with Western State in both of these cases to send these orders to Western State to make sure they're being done in a timely manner, because both subsets of actions have strict statutory timelines of 14 days and 29 days respectively.
Were you at any point aware of an issue with the delay in these orders getting signed?
Yes. I mean, that's, again, I'm not in the back of the courthouse to know for sure, but that's what we have learned from emails, that sometimes there's delays in things getting signed.
Objection, hearsay, personal knowledge, foundation.
Okay. I'm going to continue with some more questions that will tie that up.
You're going to tie it up with foundation? Is that?
I mean, I can go back and get at it in a different way, certainly.
Okay.
Okay.
I would at this point ask that my objection be granted and that be stricken.
That he's requesting well, okay, all right. Well, Ms. Rasnick, if you're saying you're going back, I will sustain the objection, and I guess we'll strike the answer to the extent that the witness appeared to be talking about things he learned from conversations.
Okay. Mr. Hersey.
I'm sorry, Your Honor. I just wanted to note in terms of our timing issue, as we're going through all of this and there's been an objection, all of these things are potentially, all of them are clerical duties. So I don't know why we're taking all this time in this case where they made certain allegations against the judge. But we're going to have problems with our witnesses, and I just want to raise it now while we're in the middle of it. You've got somebody here who's testifying with a lot of speculation, a lot of conjecture, and about things he cannot tie to our judge. And I just want to note it now because it's 4 to 4 and we don't have much time left in the day. And we had stipulated 1 day each side. So that's all I have to say. And I'll be quiet. Thank you.
Ms. Bremner's made comments for the record. Ms. Rasnick, please continue.
Sure. Mr. Hersey, you testified about some changes in practices your office had made as a result of some of these other issues. Has your office also changed its practices because of the issues with competency evaluation and restoration orders?
Yes, we have. In the prior administration, the probation officer would send everything directly to contacts at Western State, including all the police reports, everything, and then contact us if he needed any additional discovery to send. Since the new administration has taken over and given all the turnover, we've changed our practice of always contacting Western State directly whenever we can to make sure that they've received the signed order.
And so again, that's additional burden that has had to be shifted onto your staff, whereas previously it was a task that the court was performing.
Yes.
I'm just going to ask about whether you recall a couple of examples. Do you recall a defendant whose, I think his last name is Daniel, the first name is Henri Daniel?
Yes.
And do you recall whether there was an issue in Mr. Daniel's case about competency evaluation or restoration?
Yes. In this case, I think his first name was Henri and last name Daniel. But anyway, he was found incompetent, and the parties had an argument for restoration. And in that case, restoration was ordered, and this was trying to find exactly when it was. I believe it was late last year.
I mean, if there are, if you would assist, I can, if there are some documents that I could direct you to that would help to refresh your recollection, I'd be happy to do that. Are there some documents that would assist?
There certainly are.
Okay.
I know there were several emails on this.
Let me just grab those. Apologies, it's taking me just a second. Okay. All right, Mr. Hersey. Can you see there are some, what I have up and what I'm sharing right now is what's been identified as Disciplinary Counsel's Exhibit 261. Let me just scroll down to the bottom.
I do remember this now.
Okay. All right. Let me stop sharing. What was the issue in Mr. Daniel's case?
So essentially, restoration was ordered at the end of December 2023. That allows for a 29-day period of restoration. The court signed off on the order, I understand, but the order was never sent to Western State. So what we did was when the order was originally signed, there was a status hearing. Approximately, I think 26, 27 days after maybe coming up on January 26th. I had not seen any updates from Western State, which I thought was odd. So I emailed the Western State directly. They advised they had never received the order at all from the court. And the defendant essentially was sitting in jail for 30 days with no progress at all towards a bed date.
Okay. Separately, a separate case I want to ask about, do you have any recollection of the Sarabur case?
I do, yeah.
Okay.
Yeah.
What do you recall of the Sarabur case? First, was there a similar issue regarding a restoration order in that case?
Yeah, there was a similar issue. This was a bit more complicated in that Ms. Sarabur had two different cases. And
Object. Going to object again under ER 403.
Overruled.
Go ahead, Mr. Hersey.
Thank you. So the defendant had two different cases. The city argued for restoration on both. In the process of arguing for restoration, the way it works procedurally is you file an objection to dismissal. And then along with that, you send proposed orders. So the proposed orders had both case numbers. They end in 04 and 06. After argument, the judge ordered restoration on, I think it was the 06, but not the 04 case. So at that point, though, 2 days went by, and we had assumed that the order had been sent to Western State with the simple modification of crossing off two numbers that we had been proposed. But we were contacted by the jail asking where there was a dismissal order for the 04. And that had not been generated by the court. And there was, I think, 1 or 2 days of emails back and forth with this passive aggressive blame game about who was responsible for this, rather than just sending the order to Western State as soon as the problem was caught. So that was 2 days lost that could have been going towards restoration.
Right. And these specific incidents that you're testifying about competency and restoration orders, are these the only cases where this has been a problem over the last couple of years?
No, not at all. I mean, this happened just October 10th. Another defendant named Angela Wilson. The court didn't send the paperwork to Western State. She sat in jail for 14 days longer.
Non-responsive.
Non-responsive. All right, sustained. If you want to ask a follow-up, he answered the question narrowly. If you want to ask a follow-up question, Ms. Rasnick, you can.
Sure. Is there any other more recent case that comes to mind where this issue of sending orders to Western State has been an issue?
Yes, Angela Wilson a couple weeks ago.
Yeah.
Defendant.
Non-responsive.
Okay, sustained, Ms. Rasnick.
Do you recall the Angela Wilson case?
I do.
Can you describe your recollection of the Angela Wilson case?
Competency evaluation was ordered on 9/26. It was never sent to Western State. The defendant sat in jail until October 10th, and then I think she's still in jail now awaiting the evaluation if it hasn't happened already.
All right. Thank you. I'm going to move on to another topic. Have there been issues with warrant quashes, warrant recalls, and the police department being notified of those since Judge Flood took the bench?
Yes, many.
And is this something that your office has also devoted staff time to monitoring?
We have, because we want to make sure no one is arrested on a warrant that has been quashed, and we try to do our best to stay on top of that.
Okay. Was it who handled under the practice under Judge Doctor's court? Briefly, what was the practice? What was your expectation in terms of the warrants getting transmitted to Bremerton Police Department? How quickly did it take for that to happen?
It was, in my experience, always within the same judicial day, maybe the next day. So if a warrant was issued or a warrant was quashed, it was
personal knowledge.
Is this a sure? Do you have personal experience? Did you have personal experience from your case practice in Bremerton Municipal Court during that time period that would allow you to recall how quickly warrants were typically notification of warrants was typically provided to the Bremerton Police Department?
Yes.
And from that personal knowledge, how quickly was the Bremerton Police Department typically notified of warrants and warrant quashes and recalls?
Within the same day or the next judicial day, in my experience.
Okay. And currently, is it your experience that the Bremerton Police Department is being notified the same day or the next judicial day about warrant quashes and recalls?
Objection, personal knowledge.
Overruled.
Go ahead.
Based on my personal knowledge, no, it is not done consistently.
Do you recall the Glover case? Is that a case that that you recall, the Albert Glover case?
I do, I recall well.
Was there an issue? Well, let me ask, do you have personal knowledge of the Albert Glover case? Are you testifying from your personal knowledge?
I am.
And based on your personal knowledge, what was the issue in the Glover case?
So Albert Glover had a pending criminal charge. He missed court. I think it was late July of 2024. He came in and had the warrant quashed. He set up a hearing to quash the warrant. The warrant was quashed in early August. I want to say August 2nd, 2024. He, at that point, had a new pretrial hearing set in late August for which he appeared. And then I think 3 or 4 days after that, he was arrested on the warrant that had already been quashed by Paulsbo Police Department, at which point, during his arrest, he tried to tell them that his warrant had been quashed, and but the warrant was confirmed because the warrant quash had never made its way to BPD, so it showed as active. So he was placed under arrest, at which point Paulsbo Police was apparently concerned enough to place stop sticks behind his vehicle because they thought he was going to flee. He was placed under arrest, and then one of the officers tasked with moving his vehicle off the roadway didn't know about the stop sticks apparently, and then resulted in his tires being popped. And then Mr. Glover paid a bail bondsman to bail out on a warrant that he already had quashed and appeared in court the next day.
Right. Is the Glover case the only case of which you have personal knowledge where an issue like this has arisen?
No, I mean, the flip side to this is also we've seen many times where warrants were ordered but not sent to BPD, and they never made it into the system. And we found defendants who went in and out.
Is not responsive.
Can you give some examples, Mr. Hersey, of cases where that issue arose?
Yes, to give an example, there was a defendant named Nicholas Braden. He had a warrant issued when he failed to appear for his arraignment after a summons went out. The warrant had been outstanding for months. We came to learn after the fact when we got notice that he passed away from overdose, that he had been in and out of the county jail on other holds on a case out of district court, but no one was aware that he had a warrant that should have been in the system in Bremerton. And that was a case where had the warrant been active, we, given the defendant's history, would have asked for bail and likely would have asked for an in-custody evaluation to go directly to treatment. But because it was not in the system, he was released to the streets, and he died 3 or 4 days after his release from a drug overdose.
Thank you, Mr. Hersey. I'm going to move on to the last of these specific issue areas. I want to ask about the monitoring of individuals who are subject to, let's say, post-conviction monitoring, any other kind of monitoring requirements. Say prior to Judge Flood taking the bench, whose job was it at Bremerton Municipal Court to do that kind of monitoring?
It was a combination of Ian Cohen, who was the probation officer, and primarily Cindy Hope, who did most of the post-conviction, what's called clerks monitoring and pretrial diversion agreement monitoring, deferred prosecution monitoring, things like that. And sometimes some other clerks as well would assist, but they would be checking for treatment reports to make sure, 1, that someone is in treatment as they're required to be, 2, the absence of treatment reports in the event that we just stop receiving reports, and 3, of course, new law violations. If someone has new law violations in other jurisdictions, they check for that and notify us, and we can at that point decide whether or not a motion to revoke is appropriate to file.
So it sounded like you were making a distinction between court monitoring and then like another type of monitoring. And is that what the second type, is that what you think of as active monitoring?
That's what it was most commonly called, active probation. Those tended to be the defendants who needed a little more support, a little more help, and a little more closer monitoring. So in addition to, having whatever the judgment and sentence or diversion agreement may entail, whatever it may be, they would be meeting with the probation officer, be subject to random UAs, things like that.
And with
Your
regard
Honor,
to the,
Your Honor, I have a motion.
You have a motion?
Yes. I'd ask Your Honor to take steps to ensure that I have sufficient time to cross-examine this witness before Ms. Rasnick's 5 p.m. hard stop. I'd ask that Your Honor to put her on a 5-minute time clock.
Well, I'm not going to put Ms. Rasnick on a 5-minute time clock, but Ms. Rasnick, what is the nature of your 5 o'clock hard stop?
the witness has a 5 o'clock hard stop. This witness has a 5 o'clock hard stop today. I mean, we can ask Mr. Hersey if he can give us an additional 15 minutes, perhaps. That is the nature of the 5 o'clock hard stop today.
And how much longer do you believe you have with your direct?
I probably have another 15 minutes.
Okay, well, let's see how far we can get. But at this point, I'll deny the motion to put you on a 5-minute clock, but let's move it along, Ms. Rasnick.
Okay. And so the question I was going to ask, what's your recollection, Mr. Hersey, of what the practice was about reporting to the prosecutor's office with regard to folks who were under active monitoring? How often, what did that reporting look like?
With respect to reporting to my office, if everything was going well in active probation, we wouldn't be notified. It's just no news was good news. But if anything was going wrong, we would be notified immediately by Ian Cohen.
Okay.
That would come in the form of a, I should say, a violation report that's generally sent via email indicating what the issue was.
And was there a type of monitoring that resulted in a report that would come like on a specific frequency, monthly, that kind of thing?
Yeah, so with respect to monthly reports, those would come in from the court clerks, whoever was assigned to it, generally Cindy Hope back in the day, and that would come every month without fail.
Okay. Once Judge Flood took the bench and the after, let's say, during 2022, was there an interruption? Did you personally become aware of an interruption in the prosecutor's office's receipt of the reports?
Yes, I mean,
could you describe the interruption that you have personal knowledge of?
from my personal knowledge, it was twofold. I mean, I guess after Ian Cohen quit, there was several large gaps where we would not get anything with respect to people on active probation. And then after another probation officer quit or was fired after him, I don't know the circumstances of her leaving. Then there was another gap after that. With respect to post-conviction monitoring that used to be done by the clerks, after the original clerks quit, we get violation reports extremely intermittently, and they tend to only be, in my experience, for when there is a non-compliant treatment report. What we have not received, I think, with the exception of one case, since all of the original clerks had departed, was any violation reports notifying us of new law violations.
So just to clarify, is your testimony that your office still is not receiving reports of new law violations?
Correct. At least with respect to the clerks monitoring. With respect to active probation, that might be a different circumstance, but clerks monitoring, yes, I can think of one case in the last couple of years that we've been notified where there was a new law violation.
Do you know who the staff person is at the court now who is responsible for doing this monitoring?
No. I think I do know we receive emails from.
Let me ask a different question. Is it concerning to you that you?
Ms. Rasnick, I just interrupt. Mr. Gross, just understand, whenever you object, it's just garbled. It's garbled. There is actually no discernible words that are coming out when you're objecting. It makes it difficult to either stop the answer or to understand the nature of the objection. I do hope that your side will improve the technology. I'm not blaming you. I'm just suggesting that part of the problems with your objections and to be able to rule on them promptly is because they're non-audible. I mean, I can't hear them. Okay. So with
All right,
that,
thank
Ms. Connor, you have your hand up?
I do, thank you, and I apologize for the interjection, but this has been an ongoing issue since the beginning of the hearing. And I will note that the IT specialist for the Commission on Judicial Conduct, Mr. Cooper, has reached out to Ms. Bremner's firm and has some proposals for ways that the audio could be improved. I would strongly recommend that at the close of the hearing, there be some consultation so that we can overcome this issue.
So with that, let's continue though. We are on a clock.
Okay. Mr. Hersey, has your office also made changes in its practices to devote some of your staff's time to monitoring this issue?
Yes. I can tell you we are actively checking the jail roster.
Objection, non-responsive.
Mr. Hersey, can you describe for us the steps that your office has taken to have your staff assist in resolving this issue or filling the gap, as it were?
Right. I mean, well, first and foremost, we've sent countless emails to the court administrators over the years, different clerks asking what the status is of these things, the probation department. And we don't always get responses of any kind. And so that's the first thing we've done. Second, one of the things we do now that we didn't do in the past was we are actively checking the daily jail roster report. And it's not an easy process because we're just checking names and seeing if we happen to recognize any names with anyone who has active cases with us or post-conviction cases with us, whereas we would have been notified in the past that someone has new charges. Now we have to rely on that.
All right. Let me ask go in a different direction. You mentioned having sent emails to the court about some of these issues, and my next area of questioning was going to be what efforts have you made to make the court aware of these issues that we've talked about?
There have been many. I remember, I mean, it started to get, I think, pretty bad, obviously, after once the original clerks had left. And once Jennifer Johnson was hired to start, I think that was fall of 2022, even before her first day, she reached out to us and met with us before she even started. And I gave her a long list of issues that we were seeing. I know we met again in January of 2023. We've requested all sorts of things from the court via email, notified the court of docketing issues via email. We brought these issues up and attempted to bring these issues up in criminal practice and procedure meetings when we used to have them. We haven't had one in about 6 months that's been hosted by the court. My attempts to bring this up directly to Judge Flood have largely been shut down.
And a criminal practice and procedure meeting, who would attend those meetings?
Generally everyone from my office, the judge, of course, court administrator, the commissioner, the public defense office, any other attorneys are generally invited who take a number of cases in the court, and various court staff, probation officers, things like that.
Okay. Mr. Hersey, I'm going to show you an exhibit very quickly, showing you what has been identified as disciplinary counsel's exhibit 233. Let me know first if you recognize this document.
I do.
And is this a document that you sent to Jennifer Johnson in April 2023?
It is.
Okay. I'm going to ask that this document be admitted into evidence.
Exhibit 233 has been offered, Mr. Gross.
Well, at this point, I guess I don't understand. I don't know the purpose for offering it, but to me, on the surface, it looks like it contains significant hearsay. So I would object.
Ms. Rasnick?
Your Honor, it's not being offered for the truth of the matter asserted, but to demonstrate that Mr. Hersey did bring, it supports Mr. Hersey's statement that he did notify Jennifer Johnson of these issues in April 2023.
The argument is it goes not to the truth of the matter, but to notice Mr. Gross reply.
Well, I assume for some of it to be relevant, it has to go to the truth of the matter asserted. For example, he states, it's very difficult to find hearings. For example, some audio files combine AM and PM. For that statement to be relevant, it has to be true. So I would argue that is being, that specific statement and probably many others are being offered for the truth of the matter asserted.
I'm concerned about the substance of the document and the panel being able to separate the substance of these complaints with the purpose of admitting it. I'm going to sustain the objection to the admission of the document.
All right. We'll take that down. Let's see. Mr. Hersey, have you participated in any meetings with Christina Rauenhorst about the functioning of the court?
I have, yes.
Were you the only participant in meetings with Ms. Rauenhorst?
No, I mean, there have been multiple meetings.
Do you recall meeting with Ms. Rauenhorst and some other court administrators?
Yes, that was February 2024.
What was the purpose of your meeting with Ms. Rauenhorst and the other court administrators?
It was to hope to improve the functionality of the court and address everything that, I mean, these are the issues we had been raising and bringing to the court's attention for months and months and months. And we were hoping to see if we can work out some of the problems that we've been seeing. It's, you know, everything.
Did the judge, did the judge attend that meeting?
No, she did not.
Was it a productive meeting?
It was. I mean, in the sense that it was productive in the sense that there was an open dialogue. There was a
objection, non-responsive.
How was it a productive meeting, Mr. Hersey?
I thought it was productive in the sense that there was an open and honest dialogue. No one was shutting anyone down from speaking. There was no blame game. It was just everyone sitting down and recognizing there are serious functionality issues in this court. And we want to see if we can work out a way to address so many of these problems that we've seen. Yeah.
All right. Mr. Hersey, I want to ask you, have you noticed any differences in the judge's behavior towards you in the months leading up to this hearing?
Yeah, I mean, it has been awkward, and there's certainly been hostility. I've been accused of leaking documents to the CJC and breaching confidentiality. So
can you talk about the circumstances under which you were accused of breaching confidentiality and leaking documents to the CJC? How recently did that happen?
That was late, maybe 3 or 4 weeks ago.
And in what context?
It was during a therapeutic court staffing hearing that we had with the parties.
Do you remember what are you basing this on specific statements that the judge made to you?
Yes.
Were they made on the record, on the court record?
No, the therapeutic court staffing is not on the record.
And what were the statements that the judge made to you during that hearing? Or I'm sorry, during that staffing, sorry.
Well, I guess to back up, to give some context here, I had sent an email because I was concerned about a lot of the transparency issues we were seeing in therapeutic court.
Well, let me stop you just for a second. Can you briefly describe what you mean by the transparency issues in therapeutic court?
Right. So this had come to a head where at the prior week, my colleague Amanda had referenced that we had been seeing a lot of transparency issues where we had come to learn that there was many non-compliance issues that were not reported by Judge Flood or the coordinator, famous Tyra. And then we find out after the fact, looking in the court file or looking at arrest reports, that information we've been given is either misleading or outright false. So I wanted to send an email to everyone who's on the team, notifying Judge specifically what the issues were we were seeing.
And did you send an email?
I did.
Do you remember what issues were raised in the email?
It was essentially two different topics. It was giving a number of examples of transparency issues that contrasted what we were told with what we later learned, and our concerns about needing to rely on what we're told in order to make appropriate decisions for participants. And the other issue was the judge had adopted this practice of scheduling the first pretrial hearing to observe therapeutic court before defendants had even shown an interest. And Mr. Murphy, the public defender, the head of his office, and I and other defense attorneys have expressed serious concerns about this practice. And I wanted to put that in an email so Judge knew exactly what our concerns were, so we could come on a united front, hopefully, and address that.
And after you sent the email, was it after that point that the exchange that you were recalling initially, where the judge made the statements to you, happened at the staffing?
Well, so initially I sent the email on Friday, October 4th, 2024, and judge's response was to accuse me of breaching confidentiality that comes with the therapeutic court program. And then the following Tuesday was the actual staffing, where a judge made a comment after she kicked out my paralegal, Carrie, from the Zoom meeting where she had previously attended staffing with no issue. She then made a comment that she knows documents are being given to CJC.
And did you feel that you were being that this statement that the judge made to you, accusing you of breaching confidentiality and leaking documents to the CJC, do you think that was in retaliation for your identification as a witness in this proceeding?
Yes.
Objection, relevant, improper opinion.
At that point, October 4th.
All right, let me just overrule that objection.
Okay. All right, I will move on. Mr. Hersey, just one last question. Is the prosecutor's office making any different decisions as an office about how it moves forward with charges against folks based on something we talked about earlier, which is the lack of defenders or the difficulty in retention of defenders?
Yes, so we've really changed our charging practices in a lot of ways. You know, for some context, an average year in Bremerton, our office would probably charge between 1,200, 1,300 cases. I think in 2023, it was less than 900. This year, the stats aren't only up through August, but I think it was like 590. And we've seen, that's not to say that, in my opinion, we're seeing a decrease in referrals. It's probably the contrary, especially with drugs now, drug possession now being a misdemeanor. But we're having to be far more selective in charging. We no longer have direct filing from law enforcement for criminal traffic infractions and things like that. We're just knowing that there are not enough public defenders and the court's capacity is what the current state it is. We are trying to be more selective.
And is the court's capacity something that you link to the turnover that the court has had over the last couple of years in staff?
Yes.
And is it also something that you link to the experience level of the current staff compared with in prior years where there's been more experienced staff?
Yeah, I think that's a big factor.
Okay. Mr. Hersey, I'm going to stop. That is all I have for you on direct today.
Thank you, Ms. Resnick. Mr. Gross, cross-examination.
Thank you. Mr. Hersey, if you don't hear something I say, will you please let me know?
I will.
I just want to make sure I heard what you said. Did you testify in direct that Judge Flood displayed a lack of professionalism or courtesy, but that Judge Doctor was just grumpy?
No, I said he was occasionally grumpy. Yeah.
The vast majority of your interactions with Judge Flood are on the record, right?
Yep. Yeah, majority.
And all of the court's hearings are available on the court's website?
No, they're not. We've had a big issue with the court not recording a lot of hearings. So I wish it was the case, but it's not.
So in general, the vast majority of the court's hearings, the recordings of them are available on their website.
Yeah, I would say so. I don't know how you define vast majority, but I mean, there are entire weeks that were missing from the summer of 2023. There were many days in August of 2024 that were missing that may have been recovered. We've had 2 jury trials that were not recorded and were mistrials. There have been other random hearings that just were not recorded or lost.
For many of the sort of interactions that you described as being on the record, if someone was interested in assessing for themselves whether Judge Flood had displayed a lack of professional courtesy, they could go on the website and listen to them, right?
They could listen, they couldn't watch.
Yeah. You described a number of function issues in the court, such as docketing errors or failure to send NCO rescissions. Correct?
Oh, yes, sorry.
You were talking about the court not having a written policy for NCO rescissions. What was Judge Doctor's written policy regarding NCO rescissions?
I'd have to pull it up to know exactly what it said, but it was available, and it was available to the public.
Okay. Did the court cancel that written policy?
I would assume so, because at a certain point there was no written policy, although it was required by statute.
So you talked about the Gardner case and the Rodriguez case. Do you recall those cases?
Yes.
Those were, as you described them, issues regarding notifying BPD about changes or termination of NCO orders.
Yes.
Do you know what the court's process was for sending NCO orders to BPD during that time?
During the time of the incidents involving Gardner and Rodriguez?
Yes.
I always operated under the assumption that it was to send the orders as required by law within the next judicial day. So I don't know.
But you don't know. You don't know, right? Okay. The court may have had a process for sending them, right?
It would have been out of compliance with the law if there was anything beyond that. But yeah, they could have.
Did you think Judge Flood was personally responsible for sending those orders to BPD?
Personally responsible? No. If it was a situation where Judge was not signing an order that was sitting in O courts, then I would. But because this was such a persistent issue that Judge Flood was made aware of, it's hard not to hold her personally responsible for the dysfunction that we saw in that issue.
All right. I want to talk to you about, Karina, can you put up Exhibit 241? Mr. Hersey, do you recognize this email?
Yes.
This email chain?
Yes, I do.
Did you provide this email to the CJC?
Yeah, I did.
Can you recap what this email chain is about?
This was the one I talked about. The case was dismissed at readiness. So that would have been, and I think in this case, if you scroll down, I think it was probably the Friday before that, Wednesday 21st, where my legal assistant had reached out to make sure BPD got the order. Yeah, so it was dismissed on 2/16. And with the dismissal, the no contact order was also rescinded by law. But the Bremerton Police Department, for whatever reason, did not get it until we caught it and then notified the court, I guess.
Okay. And if we can scroll up. Miss Christina Rauenhorst from the court responded to explain what had happened, correct?
Looks like it, yes.
Okay. Is this a true and accurate version of this email chain?
I believe so. Yeah, it looks like it.
I would move to admit this.
Exhibit 241 has been offered, Ms. Rasnick.
No objection.
Without objection, exhibit 241 should be admitted.
Okay, and we can see on this email, Ms. Rauenhorst said, "Hello, this has been emailed. Apologies for the delay. We were awaiting the judge's signature." Correct?
That looks like what Christina said. Yep.
So do you interpret this email to be that the delay in sending it was because the judge had not signed the order?
Yeah, I mean, I guess so. That's I think the only reasonable way to interpret that. I don't know if that's true.
Are you?
I wasn't tracking when the document was signed. I don't know if I'd be able to.
Are you familiar with the O-Court program?
Yeah, yeah.
Sabrina, can you put up exhibit 318? Can we zoom in a little bit?
Or not.
Mr. Hersey, are you able to read what's on the screen?
Yeah, it's a little blurry, but I can read it. This looks like the main screen for O-Courts. When you go to a particular case or a date and then click on the case, it might show kind of an overview of the documents that were generated on that date.
Is this the O-Court record for the Camille Kelsey case, 506-4507?
I would assume so, but I don't know for sure. This would have just been, again, this would have reflected, I think, probably one day. So for any given case, it's going to have a different page that looks like this, that reflects what documents were generated at that hearing. So if the case was continued on that day, there might be like a motion to continue. And this is probably the one that would have been from 2/14 or thereabouts, which shows the dismissal order.
Okay. Can you see on this page that Judge Flood signed the order?
Yes. That's the signed by J is for the judge.
Can you see on this page that this case was archived on the 16th?
I'm not sure where that, you show me what you're pointing to.
At the bottom?
Oh, okay. Yes, it looks like Rachel, one of the clerks who works downstairs, archived it on does that say 2/16?
Can we zoom in? (2/16),
Yep. Yeah, that looks like 2/16.
which is the same day that the hearing took place.
That sounds right. I think, yeah, it was 2/16. That would have been that Friday, right?
Okay, which means that the judge signed the order of dismissal on February 16th.
I don't know. Again, I don't know. I'm assuming a document wouldn't be archived unless the judge signed it. But you would have to ask Rachel that.
Okay, and then on that same day, Carrie Mann accessed file, right? The order of dismissal.
Yeah, again, this was us, I think I think Carrie does this when cases close out for our files. So she must have done that. It looks like that afternoon.
Okay. Karina, can we go back to Exhibit 241? Okay, can we scroll down? Okay, stop. Go up slightly. A little bit more. A little bit more. So, Mr. Hersey, Carrie Mann sent an email on February 20th, 2024 at 8:53 a.m. Do you see that?
Mm-hmm. Yep.
Can you scroll down, Karina? She says, I'm going to read it. You can tell me if I read it accurately. Morning all, the case was dismissed and NCO rescinded on the Camille Kelsey case 506-45-407 last Friday, 2/16. Just wanted to make sure you received the dismissal order, right?
Yep, you read that correctly.
Okay. But at that time, we could see in O Court that she had already seen that the judge had signed this order.
That, I don't know. You'd have to ask that of Carrie. I don't know. It doesn't look like, can't tell if Carrie attached anything in that email. But I don't know. It sounds like either way, it didn't get to BPD.
Okay. Yeah, and then scroll all the way up again. But either way, Ms. Rowenhorst told Marie Hansen, Carrie Mann, BPD Records Unit, and DPC criminal cases that the delay was caused because they were awaiting the judge's signature, correct?
That is what she told her, but that'd be a question for Christina, I think, as to why. I don't know.
Okay, you can take it down. Can we put up Exhibit 257? Is there any way we can see more of that?
Yep.
Yeah. Mr. Hersey, do you recognize this email chain?
I do.
What is it?
I'm not sure where this email chain starts, but this was, I forget how we were notified that Nathaniel Braden passed away. We may have gotten the death certificate and then realized there were active warrants. But Carrie starts by emailing warrants to try to see if that warrant that was issued was ever sent to BPD. And they advised they never received copies and had been in and out of the jail at a time where his warrants would have been served had they been received by law enforcement.
Is this a true and accurate copy of this email chain?
Yes.
We would move to admit this.
Exhibit 257 has been offered. Ms. Rasnick,
I don't have any objection.
without objection, exhibit 257 shall be admitted.
Mr. Hersey, did you provide this email to disciplinary counsel?
I did, or I guess probably Ms. Slotemaker.
Okay. Do you know at the time that this event occurred what the process was for the court to get warrants to BPD?
No, I mean, the warrant is ordered and then it's sent to BPD. I don't know the exact mechanics of how it's done. But I know they are sent somehow, some way.
Do you know whether Judge Flood or whoever is presiding signs a paper copy of the warrant?
Generally, yes. Assuming we've seen many times, though, where a warrant is ordered on the record and then it's nowhere to be found in the court file. So I don't know what to make of that. Maybe the warrant's never signed and it's lost. But I do know that the warrant, if done properly, is signed and then sent to law enforcement for entry.
Okay, after Judge Flood or whichever judge signs the paper copy of the warrant, do you know what happens next with it?
Well, then again, it gets to BPD and then it's entered into NCIC and WASC.
Do you know how it gets to BPD?
Either by being picked up directly by the warrants officer who goes from the courthouse to my office, to various places, or it's sent directly, I think, via email. I don't know the court's process exactly in its current state.
Did you know the court's process at the time of this Braden warrant?
Not specifically, no.
Did you assume that Judge Flood made a mistake in this process?
I didn't assume that Judge Flood specifically made a mistake in this process. This is a case where the warrants, I can explain, this is a case where the warrants were not in the court file.
Objection, non-responsive. Your Honor, does Your Honor rule?
I said, I think he was answering your question, but if you'd like him to move on, you can ask another question.
Okay. Yeah. So I guess my question is, do you know what the malfunction in the process was in this Braden situation?
What I know is that the warrants were not in the court file, which would suggest to me that maybe it was never signed. Because if it was never in the court file and entered by the clerks for entry into the court file, that would indicate it's possible maybe a warrant was ordered on the record, but then never signed. Whereas we've seen situations where warrants can be found in the court file, but then maybe it was archived, but not emailed to BPD, whatever the process is, again, of how it gets from point A to point B. We've seen those situations come up as well.
I'm sorry, are you saying that you know that the warrant wasn't signed?
I know it was not in the court file. So when I searched the court file, it was nowhere to be found in Laserfish.
Okay, do you think that Judge Flood gets the signed paper warrant into Laserfish?
Personally, does she get the signed paper file into Laserfish? I would doubt it.
When this incident happened, did you bring it to the attention of Judge Flood?
This particular incident? No.
want to ask you about I think during your direct, you described an incident where you felt the judge had acted inappropriately after you, regarding a trial that you and a defense counsel had agreed to continue. Do you remember that?
Yes.
Yeah, I just want to make sure that I have an understanding of what happened. Defense counsel, the case had been on readiness, and you and defense counsel had answered ready.
Correct. That was the Friday before.
The Friday before. And then defense counsel emailed you and asked for a continuance.
It was a phone call, but yes. That would have been, I think, the Tuesday, November 29th, 2022.
And you did not object to a continuance?
No, I made it clear in my email that the city would have no objection to continuing the trial date as requested by defense, and that we would anticipate being ready in the following week, assuming that there was no issues with witness availability. The city was not opposing the defense motion.
Motions to continue trial are granted or denied in the discretion of the court, right?
Of course.
But you emailed the court and told them that you would make notifications to BPD and jury coordinator and others involved in the procedural aspect of getting a jury trial together to let them know the case would not proceed to trial as scheduled.
I advised I would let them know that the parties would be anticipating a continuance. So yes, effectively, but no, I did not go so far, I think, as to say that this case has been continued, as it had not yet been continued, and I hadn't received a response to my email.
Did the relevant parties receiving that email take steps to, as if trial was not proceeding?
Did the relevant parties, sorry, can you clarify?
When you notified, let's say BPD, did they cancel the transport of the defendant?
No, because he was still transported. I think I notified them that defense wasn't ready to proceed and would be asking for a 1-week continuance. I may have said you're off the hook or something to that effect. I wouldn't be surprised, because again, in my history of practice, if there's a joint request for a continuance, especially a defense request, I've never experienced it being denied before, especially under the circumstances.
You've never experienced a joint motion to continue a trial be denied?
No, I don't think so.
Okay. You described, but the jury coordinator canceled the jury, correct?
I believe so. I mean, again, I emailed, and I'm pretty sure he probably took the steps to call off the jury. I forget if I emailed or I called him. I may have called him because it was time sensitive, because I think the jury policy was that if they're not notified by Tuesday afternoon, that the city has to pay the costs associated with the jurors being canceled, I guess.
You described a bit about the hearing and direct examination. I want to ask you a little bit more. First of all, Judge Flood was not happy that you had told people they were off the hook for the jury trial, correct?
My impression is she was not happy with me.
And you admitted, or you told Judge Flood, you realized that you had stepped out of line, right?
I don't know if I said those words, but I did indicate that if I stepped out of line and that if I was stepping outside of my lane, I apologized. But at the end of the day, I emailed Judge directly with this information. She expressed no concerns about it, so I was completely caught off guard by being dressed down like that.
Okay, you said dressed down. I want to ask you specifically what Judge Flood did that you thought was inappropriate.
Well, for starters, she just started talking. It didn't address the parties at all. Started laying a factual record that was inaccurate. The judge lied on the record and said she didn't have notice of the request. When I emailed her directly with a high importance email, when all of her clerks had received this as well, I think it was incredibly disingenuous to say that this was just done with no notice to the court.
Anything else about what you did during that hearing that you thought was inappropriate?
Well, I think unilaterally changing the defendant's release conditions for a serious domestic violence intimate partner offense with no input from the parties, especially in the defense in this circumstance. This was a case where I think Judge Flood was intending to help Mr. Eccles, but actually, as a result of him being PR'd, he now had a longer speedy trial clock switched to 90 days, and he was no longer receiving credit because he'd been PR'd on this case while he was held on high bail on a pending felony, where resolving this case would have impacted his offender score in the felony case. So there were a lot of things at play here, but I thought that was inappropriate.
Did the defendant, Mr. Eccles, actually object at that hearing to a continuance, saying he was ready for trial that day, and that his counsel was using the recently received evidence as an excuse for continuance?
He later did. Sean Mills advised me over the phone that his client was in agreement to continue 1 week. And then when confronted with this record presented by the judge, he then changed his tune and said he wanted to go to trial that day.
Well, you don't know whether he changed his tune because you have no personal knowledge of what he told his attorney, correct?
Of course not. Just what his attorney told me. He said, I just finished talking to Mr. Eccles. He's in agreement. We can continue this 1 week.
Is the defendant's objection to a continuance exactly the kind of thing a judge might want to consider when they're deciding whether to grant a motion to continue trial?
Of course it is.
Okay. Your Honor, I want to let you know that we have a recording of this hearing that we would like the panel to listen to. It is a pretty lengthy hearing, and I don't believe we have time to hear it today. I guess I'd ask for Your Honor's indulgence whether we could submit this simply as an exhibit and ask the panel to listen to it prior to deliberating.
And your purpose behind your seeking to admit this recording is what?
Impeachment.
Ms. Rasnick?
I have not heard this hearing. I have not heard this recording. There was a directive at least one of our readiness conferences when I think the issue of a video of the courthouse came up, that if there was going to be video evidence or audio evidence, that it would be provided in advance. This has not been included in any exhibit disclosure to me. So I would object to this being played on the record. I would like an opportunity to review this so that I can be prepared.
Yeah, Mr. Gross, what's your response to the fact that you haven't provided any notice of a possible impeachment exhibit, including an audio recording?
It's an impeachment exhibit. It's not a primary exhibit. It's an impeachment exhibit.
All right.
Well, it's a public record.
How long is your proposed exhibit?
It's at least half an hour.
All right. Well, we're not going to hear it now, and I do want Ms. Rasnick to have an opportunity to hear it before it's proffered to the panel. Besides this exhibit, Mr. Gross, how much longer on your cross do you anticipate?
I need a minute, Your Honor, to confer with my client. I don't have anything else, Your Honor.
All right. Well, Ms. Rasnick, what is your proposal in terms of, we have 10 minutes before 5 o'clock. I want to hear your proposal for what you want us to be doing with our time and with this witness and with this exhibit.
It is unclear to me what we could do. I mean, I can certainly, counsel has represented that the recording is a half hour long. We have another 10 minutes in our allocated court day. We have approximately 10 minutes before I understand Mr. Hersey is unavailable. So I don't know that there's anything we can do with this exhibit in the next 10 minutes. Certainly, Mr. Gross could upload it to a share file send the link to my office so that I can begin listening to it, but I'm not going to be done listening to it until after the court day.
Do you have any witnesses, any of your other two witnesses available to you? We did talk about a court day going to 5:30. Do you have any witnesses available to you?
I have a couple of last questions of redirect for Mr. Hersey, and then I can inquire. But I had understood that we were going to stop at 5 today. I don't recall there having been a 5:30 stop expectation to the court day. So when we began, Mr. Hersey, I released Ms. Rauenhorst and Mr. Cohen because I thought we were going to be going until 5 o'clock. I'm sorry, I apologize if I misunderstood, but I genuinely did not have the impression that we were going to be going from 8:30 until past 5 o'clock.
Ms. Bremner, did I hear you clear your throat in a way that tells me you have something to say?
Thank you, Your Honor. I do. I mean, we've been on tight time constraints, which we really appreciate. And she was supposed to be done today. And the 5 o'clock was her request, given a witness supposedly with a hard stop at 5. So I think that she should have had witnesses ready, because we always know that there's eventualities that things can go shorter or longer with given witnesses.
I have some more information that might cut this short.
I'm still talking, but I'm almost done talking. But I do want to say, you'd also asked, Your Honor, about tomorrow. We do have a hard stop for Judge Leon at noon because she does not have a pro tem for the afternoon. And go ahead. I'm sorry, counsel.
Ian Cohen is available and is in the waiting room.
Great.
Okay. So the options are here, as I see it, to allow you your redirect with this witness, allow panel questions to the witness, and then to evaluate whether the witness will come back to address this potential impeachment exhibit. Or we stop with this witness right now and jump to Mr. Cohen. How long is your examination of Mr. Cohen, Ms. Rasnick?
My direct examination of Mr. Cohen is probably 45 minutes, between 45 minutes and an hour.
If it helps, if I may, Your Honor, I could extend till 5:10.
Okay.
That's helpful.
I think at this point, what I'd like to do is with putting aside the issue of the impeachment exhibit, and we'll leave that unresolved at this point. Let's go ahead and finish otherwise up with this witness. And then if we have time, we can start Mr. Cohen. I don't particularly want to just stop at 5 because that's convenient. I want to keep going. And I said from the very beginning, we're going to have a robust schedule on this hearing to try to pack as much as we can. And I do expect to respond to Ms. Bremner's second time. She's now talked about the obligation to complete in one day, and I want to address that. But let's finish with Mr. Hersey. I understand, Mr. Gross, but for the impeachment exhibit, you have completed your cross-examination. So at this point, Ms. Rasnick, your redirect.
Sure, just a couple questions, Mr. Hersey. The Gardner case that you discussed, do you recall that being from June 2024?
I believe so. That sounds right.
Had the issue of the transmission of NCO rescission orders been brought to the court's attention prior to June 2024?
Yes, many times.
Objection asked and answered.
And the Braden case that was discussed, oh, I'm sorry, was there an objection? I got a little delayed.
The objection was asked and answered, but because it's redirect, I'm allowing you to send to reset the table. So let's just keep going, Ms. Rasnick.
Okay. The Braden case that was discussed, that case was from April 2024, is that correct?
Yes.
And by April 2024, had the issue of warrant transmission been brought to the court's attention?
Yes, many times. And to be clear, the court had previously directed us to direct complaints.
Objection, non-responsive.
Had the court given you some instruction about the way that that kind of feedback should be presented?
Yes.
And what instruction had the court given you?
Thank you. Yes, the court had told us several times to direct complaints to the court administrator or assistant court administrator. several times. And when I tried to bring these issues up in Crim Prac and Pro, I was shut down by Judge Flood.
Thank you. I don't have anything further on redirect.
Thank you, Ms. Resnick. Mr. Gross, recross.
One moment, Your Honor. Mr. Hersey, the last Crim Prac Pro meeting was in May of this year.
April or May?
Nothing further.
Ms. Resnick, anything further?
Mr. Hersey, were either of those issues that we just talked about, the transmission of NCO rescission orders or the warrant transmission issues, discussed at the Crim Prac Pro meeting that was in May?
I don't recall what was discussed in May. I know I tried many times to discuss it before.
Objection, non-responsive.
You're muted, Your Honor.
See that now. I'll sustain it as to the last part of that answer.
Okay. Nothing further.
All right, Mr. Gross, anything further?
No, Your Honor.
All right, so to the panel members, with the possible exception of a impeachment exhibit that we have yet to determine whether it be part of this hearing, I want to ask if any panel members have questions for the witness. All right, I see no hands. So at this point, Ms. Rasnick and Mr. Gross, I'm going to ask that you two work together so that Ms. Rasnick has an opportunity to review this impeachment exhibit, and then I want to address it first thing in the morning, and then we at that point will make a decision about what we do with this witness. I assume, Ms. Rasnick, that the witness will be available if need be, based upon the desire for this impeachment exhibit, depending on the ruling of the presiding officer.
We will work that out with Mr. Hersey. Yes, Your Honor.
Okay, so again, I'm asking Mr. Gross and Ms. Rasnick to cooperate on that. Mr. Hersey, you are done for now.
Thank you, Your Honor.
All right, have a good day.
Thank you. You too.
So I'd like to keep going to 5:30 if you've got a witness in the waiting room.
I do, yes. And I want to apologize. I had understood that we would be stopping at 5 today, but I understand now that that was an incorrect understanding. So Mr. Cohen is in the waiting room and I'm prepared to go forward with his direct.
Right, I did get a flag down by Commissioner Evans. Is that a nature break or is that an objection to moving on to 5:30?
A strong nature break.
Okay, well, with the request with emphasis for a nature break, I'd like to let's take 5-6 minutes. And again, as I really cramp this, I recognize that we're moving very, very in a compact way, and not least on my mind when we do that is our court reporter. So I want to say thank you again for your patience with our schedule. Well, let's take a 5-minute nature break. We'll be back on the record in 5 minutes. That'll be 5:04. All right, by my computer, I have the time at 5:04. Just waiting for a couple more cameras.
I'm not hearing.
Couple more cameras to come on.
Your Honor, Judge Flood should be back momentarily.
All right, I'm also waiting for Commissioner Miller. If she's available, we can turn her camera on. Commissioner Miller is with us. So at this point, was Miss Bremner, is she still there? She is. All right, so I don't want to go past 5:30. I think that's unfair, but I do want to address before we get started with Mr. Cohen, understanding we probably don't have sufficient time this evening to finish his testimony, his direct anyway. I want to address Ms. Bremner's objection she's made now twice to allowing disciplinary counsel to continue her case beyond today. And it's been pointed out that the parties agreed.
Your Honor, I'm sorry to interrupt, but Ms. Flood is not present, so just 1 second. Okay, she's here. Sorry, would you be willing to start over because she wasn't present for what you said?
I was just reciting the fact that Ms. Bremner has said twice that she's objecting, or I'm construing her comments to be an objection to allowing disciplinary counsel to continue her case beyond the 1 day that the parties agreed in the stipulation. Each party would have 1 day. And she's objected to that. Now, I point out that the stipulation not only included the parties agreeing to 1 day, but also that additional time, if ordered by the court, would be on Friday, October 25. Now, in the decades that I've been doing this business and almost 15 as a judge, so probably one of the most common occurrences is the poor estimation of time in trial. And the reason for that is people cannot predictably control their opponents, both in terms of those presenting direct testimony and those doing cross-examination. And therefore, the estimations of time are almost always difficult because you're not entirely in control. I would note this morning that we started at 8:30 promptly. However, it wasn't until about 9:15 where the directs started. Now, I can't tell as I sit here, was Ms. Rasnick's estimation of time poor because she didn't factor in opening comments, because she didn't factor in opening statements, or because witnesses or information surprised her, or whether cross-examination surprised her. I can't tell, but what I can tell is that I'm not inclined to hamstring either party in a way that will allow either side not to present their case. So, Ms. Razek, you have persuaded me that I'm going to provide you additional time for your witnesses, but it is limited. It's going to be precise. It's not going to be extensive. And I will permit certainly Judge Flood's side an opportunity to present their case in a way that mirrors the amount of time the disciplinary counsel has. Now, you've told me, Ms. Rasnick, that you think that each witness will be about an hour each, and I'm using your estimation based upon what Ms. Kinlow's testimony was, which was about an hour. And so I'm counting on that 2 hours. Now, Ms. Bremner, you have said that you've got a witness issue at noon. You lose Judge Leon after the morning time. You haven't told me about any other conflicts that you have.
There aren't any, Your Honor, just that one.
So what I expect to do is try to get as much done with Mr. Cohen as possible here today.
I'm sorry to interrupt, but we do have an additional witness issue. which is that our first witness is only available first thing in the morning, which is when she was scheduled.
Okay.
Which witness, is that Miss Gowden?
Yes.
All right. Well, it is not the first time where witnesses have been taken out of order. It is not my preference at all to have a hearing that's taken out of order. But I think anybody who's been around the block and has tried a few cases know that that happens on occasion. It's not something we like to have happen, but it's sometimes we do what we have to do. So what I propose is we start with Mr. Cohen, get as much done as we can. Mr. Gross and Ms. Rasnick, of course, are talking about the impeachment exhibit. And then we will start, if that is indeed the case, we'll have Ms. Gowden, Mr. They, at 8:30 in the morning, and then resume with Mr. Cohen. How long do you expect that testimony to take, Ms. Bremner?
I would say direct is under a half hour, Your Honor.
Okay. All right. Ms. Rasnick, is that understood?
It is, thank you.
Okay, now that means you're going to split your witness in a bit. And I know that's not ideal, but that frankly is a bed that everybody's sleeping in because we've all made it. But to the extent we have to continue to Friday, we will do that. And let the record be clear, this matter has been set for Monday through Friday for, I don't know, 6 months. So this is a time where people ought to have known that this was going to happen. I also believe that it was going to be necessary anyway to go to Friday because I wasn't sure how we were going to get to closing arguments. Didn't seem realistic at all that we were going to complete closings tomorrow, the way the testimony has been going. So at this point, let us continue with Mr. Cohen for another 20 minutes. We will recess for the day. Mr. Gross, Ms. Rasnick will talk about this impeachment exhibit, and I expect some discussion about that in the morning. Ms. Bremner, you will put on your witness at 8:30. After that one witness, we'll be resume with Ms. Rasnick, and you'll do 2 witnesses. And if you get them done in less time than you've estimated, I think we'll all do jumping jacks and be happy and celebrate. But it won't go longer than that. All right, absent some compelling argument you're making to me that it's out of your control because of some surprise that's happened in things that again are not in your control. So, so long as I'm understood, is that understood, Mr. Gross?
I understand.
Ms. Rasnick?
Yes, Your Honor, it would be helpful to have an estimate of the length of time Mr. Gross expects to spend cross-examining Mr. Cohen and Ms. Rauenhorst, but he can certainly email that to me.
Okay, well, I'm not going to ask him that on the record at this point. Obviously, that's somewhat derivative, I would imagine, of your direct. So at this point, let us proceed to do what we can. And now we're down to 18 minutes. So let's continue. Ms. Rasnick?
Your Honor, I need to raise that we have Judge Leone who needs to be heard before noon, and having the disciplinary counsel put on 2 witnesses, the way things are going, we're not going to get to her.
We will ensure that, how long, Ms. Bremner, how long is Judge Leone?
Again, I tend to be pretty quick. So I'd say again, half hour. Any witness that I have on direct is going to be under 45 minutes, but my best estimates are about half hour per witness on direct.
Yeah. Well, let's have more, let's have that be an ongoing issue that we all have our eyes on tomorrow morning. And if and when we need to resume, or rather recess witnesses that are happening in order to make sure that Judge Leone testifies, we will do that. I'm not gonna have a witness go unheard because of some scheduling issue.
Understood.
Okay, so we are now resuming with your next witness. Ms. Rasnick, would you like to call your next witness?
Yes, disciplinary counsel calls Ian Cohen.
All right, Mr. Cohen, can you raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct?
I do.
All right, you may proceed, Ms. Rasnick.
Good afternoon, Mr. Cohen. I'm Reagan Rasnick, disciplinary counsel. Can you hear me okay?
I can, thank you.
Where are you currently employed, Mr. Cohen?
I am currently the code enforcement officer for the city of Bremerton.
How long have you been in that position?
I have been here since March of this last year.
Of 2024?
2023.
Oh, sorry, 2023. Were you previously employed by Bremerton Municipal Court?
I was.
What was your position at Bremerton Municipal Court?
I was the probation officer for the city of Bremerton.
How long did you hold that position?
22 and a half years approximately.
Before you took that position, had you received any specific training in how to be a probation officer?
Once I started on the job, I was sent to the Probation Academy for Washington State. Before that, I had been to the Academy for Case Managers for Mental Health, which was kind of a health thing.
And did you have a mental health certification?
That is correct. I have been a certified mental health counselor for 27 years, and I had a credential prior to that as a registered counselor with the state of Washington.
And your credential is up to date?
It is up to date. I'm trying to decide if I want to renew this year.
Did you receive any awards or accolades in your role as a probation officer?
In 2008 and 2016, I received Probation Officer of the Year from the Probation Association for the state of Washington.
And how is that decided? Is that somebody names you, or how's that decided?
It is a peer vote. The peers within the probation community in the state of Washington vote to award that honor.
Before Judge Flood came to Bremerton Municipal Court in January 2022, did you work under Judge Doctor?
I did.
Were you probation officer under any other judges besides Judge Doctor?
Just Judge Doctor and Commissioner Shane Seaman.
Was Mr. Seaman a commissioner in Bremerton Municipal Court?
Yes, he was.
Okay. Were you the first probation officer Bremerton Municipal Court employed?
There was a probation officer, I don't know how many years prior to me, but the city canceled the program due to funding and the judge and the mayor not believing that the city needed a probation officer, that everybody could be monitored via bench probation.
So were you the first person who was hired after the position was canceled?
That's correct. It had been several years.
Okay. Were you tasked with developing the position to any extent?
That is correct. Judge Doctor sent me around to multiple courts in order to glean information from them on how their probation departments work, their policies, their procedures, and then come back and start implementing it.
Did you and Judge Doctor collaborate to any extent on the development of the position?
He told me what he was looking for, told me what his expectations were, and kind of coached me through it. Kind of worked hand in hand all the way from the beginning to the end of the beginning to the establishment of the program.
Did you develop the forms for the probation officer position?
Correct. I developed all the forms, policies, procedures.
And how about the process for monitoring? Did you develop that as well?
Correct. Monitored, formed mostly after Kitsap County's probation program and also Chelan County's.
Okay. Let's see. Can you briefly tell us what your job duties as probation officer were under Judge Doctor?
Under Judge Doctor, it was doing an intake on anybody that was sentenced or pretrial to needing supervised probation. I would determine the risk and risk score using the Washington State Standard Risk Assessment, which is also known as the Wisconsin Risk Assessment Model. I would then schedule appointments for them to meet with me as per the scorer's rankings. We would discuss issues such as treatment. We would discuss issues as what providers are available in town, help them get established, discuss ways of obtaining possible funding, drug testing individuals as needed and on a random basis. I also collected all the information for Western State Hospital when there was a competency order issued. I would get information from the prosecutor, defense, the court file, compile that into one email or fax originally, and get that shipped off to Western State because we wanted to speed up our process and make it more efficient with Western State.
Were you also responsible for violation reports?
That is correct. I had 7 days to get those to the prosecutor's office from the time that I received them.
And at some point, did you also begin assisting or monitoring folks who were on pretrial home detention?
Yes, there was a point in time several years ago where Officer Boynton, who worked for the police department, he did all that, and the police department decided that they were not going to do pretrial home detention. Since Mr. Boynton and I shared office space early on, I was familiar with the equipment, and so Judge Doctor obtained some grant funding, not grant funding, funding from City Council for me to be able to do pretrial home detention.
And how would you describe your working relationship with Judge Doctor?
It was a professional relationship. It was a very efficient relationship. He'd tell me what he needed done and I'd get it done.
Did you and Judge Doctor ever have disagreements about how you should do your job?
He would tell me what to do and I would do it. If I was doing it wrong, he would let me know, hey, you need to work on this, you need to correct that, and we would come up with a solution on how to keep it from happening again.
Did you also have a working relationship with the city prosecutor's office?
I did.
Were there any, how would you characterize your working relationship? Here again, I'm talking about under Judge Doctor's tenure, your working relationship with the city prosecutor's office.
It was a very efficient program. Everybody seemed to be respectful of one another. There were differences of opinion at times, but it always got worked out in a reasonable manner.
Did you ever get the sense that you were perceived as siding with the prosecution or with defense counsel?
I was just stating what
personal knowledge.
What was the question?
The question was, did Mr. Cohen ever have the sense that he was perceived as siding with the prosecution or the defense? Your Honor, your mute was on.
I'm sorry. I was saying, with that being the question, the objection is overruled.
Okay, go ahead, Mr. Cohen.
It felt as though we were pretty much all striving for the same goal. A lot of it was to get people into recovery. It was in order to monitor people in a
non-responsive.
Well, hard to tell because I don't know where the answer was going, but I'll sustain it. Ms. Rasnick ask the question again.
Okay. Just yes or no, Mr. Cohen. Did you ever get the sense that you were perceived as siding with the prosecution or the defense counsel?
No.
Did you also testify in court?
Yes.
Okay. Did you have a good working relationship with the defense bar?
Yes.
Did you have a good relationship with your coworkers on the staff of Bremerton Municipal Court?
Yes.
Had most of them, and again, I'm talking about the let's say the last year or so of Judge Doctor's tenure. Did you have long-term colleagues on the at court staff?
Many of them had been there for 18 years, and I would say it was a good relationship.
Did you know Judge Tracy Flood? Had you ever met her before she was elected municipal court judge in Bremerton?
I met Judge Flood when she was practicing attorney in Bremerton in 2000. Her first day in Bremerton Municipal Court was, I believe, my first day. She has pointed that out to me as well.
And did the two of you get along with each other?
I believe it was a cordial working relationship. We were aware of each other.
Okay. But you had no resentment of Judge Flood when she was elected judge in Bremerton?
I had read a news article.
Leading.
Actually, I'll sustain.
Okay. Did you have any information other than your having both started at the court on the same day? Do you have any other information that was informing your opinion or your beliefs about Judge Flood when she was elected to the position?
I had read one article.
And do you recall what the article said?
It was a Kitsap Sun
Objection, hearsay.
Did you change your opinion of Judge Flood based on the article?
No.
Okay. When you first saw Judge Flood in the courthouse, do you recall interacting with her? And I'm talking about after she was elected, the first time you remember seeing her in the courthouse. Do you recall interacting with her?
The first time I saw her in the courtroom or courthouse was the day that Don Williams was showing her the building. I met with her. It was between the
Objection, non-responsive.
I think he is responding.
Yeah, overruled.
It was between the clerk's office area at the base of the stairs leading to the judge's chambers and the vault. I welcomed her to the team or the family. I can't remember which way I put it. And I gave her kind of a side hug.
And what was her reaction, if you recall, to your what you just described as your welcome of her?
She was smiling or appeared to be smiling.
Do you remember Judge Flood swearing in?
I do.
Did you attend the swearing in?
I did.
Do you have any recollection about whether other co-workers of yours at Bremerton Municipal Court attended the swearing in?
I believe there were 6 of us that attended and 2 that were unable to attend due to working early shift and having other obligations after they got off work.
Were all of those people who attended able to actually be in the room where the swearing in was taking place?
If I recall correctly, it was pretty much standing room only. I know 4 of the clerks were seated in the atrium area of the Norm Dix building, which is where it was being held.
Okay. Is the atrium area, is that where the swearing in was happening?
The swearing in was in the council chambers, which is a large enclosed area. Outside of there is the atrium, which has the main entry reception area for the building. And there were monitors set up for overflow crowd to be able to watch the swearing in.
Okay. So the 4 of your coworkers who sat in the atrium were not in the actual room where the swearing in was taking place?
That's correct.
Be thinking about a stopping point, Ms. Rasnick.
I was thinking about a stopping point right now, but it's only 5:27, so let me just squeeze in one small question. Where was your office located in the courthouse compared to the judge's chambers?
Her chambers is on the south end of the building, and mine was on the north end of the building. She was south of the courtroom. I was north of the courtroom.
But both on the second floor?
Both on the second floor.
And that's on a different floor from the clerk's office?
That is correct. It's on second floor.
Okay. Did your job duties change once Judge Flood took the bench?
There were changes. She was implementing changes to make us more like the King County model.
And were there any changes to the way court monitored or court monitoring was to work compared with what you had experienced?
She was in some cases setting the frequency of how I was to meet with people and not using the risk assessment model. I was supposed to be reporting under the previous model to the prosecutors any violation. I was to check on the box if it like a first relapse, say, hey, this is free treatment. We're still trying to engage in treatment. There was information that I was supposed to be putting in there, and Judge Flood directed that I not provide any information to the prosecutors and that I go directly to her.
Did Judge Flood use the same terminology that Judge Doctor had employed in terms of court monitored, active, the kind of distinctions between the types of monitoring?
Yes, there was changes.
And what was the change that the judge made to the terminology?
So for the efficiency of the court, we had a couple different terms that we used. Supervised probation was done by Clerk Cindy Hope as part of her duties, and active supervised probation, or as we shorthanded in the computer, level 2 probation was handled by me. It made it more simple for the staff to rapidly be able to determine who was getting what case when ordered by the judge.
So that was the way it had been.
Correct.
What was the change that Judge Flood made to the way that that terminology was employed?
She made it so that we weren't supposed to be using the term level 2 or entering that in the notes tab on JIS JABS, which made it so you then had to go and look at the judgment and sentence conditions to do that.
And was it necessary to change the existing records to reflect the terminology that the judge wanted to use?
Yes, I had to go back and try to change all the cases that I knew of, and then go back and try to find all the ones that were in warrant status.
And how far back were you having to go to make these changes?
She did not specify how far back, but basically as I had time in between individuals, I would pull a case number up, delete the identifying mark of level 2, and then go back to meeting with somebody. And next time I got a chance, I'd go back and do 2 or 3 more.
Okay.
Raznick?
I have 5:30, Your Honor. I can stop there.
Okay, let's stop there then. So, Mr. Cohen, thank you for your testimony here this afternoon. There will be an interruption of your testimony, and we'll pick up when we are able to tomorrow.
Okay.
So at this point, before we recess, let me just make a couple of comments. First of all, we're going to start tomorrow morning with Ms. Bremner as her first witness out of order. And once that witness is completed, we'll return to Mr. Cohen. And then Ms. Raznick, depending on where we are, we'll do your next witness, but we have to have our eye on making sure that we complete Judge Leone before noon. So Ms. Bremner has told me about her amount of time. Ms. Bremner, perhaps you and Ms. Raznick can make sure that you're on the same page with respect to her cross-examination to make sure we start that witness with sufficient time so we can get her completed. And Ms. Raznick, Mr. Gross, you're going to work together on this impeachment exhibit and make some proposal, either issue for me to decide or a proposal for how we deal with that. It's not entirely clear to me what about that exhibit is impeaching of the testimony, but perhaps that can be a discussion you two can have. Obviously, I don't know what's on the hearing. Now, final thought, Ms. Bremner, I am going to ask that your side do everything you can to improve the technology at your end. It has been really, really difficult for Mr. Gross to effectively object the way the technology goes. It's just very hard to hear. It's hard to hear an interruption. It's hard to understand it. And it's actually caused, I think, some of the delay. So hopefully we can get some of that fixed at your end. So especially, Ms. Bremner, when you're examining your own witness, I'm concerned about echoing if you're in the same room. And hopefully you all are way smarter than me on that type of thing, can get a fix. Do we have anything emergent that we have to discuss before we say goodnight, Ms. Raznick?
No, before we get to that though, Your Honor, I'm a counsel to the law firm, but I'm physically at the Fairmont Olympic, my office. So I've had everyone go back to the IBM building. So it's the $5 system, and I hope that they can work together on it. We were all in the same room this morning here at my office, but we've got additional space over here. So we try to separate. But I think I've been clear, have I not, this afternoon, doing this way? I just wanted to check.
You have been clear. Occasionally your camera, well, it's sort of casual in what it's capturing. I don't know if that makes sense to you. So, but I think that's because it's in handheld. But we just need to make sure that I don't need to know the details. I want to be assured that we won't have revisiting some of the technical problems we've had.
Excellent. Thank you, Your Honor.
All right, Ms. Raznick, any emergent issue we have to talk about before we say goodnight?
No, Your Honor.
Ms. Bremner?
No, Your Honor. Thank you.
Okay. With that, then, I want to thank everybody who's participated. I want to thank the panel members for your patience. And I want to thank the technical staff, but above and beyond, I want to thank our court reporter. That is a long, I've worked with a ton of court reporters in my career, and wow, without complaining, a long day. So I appreciate that. We will be in recess until tomorrow.